Next to her is Joseph Ferrara. Next to me on my right is Councilor Robert Juvenville. To my left, Councilor Eileen Duff. Seated next to her, Councilor Terry Kennedy. And next to Councilor Kennedy is Councilor Paul DiPaolo.
Mary.
And is Ramadan and Mary Hurley had some car issues or whatever. She will be on WebEx. Okay? And Ramadan Shabazz, is he, where is he? Okay, he's coming. We'll wait till he comes in and then we'll start the commutation hearing. The witnesses. No. Good morning, sir.
Good morning, sir. Back to you, sir.
Good.
morning.
At this point, representing Mr. Shabazz is Attorney Mia Teilbaum. And are we going to hear from you first? Yes. Okay, we'll hear from you and then we'll hear from you witnesses.
Wonderful.
And
Thank you.
obviously, Mr. Shabazz. Thank you.
Well, thank you very much. Good morning, counselors, and thank you, Chairman Iannella. My name is Mia Teilbaum, and I'm honored to be here today representing Mr. Ramadan Shabazz. We're very grateful to have this opportunity to present his case to you and to address any questions you may have. I first want to thank the Advisory Board of Pardons for honoring Mr. Shabazz with a very thoughtful and moving hearing and for recommending his petition to the governor of Massachusetts. I want to thank Governor Baker and his legal staff for a very careful and thoughtful review of Mr. Shabazz's case. And in conjunction with Mr. Kuntz and Mr. Allen, bringing back the remedy of commutation to Massachusetts after so many years. I also want to thank Mr. Allen, Mr. Kuntz, and their legal teams for paving the way for Mr. Shabazz and providing a tremendous amount of support and guidance during this process. And before we begin, I'd also like to recognize the families of Calvin Thorne and Harry Jeffries, who suffered a tremendous loss over these very many years, a loss which I'm certain caused wounds that may never heal. On a personal note, I'm guided in this life by my faith in the fundamental goodness of humanity and the recognition that no person is the sum of their worst act, I believe is formally recognized by our society in the form of clemency. I know the council's well aware of the importance of clemency to our criminal legal system and has been actively advocating for clemency to be utilized more widely in Massachusetts. What is rehabilitation if not Mr. Shabazz? If clemency enshrined as it is in our legal system is to mean something, then what Mr. Shabazz has done over more than 51 years of incarceration is surely deserving of this extraordinary measure. As you'll hear from the witnesses today, Mr. Shabazz today is not the young man who took the lives of Calvin Thorne and Harry Jeffries. Within a year of his conviction and after 6 months on death row, he embarked on a path of self-development and self-improvement that continues to this day. His steadfast commitment to bettering himself, a commitment notwithstanding the lack of any motivating source like the possibility of parole, is remarkable. The number of programs he's participated in and led is unparalleled. He has served as a mentor and guide for countless young men who are veering towards a path of risky and violent behavior, back to a place of self-awareness and self-respect through participation in programs like the Reach Out program with DYS Youth, providing GED tutoring, and the Companion program. It was Mr. Shabazz's patience, calm demeanor, and ability to see and communicate his respect for the humanity in these men that helped them to learn to care for themselves and to connect with others respectfully. In other words, the effects of Mr. Shabazz's efforts to better himself and to mentor others ripple out, improving not just the specific lives of the individuals he's worked with, but the entire community and society at large. You can see the impact Mr. Shabazz has had on the community by simply taking a look around at the many people here today to support him. One of the letters of support that we submitted includes 284 signatures. It is incredibly difficult to maintain relationships with family members and friends outside of prison walls. because of the practical barriers to meaningful communication and contact. And yet, over more than 51 years, Mr. Shabazz has built a community that stands by and supports him tirelessly. The strength of these relationships and his community is not just remarkable, it's also indicative of his particular likelihood of success if he's released. Mr. Shabazz appreciates the tremendous responsibility of demonstrating to you that he is worthy of commutation. And he does not shy from that responsibility. He embraces it with grace and humility, as he has every challenge he has faced during his more than half century of incarceration. Thank you very much.
Thank you very much. Any of the counselors have any questions of Ms. Titlebaum? No questions? Okay. Next, I have you, excuse me. I have your witness list, but before I get to your witness, does Mr. Shabazz want to make a statement? Does he want to do it now or after the witnesses? I'll leave it up to you.
Are you ready to do it now?
Sure, we could.
Absolutely.
Yeah.
We can do it now. Thank you very much.
Okay,
Thank you, sir. Thank you.
thank you.
I know. As you know, my name is Ramadan Shabazz.
Hey, speak up just a little louder, please.
As you know, my name is Ramadan Shabazz. I had it changed from James Hall. I want to thank this honorable Governor's Council for granting me this opportunity to speak to you on my behalf for the work that I've done to be here today. Thank you. I want to express my sincerest, deepest apologies to Mr. Calvin C. Thorne, his family, his mother Alberta, his daughters Phyllis, daughter Thelma, 6 brothers and 4 sisters, his loving friend Miss Carrie, and other family members and relatives. I want to express how truly sorry I am to Mr. Harry T. Jeffries' families, his father Lemuel, his wife Nancy, his 2 children, 3 brothers, 2 sisters, and other family members and friends. So, I want to thank our Honorable Governor Charles Baker for making bold steps by setting precedents and making clemency real possibilities of hope for the men and women incarcerated in the great Commonwealth of Massachusetts.
Excuse me 1 second. Anyway, because there's people on WebEx, if you could put this a little closer to you.
Okay. It's on.
Thank you.
Thank you. I'm sorry. I thank the Advisory Board of Pardons for recognizing the work that I have done to better myself and give back others to the community, and recommending my petition for commutation to the governor. On August 14th, 1971, I was 21-year-old, returning from Vietnam with a drug problem, with unbeknown PTSD at the time. I committed a robbery to get money to get more drugs at Freedom Foods Supermarket. I shot and killed Mr. Calvin Thorne. And I'm responsible for my role in the shooting and killing of Mr. Harry T. Jeffries as well. I caused both men's death. I'm the reason why Mr. Thorne and Mr. Jeffries didn't return to their families on August 14th, 1971. I caused the pain and grief, hurt and suffering that children experience by losing their fathers and growing up without their fathers. Because of my selfish actions, Mr. Thorne and Mr. Jeffries did not attend their children's school and graduation because of me. Because of my selfish and greedy need for drugs, I took away Mr. Thorne and Mr. Jeffries' suggestions, guidance as to which school or career their daughters and sons should follow. Because of my actions, Mr. Thorne and Mr. Jeffries are not present for holidays, birthdays, weddings, vacation times with their families. Get away. Because of my actions of August 14th, 1971, the only way Mr. Thorne and Mr. Jeffrey's grandchildren can see them is visit their grandfather's gravesite in the cemetery. That's me. In my family, we lost a son and nephew to gun violence. His son now would grow up without his father, just like Mr. Thorne and Mr. Jeffrey's children. Knowing that pain and hurt helps me to understand the pains and hurts that I have caused. I am deeply, deeply sorry for causing the deaths so much pain to Mr. Thorne and Mr. Jeffrey's families. I know I can never take back my actions on that day, August 14th, 1971, no matter how much I like to. But today, I try to use my life to make amends and making the world a better place. I tried to do every program available in the DOC facilities where I've been in. Alternative to violence, including basic or advanced trainer, facilitator, with my dear friend and mentor, Ms. Marjorie Stryker, the mother of Christine, wife of Dr. Richard Parker, taught me how to listen to what is being said, find a common ground, trust my instincts, and when it's time to act, by withdrawing or walking away. Ms. Stryker was also my thesis advisor for my thesis for incarcerated Vietnam veterans for a master's degree. I was involved with Mr. Robert Karsasian's program, Growing Together, for 9 years, focusing on issues of self-understanding, taking responsibilities for offending behaviors, internalization of personal growth and learning, and thinking about the experiences of the victim's family and the suffering that I caused. I was chosen by Chaplain Peggy Newman to participate in a newly created, very selective companion program while I was a casualty worker at Worcester State Hospital for 8 years. Served as a special needs assistant for 2 mentally ill patients. My focus was to connect and work with these men. They both was very difficult, but my internal self said, I can do this. It took some time, patience, listening skills, coping skills, to show these patients that I am just like you, meaning I've been there too. I also worked at Worcester State Hospital for 3.5 years while I was at Lancaster pre-release for 5 years, with 48 furloughs doing community work, delivering meals to the elderly with my wife's church. While on furloughs many times, we returned to Freedom Foods to say a prayer to Mr. Thorne and Mr. Jeffries on how sorry I was for stealing their lives from them. I want to thank my families, supporters, Will Allen Second Chance for Justice, Brockton Interfaith Group, have all rallied around me to support me for this opportunity for commutation. I am deeply, deeply sorry from the bottom of my heart for causing both families, Mr. Thorne and Mr. Jeffries' families, so much pain and grief for my selfishness. I'm truly sorry. Thank you. I look forward for your answer, your questions.
Thank you very much. Do any of the councilors have any questions of Mr. Shabazz? Councilor Robert.
On, sir.
Good morning.
On, sir.
So I take it you're not the same person you were in 1971 when you committed this crime.
I changed, sir. Yes, sir.
1969, you were drafted into the military.
Yes, sir.
Where did you go for boot camp?
Fort Dix, New Jersey.
And you did a year in Vietnam.
No, I did 1 month in Vietnam.
And have you been treated at all for PTSD?
Over the years, yes. In 1980, when we found out what it was about, I started getting treatment then. I had at least 25 years of PTSD counseling to the different institutions I've been in. I'm in a PTS group now at Old Colony.
Uh, Well, I reviewed the material on you, and I think what you did in prison is pretty remarkable.
Thank you, sir.
I don't know how you did it, to be quite frank, but you did it. I go into prisons quite a lot representing people. I don't think I could make it in there like you did.
Thank you,
And I
sir.
accept your apology to the family, and I think you mean it.
Yes, sir, I do.
Thank you very much.
Thank you. Counselor Joseph Ferreira?
Thank you. What do you say to the people in society that say the victims aren't walking around? Why should you be walking around?
I tell the people in society that, yes, these two men are not walking around because of me and my selfishness and my drug problem at the time. But I think I can help society out. I have. I've done work in society. Worked at Worcester State Hospital, 3.5 years. Worked at Bridgewater State Hospital, 8 years, dealing with mentally ill patients. So I helped on furloughs, delivering meals. I was in Lancaster. When the river in Lancaster overflowed, they needed bodies to help at Lancaster. I got there making sandbags, delivering sandbags to people's homes and their businesses so they won't get flooded out. In the middle of the night, raining, coming down, snow, ice, everything. Wet like everyone else in the town. And when what was done, the town gave us a nice barbecue during the summertime in the town park.
There's no question you've been mostly a model prisoner with, a few exceptions of disciplinary reports. If someone had killed a member of your family, how would you feel about them being released?
Everyone deserves a second chance, at least one chance, at least 1 second chance, especially if they're doing well and following the rules, and obeying the rules, doing the things positive to keep them out of prison. They deserve a second chance. I said I lost a member of our family too to gun violence, and I know one day that person's going to come up.
And you'll be there to testify in favor of release?
I have to be, because he deserves a second chance. Hope. That's all we have in prison is hope. We hope to come this far, to be here, to show the governor, as well as the governor's council and everyone else, that some of us are capable to handle freedom again, to be in society again.
How many people, you've been there 50 years, how many people in your situation you think ought to receive a commutation or a pardon?
Well,
Guesstimate, I have no idea.
maybe in the last 25 years, 3.
No, not but how many you think should be put up?
Well, they have to work for it, sir. They got to work for it. If you're not working, you're not, you can't come here without work. You have to work. And when I'm saying work, I'm saying work in here, not work out there, work in here. That's where it's at. That's what made me mess up. Me, in here. Not out there, here.
So would you agree that other people have worked in here and they're not before us today?
Not like I have worked.
You're the hardest worker out
I'm
of
a
everyone
hard worker, yes.
in prison?
Yes, sir.
Okay,
I know my skills.
thank you.
Thank you,
Thank
sir.
you. Any, Counselor Demani?
Thank you. Well, I want to thank you for all the time that you afforded me. We met almost 3 hours. And I was touched that you were concerned about me driving home in the dark, because I'm from Watertown and
Yeah.
Bridgewater. I was there before. I met with another inmate. But anyway, I did drive in the dark. But I want to tell you, I bought a GPS that morning because I said, I've got to make sure this works. It had all the old exit numbers. So, but I managed. But it was I really appreciate the time you gave me to really know you. I meet with everyone, not voting on a piece of paper. I want to know the whole person. And I feel I know everything about you, all your life and everything. We laughed, we cried. It was a great meeting. Could you tell us how drugs affected the tragic decision that you made?
I have to stop in Vietnam. I never was a user, alcoholic, or anything. I was a hardworking young man at the time when I was drafted. But being an American citizen, they draft you, you go, you make your call. Got to Vietnam. Morale there at the time when I got there was very, very low. Men were refusing orders. Men were still dying. So much was going on back in our country at the time. We could call home, and our parents and friends and wives was telling us what was going on back home. But when I got to the company that I was in Quang Tri, the northern part of Vietnam, everybody's on drugs. Everybody's on drugs. They got tired. So we're tired of being here. So we use drugs just to get out of the mode of the possibility of being killed. That's what we did, just to maintain ourselves. Because there was a lot of stress and pressure there at the time. I know I was there. And I seen our men die. So the drugs, that's where they came at. I'm sorry I picked up that habit. I brought it home here. And I hurt 2 people for that. I'm responsible for that. That lives in me every day, what I did. I'm sorry. Drugs, I haven't touched any drugs since 1983, 40-something years, and I'm touching no more again. So I'm good with drugs.
Well, my husband was in Vietnam. I have friends that died in Vietnam, and I apologize to all the veterans who were treated so badly. I belong to the American Legion, and we are trying to make up to it. But what I saw in you in meeting with you, you are truly a religious person. You know, we hear all these people are born again. You know, a lot of it is a lot of baloney. You're the real thing. And you know, we can't turn back the clock. What happened did. And as you said, you live with it every day. And we have to forgive. And I cry at parades, so you got to know that. But I just have to say that you really have gone through a lot. And when we spoke, I couldn't imagine being on death row. And of course, that was overturned. But you've gone through all of it. You've helped a lot of people in a lot of programs. And you went through, what is it? What, 50 rehabilitation? Am I right? 50 rehabilitation
Yes.
programs.
Yes.
That's amazing.
Yes.
So, you know, you are so excited about going out and getting that job, and you got a wonderful doctor and wife who are going to be, who are your mentors. God bless them. And so, I'm going to stop because I'm going to cry, but I just got to tell you that was so meaningful meeting with you. And it was the best 3 hours I've spent to get to know you.
Thank you, ma'am.
So
Thank
you have my support.
Thank you, ma'am. Thank you.
I just have a quick question, then I'll go to Counselor Ox. I know you're 71 years old, but I'm just curious, maybe I missed it. What do you plan to do if you're released, and where do you plan to live?
Well, first of all, I'm playing with the Parker. He's going to get me a job in the mental health field because that's where I want to work. I want to give back there. I want to give back because there's a lot of mental health problems out there, and I see it coming, the kids coming in through today, in prisons today. It reminds me. I want to be in that field of work, and he can give me a nice job with that. I'll be living in Newton.
Live where?
Living in Newton.
And you don't have to tell me the names, like a family or a pot?
Yes,
A family.
a family.
Okay, thank you very much. Counselor Terry Kennedy.
I asked that same question that Councilor Miller just asked, that indicated to the attorney earlier. I'm very interested in what the plan is. We talked about it a little bit on the phone last night, but what the plan is going forward.
We can't hear you, Terry.
I'm sorry, Mary, my microphone's off.
Yeah, I was talking about you, Mary. That's why I had the microphone on. The, first of all, I apologize that I didn't get down to see you. I was trying to do that, but I had some personal issues come up that your lawyer's well aware of, so I wasn't able to. But we've been talking quite a bit, and she's a superstar, by the way, for you. She's like, she'll be on the Super Lawyers cover this year with getting you to this point. And I happen to know her. I've seen her in court. She does a tremendous job there as well. But I'm going to get back to your plan in a moment, but did you say you were in Vietnam for a month?
Yes.
And that's an extremely short period of
Yes,
time.
it is. Yes, it was, sir.
What caused you to come back so quickly?
As I got to Quang Tri,
You what?
when I got to Quang Tri province, that's where I was stationed.
Yeah.
The northern border of North-South Vietnam, the DMZ was right there. The morale was very low, drugs was there,
Oh, I'm sure.
and a lot of men was refusing orders, going out into the field. A lot of men. So I just fell in line with the rest of them.
There weren't many people there that were volunteers at the time. Most
Now,
people
we was all
were
draftees,
ripped out of their
all
homes
draftees.
and brought there very young men, unfortunately.
19, 20, 21-year-old kids.
But were you discharged from?
Of a discharge under honorable conditions. A general discharge under honorable conditions.
Okay,
But I still had my benefits.
okay, but that was pretty quick.
I was surprised because, when you,
I find it a little, I've never heard that where somebody went there for 30 days and
Yeah.
unless they got wounded or hurt or
Yeah,
something
well,
happened that
lot
they're
of-
back so quick.
a lot of that was going on, sir, that people don't know what's going on over there.
Well, I'm sure.
A lot
I
of
don't,
my
I don't
friends-
doubt that. And,
lot-
a lot of young men, lives were ruined, they died there,
Yeah.
no question about it. Who didn't deserve to be there. In any event, so you come back, you're not suggesting that you got addicted to drugs in that 30-day period, right?
I did get addicted to drugs in 30 days.
That quick?
That quick. I
That-
never.
nothing
used
before
drugs.
that?
Nothing. My
Uh,
body just absorbed it.
Okay. On the day of this event, you indicated you were under the influence of LSD.
Yes, sir.
Was that the drug of choice that you had from Vietnam? Is that
Yes.
what you got
Yes,
addicted
that was
to?
one of them. LSD.
I know it was
heroin.
very common in the 70s. It's
Yes,
not
LSD and
thank
heroin,
God
yes.
It's common now, but, so you started abusing LSD when you first got there, the first month,
First couple of days.
first couple of days? And, when I look at the fact that you testified at your trial, and you testified that on the day of the offense, you were under the influence of LSD, but there was some planning that went into this ahead of time. It wasn't a crime of opportunity, shall we say. You planned it out ahead of time. You got weapons to rob it. You must have sort of cased the place to know that they were bringing money in there, right?
But my co-defendant worked there.
Okay. So you and your, by the way, is he still, what's his deal? Is he still in prison? Is he
Yeah,
alive?
he's still in prison. I don't know
Okay.
if he's alive or not. I'm not.
No, I'm just saying, he's still in prison?
He is still in prison. Yeah. He actually still has, I believe, he never had a direct appeal. So I think he's currently litigating.
He never had a
motion to
direct
go.
appeal on a first-degree murder?
No, both Mr. Shabazz and his co-defendant, Mr. White, had counsel that seemed to have dropped the ball and.
He had the death penalty. He never had a direct appeal on a death penalty case?
Mr. Shabazz eventually did a number of years later, but it is mentioned in the decision, in the SJC's decision, that his appeal was originally dismissed because his counsel never.
On a death penalty
That's
case?
correct.
That's astounding.
The SJC was very disturbed.
I always thought death penalty cases had an automatic direct appeal.
I believe at the time there was, it was a bit of a different process. There was an assignment of errors that you had to
Right,
go
huh?
through. And I think that my understanding is that neither Mr. Shabazz's counsel nor Mr. White's counsel went through with that process. And as a result, both of their appeals were just dismissed. In Mr. Shabazz's case, the error was corrected. There was successor counsel, but the SJC noted in their decision that his attorney had actually done the same thing on another death penalty case. And I think mentioned that perhaps there should be some action taken by the lower courts with respect to Mr. Shabazz's attorney.
And
Mr.
is that what led to the death penalty being vacated?
No, it was just Furman versus Georgia. It was the
Okay.
fact that it had been ruled
All right.
unconstitutional at the time.
I'm curious, just on the procedural side, and I'll get back to where I was. On the procedural side of things, he filed a motion for new trial in 2019. Tell me about that.
I believe it was 2020.
Oh, 20, okay.
Yeah.
And that was voluntarily withdrawn a year later. What was the
That's-
basis of that motion for new trial?
Do you,
If you know.
I can speak to it.
Yeah, please.
Yeah.
See the lawyer.
It was filed pro se, but Mr. Shabazz has filed a number of motions over the years, and all of them have to do with mitigating circumstances at the time. So the 2020 motion was about adolescent brain development and PTSD as
Okay.
mitigating evidence that he believed should have been presented. Not as evidence that he was not guilty,
Right.
but with respect to the possibility for parole to have a
Right.
parole eligible sentence.
Mitigating circumstances that would have potentially avoided a death sentence or life without parole.
Yes.
That's
Bring
correct.
bring it down to a second degree, basically, which is what we're here to do today. Okay, so so you did your time in the service. You come out, you're on, how often were you using LSD?
As often as I can get it, sir.
Huh?
As often as I could get it at the time.
Okay, your case is more difficult for us, you understand that, than
Yes,
the
I
other
do.
two
Yes, I do.
commutations we had.
Yes,
Mr. Allen, who's present, was convicted under the old felony murder rule, didn't actually commit the murder himself. And Mr. Coons that we did, I saw a very strong self-defense case there. I was shocked that he was convicted when I read through all of his materials. Yours is more difficult
yes, it
for
is,
the
sir.
people on this council, and I think you can understand why.
Yes.
The folks who died, do they still have family around? Has there been any input in this process from them?
My understanding is that the advisory board of pardons, I understand they reached out, and I believe that there was no response.
There was
There's
just,
two of them on Zoom today, I believe.
they are, okay,
Maybe I'm wrong, but I thought I read that someone was going to be on Zoom.
okay.
I'm
We'll
not
see.
aware.
We'll certainly find that out, but I'm just curious because I know that with Mr. Coons and Mr. Allen, there was input. One was opposed to the commutation and one member of the family and the other one were in favor of it. And I was just curious about that. So, the planning part of this, it's easy to say I was under the influence of LSD that day and have no memory of it, but the planning took some thought. You would agree with that? On LSD and not on LSD, you had to plan it out,
I had many years to think about this. Yes,
you know what I mean?
Yes.
It makes it more difficult
yes,
for
it
the
does.
people on this council. It was a lot of money at the time. It was like $20,000 in 1971. That was a lot of money.
Yes,
So it wasn't just a small robbery. Right, so now you get convicted and you go to jail, and you clearly have done a lot of good things while you're in jail. There's no question about that. You did everything you could. You worked at it very, very hard. That's why I was a little curious about your co-defendant, because he would be in the exact same circumstance you are, or should be, if he's done the same kind of things in jail. I know that you wouldn't know that. You're not responsible for what he may have done or not done since he's been there, but I'm curious where we have two people that committed the same crime together and are guilty of two murders while one's here and one's not. But that's a different issue. So anyway, let's talk about when you get out, because I think that I'm very, very curious as to what your plans are. I certainly addressed that with Mr. Allen, Mr. Coons. Mr. Allen's I got a chance to speak with for just a moment before we started, and he seems to be doing terrific, doing everything. And one of the things that he was very proud of was the things that he's still doing to give back on the outside. And that's certainly what we want to hear about. What are you going to do to give back? You're not a young man. You know, you're not an old man, but you're not, I'm not far behind you, but you're not a young man. So, it's it is somebody who was, say, 50 or 41.
Excuse me, so I'm 73, but
73?
73,
All right.
but I've been working all my life. In prison, that's what I do.
Right.
If I'm paroled, that's what I'll continue to do. I have cooking skills, I have
Okay.
electrical skills, carpentry skills, plumbing skills, a mentor, a teacher. I could be a professor. I have a master's degree. So I got many, many things that I can do out in society.
Okay.
And I want to give back. That's my way of giving back. I want to give back.
Well, working is great, and that's one thing I think is good for anybody who's
Yes.
coming out of the, I think you need that when you come out of the system, you need the structure of it. But let's talk about what how you're going to give back in other ways. I mean, working is to keep you on the right track and to fill up your day and to give yourself some sense of worth as you're out there. I agree with all that. But like, what are you going to do in terms of talking about your experience and who you're going to talk to about it when you're on the outside?
Oh, I'm definitely going to be getting counseling. I mean, you need counseling. My PTSD counseling, definitely, because I like talking to other veterans about our experiences. That's more important to me. Like I said, I'm in a PTSD group now in Old Colony. We talk about experience. We have Vietnam veterans, Iraqi veterans, and Afghan veterans in prison now. So we talk about experience and the things we need to do for ourselves to make ourselves better persons. So when we do return back to society, we can help other veterans.
Okay.
I work with autistic children. I work with them a couple of years at Colony. We had programs for them coming into Old Colony. We had a marathon for Franciscan House in Brockton. We raised $10,000 with our Chain Games Runner Club. And one of our testimonies that came today, Mr. Carl Bowen, brought his runners in and we ran the inside yard of Old Colony after the marathon. BBA came in and measured out the mileage for us and we had a marathon a couple of times. We raised $10,000. I donate to charities on the street now. So I want to give back. I just need the opportunity to give back more,
Okay.
more. And I will do that.
You know, Council Jubenville has brought up many times that he doesn't believe in life without parole, and neither do I. I believe everybody should have the opportunity, at least the hope of getting parole. And I think that, you know, people are capable of redemption. They're capable of bettering themselves and should have the opportunity to reenter into society. As I sit here, I would say there's about a 99% chance that I'm going to vote in favor of your commutation for that reason alone. One of the things that people don't understand is that when we commute a sentence, you're not walking out free. You don't walk out if we voted right now to commute your sentence, you're going back to jail and you have to get paroled. And I expect that you're going to spend whatever years you have left on this planet on parole and subject to the rules and regulations of the parole board and being monitored in society for the rest of your life. That's what happens when you get a second parole on a second-degree murder. So I don't have any other questions for you. I'm looking forward to hearing from your witnesses. Once again, you're sitting next to a superstar.
Thank you.
Thank you.
Councilor Duff?
Thank you very much. So you served in the Army,
Yes, ma'am.
I'm correct? And were you proud to serve?
Yes, ma'am.
You love your country?
Yes, ma'am. I was born here. I gotta love it. It's the only country in the world for I'm concerned.
What
Good
was the
today.
most shocking, or I guess shocking is the right word I want to use. What was the most shocking thing to you when you arrived in Vietnam?
Seeing so many young men there. We were babies. Just cool. I graduated in 1968. 1969, I'm in the service. 1970, I'm in Vietnam.
Was it difficult to acclimatize? I mean, I know I'm going way back asking these questions.
May I give you an example?
Yes, you would, may, please.
When we arrived in Vietnam at 2:30 in the morning, 300 of us on a plane, coming from there to there, here to there. The sergeant said, duck your heads, because we gotta go through this town, and they take pot shots at us, but we go through the town, we're in a bus. Keep your heads down till we get to the other side. Well, we got to the other side. We rolled off the bus, called everyone's name. There was this one name that kept calling. So I said, check the bus to see if he's on it. He was on the bus. Yeah, I caught one in his head. He didn't duck. So they bring his body off the bus. And he said, this is what happens when you don't pay attention. This is what happens when you don't pay attention to the orders we give you. He said, now we have to write his parents. That was the first time ever in my life I've ever seen a body. Young body. I think he was about 20. When that traumatized to other events that I've seen in Vietnam, it just takes a lot out of you.
It's quite an introduction to the country. How were you introduced to LSD? And I'm gonna guess heroin, since it was so much heroin coming. Full disclosure, I lived in Vietnam at one point, so I'm
Okay.
very familiar with the country and very familiar with the area you were in. And anyway, but this is about you. How were you introduced to heroin there?
Like I said, the morale, the company I was in was very low. Everyone was using drugs.
Did people just give them to you, or did
It
they
was-
say, try this?
It
Or
was that accessible to us. I mean,
Yeah.
I was in the armor division, so they would go out in the field and, out in the field, if you're from Vietnam, you know how it was back then, that, Papa San had his little house out there, little village, and they'd be making whatever they have to make. And of course, American soldiers, we're gonna buy it up. And when we came back on base, they had as much as you want, whatever you want.
Mhm. I don't know one veteran who's come back from any war since Vietnam without PTSD, I'll be honest. And I'm sure many of the men and women from the previous wars did too, and it was just completely undiagnosed. Do you hold any resentment towards your country for sending you there?
Oh, I love being there, but at such a young age, seeing young men die, young women die, 20, 21-year-old people haven't even lived yet. At the time when I was growing up, we was just trying to learn how to drive a car, get our first jobs, and to be drafted without fulfilling that, and you get traumatized, and you come home and you look for help. And at the time, PTSD wasn't out, but shell shock was,
Right.
but no one didn't call it shell shock. They just didn't know.
And so you did try to seek services, mental health
I
services.
went to Boston, the Jamaica Plain VA several times.
Yep.
And I told them, I said, look, I'm not myself. I knew something was wrong other than the drugs, but I thought it was the drugs.
Right.
They said, we can't help you. I said, wait, I just come from Vietnam. Here's my DD-14 right here. It shows you. Yeah, we know. There's a lot of you guys coming back from Vietnam, and we don't know what's wrong with you. So I asked the two doctors, I said, you know that we're coming back from Vietnam with a problem, and you can't tell us what it is? I said, no, we don't know what's wrong with you guys. We have no idea.
So it was a comorbidity, really. At least that's what we would call it, is the mental health challenge of PTSD and the addiction.
Yeah.
And you knew something was wrong, you tried to get help, and you just spiraled. Is that a correct?
Yes, I spiraled after that because I went to the Boston City Hospital on Harrison Avenue, the old city Boston City Hospital, seeking the same thing, help. Hey, help me. I'm not myself. Tell me something. And I said, I'm a Vietnam veteran. I just returned back a couple months ago. I need some help. Can you help me? And the person there, well, we don't help Vietnam vets. You got your own hospital.
So despite all of this, and this is not, I always say this doesn't absolve your crime. I'm trying to build a mental picture of how you even got to that spot. Despite all these great, frankly, for lack of a, probably not with malice from people, but the inequities that you faced coming back as a veteran, you hold no resentment or malice towards your country.
No.
And you feel proud to have served.
I tell you a story.
Please.
The day I was discharged, coming through Logan Airport, which is not Logan Airport today, the way I came to at the time, I had my uniform on, vest screens, sharp, creases, medals, and I'm walking through Logan Airport. This kid yells out, this early in the morning, "Mommy, there's one over there." So I looked around like everyone else looked. Who's he talking to? As this mother walking toward it, she started calling me, "You murderers, how many people you kill? How many babies you kill? Nothing but murderers, you Vietnam veterans, all you all do." So, and as she yelled at me, I'm looking at her, the kid, the son, kicks me in my shin and spit on my shoes. I was telling, something hit me on my hand, on my shoulder here. I didn't know who it was. Could have been a person, I don't know. They just move along. I heard a voice that just move along. I just moved, kept moving like everyone else. I was flabbergasted that happened. I'm here representing our country, and here you are calling me a murderer. You don't even know what I did. I have no idea, but yet I accepted it and kept moving. So what I'm getting mad at the country for? I have to serve my country.
Thank you very much.
Thank you very much. Next, we'll hear from Councilor DiPaolo. I just want to remind, we have an extremely busy day. Everyone can ask as many questions as they want. We're going to break sometime before 1 o'clock. And if we do not finish, and I think I told your attorney, we will come back another day because they have a hearing at 1 o'clock that I've talked to Councilor Kennedy. That will say at 1 o'clock. Hopefully the goal is to finish before then, but I'm just putting everyone on notice, okay? We will break before 1, whether that means at 12:15, I'm not sure, but keep that in mind, okay? Councilor DiPaolo, do you have any questions?
I do, Counselor. Thank you. Good morning.
Molly.
If it's okay, I'd like to ask your attorney a couple questions, Mr. Shabazz, before I talk to you. So first off, thank you for working on this case. We have a need for attorneys to be willing to devote themselves to commutation cases because they apparently take so long. And obviously, there's not a lot of folks who specialize in it. So thank you for that. And to everyone else here who worked on this to get us to this point. I want to ask about the process. In 2014, I don't think you were involved, but there was an initial commutation petition submitted to the parole board. Is that correct?
That's correct. Yes.
And what was the result of that petition?
So another attorney submitted Mr. Shabazz's petition in 2014, and there was I think there was a supplement that was filed in 2016. There was no action taken on it. In 2020, in May, when I got involved in the case, was the first time that I believe Mr. Shabazz received any sort of response from
The first time since the initial in 2014? So
Yes.
6 years
Yes.
before any
there was
response came?
correct. And
Okay.
and at that point, he received a letter, I think indicating that he had 30 days or something to supplement his petition. So at that point, I became involved and advised the board that I needed more time to supplement the petition.
Sure.
And they gave us plenty of time. And so when I finally filed the petition that you now have before you, I asked to withdraw, just to have a clean slate, have everything together, to withdraw what had been previously filed and put it all together in the petition I filed in November 2021.
And then when did the hearing happen?
The hearing took place believe it's July 26th of 2022. So it was filed November 1st, 2021.
Okay. So it's a long process.
Yes, very long process.
And I imagine there was a lot of diligence by the parole board.
I think that, you know, there's been increasing responsiveness.
Mhm.
Certainly, when we learned of the fact that Mr. Shabazz was going to have a hearing, that was in January of 2022, I believe.
Mhm.
So, there were a couple months where we just really weren't sure what was
Sure.
going to happen.
Sure. And then you had your hearing and I received a report from the parole board, pretty detailed explanation of the recommendation they made.
Mhm.
So I just wanted to know about that process because I appreciate the parole board doing its work in providing this info
Yeah.
so that I'm not just getting your side of the story. I'm seeing what the Commonwealth is presenting or what the parole board is presenting to us. So with that, Mr. Shabazz, thank you for your service.
Thank you.
Heard a little bit about it today that I won't rehash, but do you think we're where we are, but for your service? Do you think we're where we are if you had not been called to Vietnam?
I think I would be a retired old man now.
Yeah. You wrote a master's thesis about Vietnam vets.
Yes, I did.
Could you elaborate on what your angle was on that?
At the time, it was 1995. My best friend, like I said, Marjorie Schweiker, she was my master's thesis advisor.
Mhm.
I wanted to write something about us, incarcerated Vietnam veterans, because no one at that time, as far as I could read, wasn't anything out there about being incarcerated veterans.
Mhm.
And so I set off on the project of doing that because I am an incarcerated Vietnam veteran.
Could I ask you, as you continue, at that time, were you incarcerated alongside a lot of vets?
Yes, I
Was a
was.
significant portion of the
Yes.
population?
I was in Norfolk at the time,
Yeah.
maybe about 100 guys.
About 100. Okay, I'm sorry to interrupt you. You can keep going. So there wasn't a lot out there about incarcerated Vietnam vets that you had seen. And so you undertook this, and what was the
Just
thrust
this,
of your thesis?
the thought was just hoping that, the powers that be would do something for us. That's the basic purpose of me writing that thesis, that hopefully somewhere down the line, someone will wake up and say, hey, what about the incarcerated Vietnam veterans? Let's help them. Let's help them.
Sure. And in your experience, I imagine you've paid attention to these issues over the years, is
Yes,
what
I
I would
have.
guess. Is that accurate?
Yes.
So are things different? I mean, when we have Iraq war veterans, folks who've seen combat in Afghanistan, has much changed? Do we have a lot of veterans from those wars in prison now?
They're coming in.
What were the biggest challenges back then that at that time writing that thesis you thought Vietnam veterans would benefit from, incarcerated Vietnam veterans? Is it the same diagnosis that you would make today about young folks who are in?
No, because you have so many programs out here now. You have the DAV, Wounded Warriors program. You have personal programs. You have all kind of programs for veterans today coming home. When they come home today, you got the people at the airport waiting on them. Their families are right there, getting off the plane and hugging them, kissing them. When we came from Vietnam, there was nothing,
Yeah.
nothing.
And as far as programs available while incarcerated, the parole board documented a lot that you've done. And you've talked about hope a couple times. We know, folks who pay attention to this know the governor's clemency guidelines talk about commutations intended to serve as a strong motivation for confined persons to utilize available resources for self-development and self-improvement. And as you also noted, you're at the third commutation in quite a long time. So you're working on these fellowship programs, right? There's mentoring that you've been able to do in different kind of niches. So, I mean, let's be real, are the folks you're mentoring, do they feel hope based on the three experiences? And what does it look like?
The hope that I gave the Vietnam veterans, I hope they're still trying.
Yeah.
They're still trying to come here, get this far. But some don't have lawyers, some don't have families because they've been in so long. 45, 50-year men.
Mhm.
And some women have been incarcerated that long too, that I noticed doing first degree life at Framingham, 45 years in. So we're just looking for hope.
So if you're granted this commutation and then perhaps granted parole, I don't sense that you're any threat to public safety. Do you feel that
No, sir.
I'm understanding the
I have-
situation accurately?
I have so much support, as you can see. I mean, I have support.
Mhm.
I didn't have any before. I have support now, family, friends, people I met while I've been incarcerated are still here today.
You served 51 years. That's a long time.
Yes.
You've undertaken quite a bit of self-improvement and self-reflection. And I can't see any reason why we should be devoting state resources to keeping you behind bars. So I'm going to be very proud to vote in favor of this
Thank you.
commutation.
Thank you very much, Councilor DiPaolo. Mr. Shabazz, did you ever incarcerated for 50 years, give or take? Have you ever filed for commutation before this? And either your attorney can answer this if she wants.
I think that there was a petition that was filed in 2010, pro se.
So he was convicted and went to jail 1980, what was the date?
He was 1972.
1972.
Yeah.
So he waited, what, 38 years before filing a commutation petition?
My math is not wonderful, but I will.
Okay, give it a sec, give it a sec.
I really,
That's good.
I'm trying to run those numbers.
Math and
in my-
geography were my best subjects. Civics, I'm
Yeah.
kidding. Why did he wait so long? I mean, we've had commutation petitions that come before us that are a lot sooner than that.
I'm smiling because the governors that came in after Willie Hood and Armin Theory and escaped off of programs, they shut everything down. So everything was shut down until 25 years ago when an inmate named Joe Yano got a commutation.
Yeah.
And now just Will Allen and Thomas Cooks, the next two came up. So, you know, I just kept busy working.
No, I got it. I get that. So you filed it in 2010?
2010.
And it went to the parole board?
Yes,
Advisory boards of pardons, and they rejected it,
yes.
and, okay, they rejected it, and now you're here before us today. Okay, to me, whether someone wants a pardon or a commutation, the first thing you have to do is you gotta own up to it. You gotta own up to it, and you clearly have done that.
Yes, sir.
You appear to be very remorseful. You have as good as anyone, a good institutional record. Okay, that's important.
Yes, sir.
For that long a period, someone could say, hey, you go off and who knows what you might do.
Mhm.
But you've done as good as anyone, at least that I've seen. So I commend you for that. Looks like you have a plan. You're going to be working with somebody. You're going to live in Newton. You have a place to live. And when we sit here, we never know. I mean, we just listen to you. We listen to your witnesses, your attorney, and we try to make our best judgment.
Yes.
And I say this to all the people, who sit there, more likely than not, it's just my own personal opinion that your sentence will be commuted. But don't let us down. Don't let your lawyer down. Don't let the victim's family down. You owe it to yourself and to your family and your friends. I hope you're going to do the right thing. And I hope the only time we see you again is that you'll be here like Mr. Allen. And I'm glad we supported him. But I wish you the best. And that's all I have to say. Do you have anything else you want to say? You don't have to.
One thing that my heart says is, I will never let anyone down for helping me and my family and my supporters to reduce my sentence to second degree. I will not let anyone down. That's from here. Not here, it's from here.
Well, thank you.
And I mean that.
My understanding, Attorney Titlebaum, on our last commutations, the folks got out relatively quick. What does that mean? My understanding in talking to parole, not on this case, but in general, people get out 2 months, give or take. Does that sound right to you?
I believe that, at least in Mr. Allen's case, I think that the parole hearing was held about 5 or 6 weeks after the governor's council voted. And then I think he was released maybe a month or so.
Okay, so within 2 to 3 months.
Yes. I believe
Okay,
so.
okay, that's good. Well, thank you very much. I just want to acknowledge a letter that I did receive from Catherine Moran, the Victim Service Unit Director at the Mass Parole Board. Counselors, I want to let you know that I have been in contact with victim families on the Ramadan Shabazz case. I've been in communications with Nancy Shaw, the wife of victim Harry Jeffries. She lives out of state and would like to observe the hearing virtually. She does not want to provide testimony, but she is watching virtually, and at this point, she does not want to give any testimony. Okay, thank you very much.
Thank you.
Next, we'll hear from William Allen, who's very familiar with the council. He's a friend, he's a supporter, and he's a commutation recipient. And, you know, as I indicated to Mr. Shabazz's attorney, we want to limit the statement, and I will hold everyone, you know, if it goes too long, whatever too long means, we'll figure that out. But if you just stay your statement, and the councilors have any questions, they can ask you. Thank you very much.
Thank y'all for having me again. It's an honor to speak on behalf of Ramadan. I would like to start this off by giving thanks to our Lord, because none of this would have been possible without God. Also, I'd like to give thanks to Governor Baker, Lieutenant Governor Polito, for believing in Mr. Kuntz and I, that we would help to make a difference in society's eyes. And to be honest with you, we are carrying our brothers and sisters on our backs comfortably. I give thanks to the Governor's Council, the Advisory Board of Pardons, my attorneys, and Second Chance Justice, a campaign of Brockton Interfaith Community in partnership with the Massachusetts Communities Action Network. I sit here today with happiness because I have a chance and opportunity to speak on behalf of a great man who I love and respect with every inch of my being. When I first met Ramadan, he was a tutor for the school program, mentor for the vulnerable, and a role model to many, including myself. Staff and anyone that came in contact with Mr. Ramadan respected him because of the way he carried himself and also how he treated others. Ramadan and I were in the same unit for over 11 years. We talked every day and ate occasionally together in the unit when Charles Hall food was terrible. He shared his knowledge with me, and he also shared his food. I never went without knowledge or a full belly, thanks to my brother Ramadan. Ramadan was one of the first to help give the companion program the respect it has today. Let me close with a story that is so profound that it's still being talked about till this present day. There was a patient that we will call the Heisman, and they kept him locked in a cage in the back of the unit by himself. They considered him to be the most dangerous, but all he wanted was love and attention. So our companion leaders matched Ramadan with Heisman, which was a wonderful thing because Ramadan gave Heisman the freedom and love that he was seeking. Because of Ramadan's advocacy, they stopped cuffing Heisman, and I would see him walking around the quad with Ramadan. Everyone saw the change in Heisman. Now Heisman is doing great and no longer locked in a cage 24/7. Over to my left, I support, as many do, for this council to grant Mr. Shabazz his freedom because he is deserving of it, and we need his help to continue the good work that we are doing for our community. Thank you.
Thank you very much. Any of the Councilor Juvenville?
How you doing?
I'm doing great.
Yeah, how's work?
Work is wonderful.
Yeah.
Great, yes.
What's the story with the beard now?
I said to myself, I said, so, when I see Mr. Juneville, it's cold. So keep my face warm.
Thank you very much for your very kind letter.
Thank you.
Counselor Terry
Please,
Kennedy.
we'll have a copy together.
Thank you.
All right, Counselor Kennedy.
Thank you so much. And
Thank you very much. Counselor DePaulo.
Good morning.
good morning.
It's great to see you. I just want you to know how proud I was to make this vote and how much you and Mr. Kuntz have impacted the community. In my world, giving the hope we talked about at your hearing and just now, and also among the legal community, folks starting to pay attention and think this is something that's a valuable use of my time to be pursuing these things. So I just wanted to commend you on that. I'm so glad to see you doing well.
Thank you so much.
Thank you very much. Counselor Marilyn Devaney.
Thank you. How nice to see you out. I would be remiss if I didn't thank you again for all the time that you afforded me when I came out to meet with you.
Yeah.
And I have to admit, after we met, I went in my car and I cried. Travesty of justice. There's so much racial disparity in our courts, and we see it, but nothing is done about it. And I'm not going to retry the trial, but here's someone who wasn't even in the room when his friend murdered a man, stabbed him 12 times and killed him. And he got life in prison without parole. You would have cried after you met with him too. But when I met with Ramadan, he talked about you, and he talked about the friendship that you had formed, and what a wonderful, wonderful act for you to come and speak on his behalf. I really, and we've been in touch, and we'll be seeing each other again. And I'm so happy you got your license. You with your dad. We have to go forward. Can't live in the past. And but I just want to thank you for coming and testifying. You're a good friend. And the programs that you put in, the people that profited by it, who came at your hearing, and you're a good religious person, Eucharistic minister. You got inmates to come to church every day. That's pretty good. So I just want to thank you for coming. And your testimony means a lot. But we talked about you. Your ears must have been ringing. But it was a pleasure meeting you, and we're going to meet again. And you have a wonderful future.
Thank you so much.
So God bless you.
Thank you very much. I don't have any questions. Just to let you know, so far, so good. You're making us proud. You're making yourself proud. And you're making your family, your friends. Keep up the good work. Councilor Ferrara.
Thank you.
Did he want to have a
I
quick?
hear everyone saying how well you're doing, but I have no idea what you're doing. So could you tell us what you're doing?
I work at Tefenci and Toyotas in Braintree. I go around and I do talks. I spoke at Northeastern University Law School. I'm doing me and Peg Newman, we doing an event at St. Suzanne's talking about criminal justice. And I have more up and coming events, in January, because they want me to speak again at Northeastern University.
Was it you or Mr. Kuntz that wanted to be a barber? I forgot.
Yes, I'm a master barber.
You're a master
Yes,
barber.
I'm a master
Are you
barber.
cutting hair now? Are you doing that?
I cut off and on, though,
Okay.
because I cut my father's dreads off. So,
All right.
but that was pretty good.
So your situation, as Councilor Kennedy alluded to earlier, was quite different. You were in another room when the murder took place, murder felony rule. This man's alleged to have killed 2 people within 3 feet, cold-blooded murder.
Yes.
They didn't have a chance. They just went out there, killed them dead,
Yeah.
without even asking for the money. Do you think that we should look at that a little different than your case?
No,
Why not?
because a mistake happened both ways. And we all make mistakes. You know, it's about how we overcome it. And if, you know, you're sincere about correcting that mistake, you know, you shouldn't be punished for the rest of your life. But if you're awarded a chance and you mess that chance up, then, you know, you gave your chance.
What about the other people in prison for first-degree murder? Maybe not quite as heinous as killing two people within 3 feet. Why aren't they here? Like, do you think like you three are the hardest working in prison?
Not
Like,
at all.
So what is the process, and what would you say, like, in fairness to other people that are left behind?
Well, I think, you know, if you do the work on yourself, because the first thing you have to do is work on yourself. You know, you can't work on somebody else if you don't work on yourself. You know what you did wrong. You know what you have to do to correct yourself. So once you get the tools that you need for yourself, you can apply it on others.
In your experience, are there a lot of people that are still in jail that should be before us?
I agree, yes. There's a lot of good men and women out there that are deserving of this opportunity. But, you know, like I said at Northeastern, I said, we buried that Willie Horton apple. And Coons and I planted some new ones. And we're like Cinderella. The apple is red. And we have no problem carrying our brothers and sisters on our backs. Because if we mess up, we close the door for everyone else. And that's not going to happen.
I'm glad to hear that. I'm glad you take it so serious. Thank you for coming in.
Thank you very much. Next, we'll hear from Dr. Richard Parker. He's a friend and he's a supporter. Good to see you, Doctor.
Thank you. It's good to be here. This is a joyful day. Thank you, counselors, and good morning, Ramadan.
Good morning.
Good morning, Attorney Teitelbaum. I have a few notes. I promise I will not be long, but I do want to say a few things. My summary of Ramadan's situation is there are no excuses, but there is forgiveness. I also wish to reflect on the losses for the families of Mr. Calvin Thorne and Mr. Harry Jeffries. I don't think we can ever forget them. They paid the ultimate price in this situation, not Mr. Shabazz. I believe his remorse is real. I believe his remorse is persistent. Our family goes way back with Ramadan. My wife is here, Chrissy Parker, and her mother, Marjorie Stryker, who's passed away, worked in the prison and met Ramadan in 1983. So we're almost on 40 years that the Parker family has known Ramadan. I think it's ironic that his tragedy, Ramadan's tragedy, began in Vietnam in 1970. Our oldest son is 30. He's in Hanoi right now as a tourist. He sent a picture. He's playing keyboard in a restaurant. How times have changed. Vietnam has come a long way. I think Ramadan has come a long way. I think we've all come a long way. I feel that we cannot judge an entire person's being on the actions of one day. And I think his efforts to better himself are impressive and real. Got a BA in prison. He got a master's degree. I'm personally touched by the fact that he chose to help mentally ill people, which is not an easy thing to do. About myself briefly, I'm a physician. I worked at Beth Israel Deaconess for 30 years as an internist and their chief medical officer. I currently work for an IT company called Arcadia. I also see patients at Care Dimensions Hospice in Lincoln on weekends. He'll be there this weekend. And I've talked to Ramadan about my hospice work, and he's expressed interest in that. And I spoke to the folks at Care Dimensions, and they said they would be interested in speaking with him. No promises, but they would be interested in speaking with him. My wife, Chrissy, is a registered nurse. She's a certified nurse midwife. We have 4 grown children, ages 24, 26, 28, and 30. Ramadan, if he's able to move in with us, he'll have his own room, his own bathroom, his own telephone. We have a nice, big old 125-year-old house in Newton. I work from home. My wife is at home every day. 2 of our adult children are at home. Our dog's at home. It's a nice place. I think he will feel welcome. I've talked with our neighbors in Newton Highlands, which is where we live, about the impending possibility of Ramadan moving in with us if he's granted parole, and they're pleased and excited that he would be part of our neighborhood. We consider him a member of our family. We are ready to accept him into our family. Attorney Teitelbaum asked me if we were intending to provide financial support for him, and I said, yes, we are. We can do that. In fact, some of our his supporters have already donated $2,400 for him, and I have an account for him, and that money is there. But we will support him financially until such time as he can find a job. I spoke to the folks at Whole Food Market in Newton Highlands. It's about a 10-minute walk from our house. And they said the same thing as Kira mentions. No promises, but we're happy to speak with someone who's an ex-convict. And yes, we will talk with him. And the possibility of work at the local Whole Foods is a possibility. I've arranged his medical care with Dr. David August, who's got a concierge practice in Chestnut Hill, and he said he would waive the concierge fee, which I appreciate. We arranged for mental health care with Dr. Bob Joseph, who's a psychiatrist in Newton. Our dear friends, Dr. Alan Abrams and Dr. Rich Balaban, have said they will stand in if we need any help around the house, should we be away and Ramadan needs something. We have some backup. So in summary, it is my sincere belief that he has paid his dues to society and he is ready to give back to society. As I said at the beginning of my comments, there are no excuses. There is room for forgiveness. Thank you for giving him this opportunity. He and we will not let you down. Thank you.
Thank you very much. Councilor Devaney.
Thank you for your testimony, and thank you for the time. We've talked a few times. And I say this, and I don't say it frivolously, but I mean it. If you looked up kind in the dictionary, there would be a picture of you and your wife. You are unbelievable. I've been here 23 years. I've never seen anyone come and offer what you're going to do for this man. And I think that's wonderful. And what a wonderful future he will have, to have a neighborhood that supports him and in a job out there. So I want to thank you for that. So you got involved, your mother-in-law, from your mother-in-law. So she got to know Ramadan. I know. Why don't you tell a story?
Yeah, so briefly, my wife's mother, Marjorie Stryker, was volunteering with a program called Alternatives to Violence. And she met Ramadan in prison, and she felt that he was a man with a lot of promise. And he saw that she was a mentor with a lot of promise for him. So it was a good match. And she was able to help him pull himself together and become a really good student and learn a lot about the world. So I thank my mother-in-law for making the
I want to
original
follow up
connection.
on you on, this is a side thing. I did a little investigating, and there's a lot of inmates at Bridgewater who are very, very sick, some dying. You don't send them to Shattuck. You know, William Allen went to Shattuck. He didn't get the medical help that he needs. And I'm very concerned about that. And I don't know who to go to about it. So I hope that we can work together to see that there is some resolution for that, because there is a need, and there is a need to have the proper doctors and medication. And, you know, I'm not trying to be demeaning, but we know Shattuck Hospital, and we know the little that they have been providing. So I hope that, I'm saying it publicly now, so I hope that we can work on that and help those inmates that need the medical help that unfortunately William didn't get, and Ramadan didn't either. So I'm kind of talking, you know, on the side, but that I hope we can do that. But again, thank you for what you're doing. I know when I met with Ramadan, he speaks so highly of you and your wife and your mother-in-law that you are family. And I'll be looking forward to seeing where he's going. He's got the education. He's gone through a lot of programs. So I know wherever he works, he'll he'll do a great job. So thank you for all you're doing.
Thank you very much.
Appreciate it.
Thank you very much. Very briefly, he's going to live with you, and who lives in that house?
My wife, me, and our two older children, Julius and Isabel. Julius works for Riverside, caring for folks with disabilities, and Isabel is a grad student at William James, getting her doctorate in
got it.
psychology.
Special, very special person.
Yes, sir.
Very, very, very compassionate person.
Yes, sir.
You should be commended. Really, words can't describe what I think of you and your family, what you plan to do. Thank you very much for your testimony.
Thank you.
Very compelling. Thank you. Next, we'll hear from Elaine Daniels.
Good morning, and thank you for the advisory board for giving me this opportunity to talk about the man that I have known and loved for 52 years. Ramadan and I were married. Well, we met back in 1969. We were just out of high school. We both worked at the Boston Gas Company. I'm not going to go off my notes here because I know I only have a short period of time, and my notes may carry me further on. But we met in 1969, just out of high school. I was 18 and he was 19 years old. We've never lost our love for each other during the entire time that he's been incarcerated and before he was incarcerated. We were married at one point, and I became disillusioned after the Willie Horton situation, years after the Willie Horton situation. I lived here. I worked for the Department of Correction. I worked for the United States District Court. I helped them move in that building that they are now on the waterfront from the Post Office Square. I have a lot of experience. I worked, because I said, the Lawyers Committee for Civil Rights. I did legal aid work. I worked with the Legal Aid Society. So I understand the laws of Massachusetts, and I understand what it takes for someone to survive once they've been released from prison. I spent 48 furloughs with him. We never had one incident. There was never any drug use. There was never any alcoholic use. We attended church. I'm verifying just what he said earlier. We attended church at St. John Missionary Baptist Church, where I was a member at that time. Currently, I am living in the state of Florida. I'm a real estate agent. I hold several positions on different boards. I'm a secretary for Broward County Housing and Community Development Task Force. I'm also, I live in Castle Garden, which is a 55-plus community development condo area, and I am the president of my building. But I plan to move back to Florida, to Massachusetts. I don't know where I am. I'm in Florida, Massachusetts. But I know by the weather. But I plan to come back to Massachusetts and do what I can. We plan to remarry because I got disillusioned after we did so many things. He has had to fight for everything that he's had. You asked about his co-defendant, Raymond White. Well, Raymond White did something that Ramadan would not do. He was given all these privileges, furlough release, work release, way before Ramadan was given these releases. Ramadan had to fight legally to obtain these privileges. Raymond White came out to work on work furlough, and he went on escape. That's why he's not here now. He went on escape. He was out in Texas, and then he started coming back to Massachusetts, and that's when he was arrested. I feel like Ramadan was the only, there was 3 people involved. I feel like out of the 3, he's the only one that stood up like a man and took his punishment. And I think he should be commended to that, because the other person turned state evidence, and Raymond White went on escape. Ramadan had 48 furloughs. He and I had 48 furloughs. He was also going out in the community doing mentoring. He was out in the community cleaning cemeteries or whatever it took. He's a man that I've known all of my life. And I feel that our relationship is so strong that if I had been here, I may have able, because I left him at that time because things was just crazy, Vietnam War and everything that was going on. I feel like when this incident happened, if I had been here, it would not have happened. I feel that we have that kind of influence on each other. I plan to come back to Massachusetts. I've spoken with people today and in the past, even some of the people that are here, because I'm a paralegal as well. I went to Northeastern. And when Will mentioned Northeastern University, I feel like there's a spirit there. Because when I attended Northeastern University, I got my paralegal studies there. I don't even know if they have that course anymore. And he helped me do my schoolwork. I would send him my assignments in the mail, and he would do the schoolwork and send it back to me. And my study partner and I would go to the library, the Northeastern University Law Library, and we would trace down everything that he had done for us so we wouldn't be stupid in class. This man has been better to me than men on the street. I have never in my life met a man with the tenacity and forgiveness and the heart that Ramadan has. This is all I have to say now. If you have any questions for me, I would be happy to entertain them.
Counsel?
Thank you. Counselor Devaney.
Your testimony is very meaningful, and I admire you for coming and speaking for Ramadan. He spoke of you when we met, and when you think of that time, you were young. You were a young girl and married, and then he's drafted right away, and all of that happened to him, the drugs and everything. You can understand your position at the time. So you really are amazing to come. And I admire you and thank you for all you do as a paralegal. So I just want you to know your testimony means a lot to me. Thank you.
Thank you very much. Thank you for your testimony. We really appreciate it. Next, we'll hear from Chaplain Peggy Newman. She supervised Mr. Shabazz participation in the companion program. Good morning. How are you?
Good morning. I'm quite well, thank you. Very happy to be here today. And very happy to have this opportunity to speak on behalf of Ramadan. At first, I knew him only casually. He was a cadre at the state hospital who others looked up to, and I knew he was a man who took his faith seriously. But it wasn't until Ramadan became a companion that I came to know him well. The companion program was established as a volunteer commitment that required several hours of work one-on-one, as well as participation in group activities and our weekly supervision group. And this was all in addition to his full-time work as a cadre. At first, we weren't sure how many men would volunteer to be in the program that took up so much of their time and energy. But Ramadan didn't hesitate. He was one of the first to apply. He completed the training program with flying colors. He easily mastered everything from the use of adaptive equipment to working with whoever we assigned him to. As it happened, we needed a cadre companion who could work with an individual who most would consider difficult because of his violent outbursts, his speech impediment, which made him sometimes difficult to understand, and his cognitive deficits. We needed someone patient, compassionate, reliable, and sincere. Above all, the person would need wisdom and insight. And we found all of these attributes in Ramadan. It's not just a coincidence that Ramadan and Will Allen worked with two of our most difficult and challenging patients. These two men are cut from the same cloth. They're both exceptional people with great wisdom. They can sense what a person needs and find healthy ways of meeting those needs. By imagining what it would be like to walk in another man's shoes, they have a depth of understanding that many other people do not have. Something happens to men who serve as companions. In opening their hearts to another person in great need, in an environment that often does not value openness, they have an opportunity to become their best selves. Ramadan was an extraordinary individual before he was a companion, but I think the program enabled him to deepen in empathy. And because cadre companions work together on many group projects, Ramadan was also able to benefit from the experiences working as a member of a team. Ramadan's many talents and skills transfer to the everyday things that happen in life. If granted his freedom, I'm certain that he will be an asset to his community. Anyone who comes to know him well will learn from him, and I know he will not hesitate to help anyone in need. As you can see, Ramadan has many people ready to help him in any way they can. Second Chance Justice, which was the group that worked with Will, We'll be there for Ramadan, just as we have been there for Will. We would love to adopt Ramadan and bring him into our Second Chance Justice family, and the Parkers too. In closing, I'd like to say Ramadan is a man without pretense. What you see is what you get. A man with integrity and a good heart. Thank you.
Thank you very much. Thank you very much. Next, we'll hear from Carl Bowen, institutional school principal.
That sounds
DOC.
scary, doesn't it? Institutional school principal.
What's that?
Ramadan, I forgot about the road race, by the way. My name's Carl Bowen. Well, welcome. Thank you for having me. I really appreciate it. And Ramadan, welcome. So my name's Carl Bowen. I worked as a school principal in the Massachusetts Department of Corrections for 34 years. I met Ramadan after the Willie Horton incident.
Excuse me, before you even start.
Yes.
I am, because I've had some requests, we're going to take a 5-minute break. Okay, maybe a 10-minute break. People have to go to the restrooms, and we'll be back. But sorry to have interrupted you. Okay, thank you.
All right.
in special ed, GED, life skill, and English as a second language. Don't know how good his Spanish is, but he was an English as a second language tutor. And I look back, and just yesterday, I recognize that often our tutors stay in one subject area. And I have a funny feeling Ramadan did that moving around or asked for transfers because he wanted to learn. He wanted to learn about special education. He wanted to learn if he lived in America with a second language. And I also recognize there's great value in the classroom. I once had a brand new teacher who was trained to teach in public schools, not a prison. And this can be overwhelming for a young teacher to come into the prison system. And she was going to be assigned a teacher's aide by the name of Ramadan Shabazz. And I knew she'd be in a much better position to develop her skills as a correctional educator because of him. And it came through today, and I actually wrote it down a week ago. His current abilities are going to make Massachusetts a better place. I see him working in a mental health facility with juveniles who may be in trouble with the law, in hospice. I can only imagine what he's going to, I want to hear from him the month after his release. He's a little overqualified for Whole Foods. But let me finish. He's truly a story of redemption, a man who entered prison at his lowest depths of his life and is worthy of this rare commutation. And I thank you for your time and Ramadan's consideration.
Thank you very much. Any, Councilor Joseph Ferreira?
Thank you. Well, thanks for coming in. I spent 30 years in law enforcement, but not in prison, so I don't know what a institutional school principal is. Were you a, is that
I was kind of a regional, I had all of Bridgewater and Plymouth, and we ran academic vocational school programs ranging from special ed through high school equivalency. We had college. I supervised the Norfolk program when I worked over at Norfolk for years. I'm well aware what BU does. And I work at Massasoit now, I teach government and criminal justice courses.
Were you a
And we'll be
civilian or were you part of the DOC? How did
I was
that
part
work?
of the DOC.
Part of the DOC.
Yes.
Thank you. Did Mr. Callis, was he there at the time? Dan Callis?
Yes, oh, sure, absolutely. Yes.
And Mr. Cowan, was he there?
Yes, Brad Cowan. Yep, the big guy. Yep.
Both Somerset guys, good
Yes.
guys.
Yes.
I appreciate you coming in here because it is still a mystery to me why these three came before us in the last couple of months and not others. So I don't know how they select, but you said he's the most deserving, but I don't know the process. I know people can apply to the parole board and they get yes or no, but I'm not sure why these three especially got chosen.
Yeah.
Can you shed light on that?
Yeah, probably their attorney,
Their attorney?
I would suspect.
Yeah. There you go, Mia.
No, I can't. I'm sorry, I can't shed any light on the process, how someone gets to this point, another man or another woman doesn't.
All right. Thank you.
Thank you, Raz. Councilor Marilyn Petito Devaney.
Thank you for coming.
You're welcome.
Your testimony means a lot. I just want to thank you for the work that you do. That's very important. And for your interaction with this nominee. Thank you.
Oh, you're welcome. Thank you.
Thank you. Last, Councilor Paul DiPaolo.
Thank you for being here. I just have a quick question. So what age is being serviced in your
18
institution?
to 80.
18 to 80?
Yeah.
Okay.
Roughly. I truly mean that. He was such a great role model. And someone brought it up at one of the other things. He is a role model for staff. It is a hard place to work, prisons. Old Colony in 1988 in up through the early 2000s. Let me say this, was real difficult because we were called a high medium, but that's only because Walpole grew tired of some folks and sent them down to Old Colony. And it was a hard place. And he was a great role model for staff also. When we talk about how positive Ramadan is, that doesn't quite tell you the extent of the positivity he showed. I truly believe that other staff believe because of him change can take place in inmates.
Thank you very much. Before we leave, Counselor Mary Hurley, I believe,
Yes,
yes, Counselor Hurley, you have the floor.
thank you. I just have a question of this gentleman. Being involved in the educational system, is it for a certain limited number of prisoners in one place, or is it a system that takes into account all of the different prisons in Massachusetts?
Counselor, I'm retired, and I loved my job, but I didn't like prisons anymore. But I think I can answer your question. There's always waiting lists for programs, particularly the most valued college vocational training. Is that what you're asking? Is there enough space for inmates who want to become students?
Yes.
To some extent, not always. Some of the waiting lists are pretty long, probably even today. They were when I was there.
All right. Thank you very much for your service. And I just have one comment or question for Ramadan, but my dog is going crazy right now and I got to put her out. So I'll be right back. All right, Maggie. All right.
Thank you. Thank you. At this point, the
Oh my God.
hearing is concluded. More likely than not, you never know, Ramadan, but more likely than not, I would believe that the vote on your commutation will come tomorrow. I will recommend to the body, for whatever it's worth, that your sentence be commuted. You can count on me for support. I wish you the best, and like I said to this other gentleman, Mr. Allen, don't let us down, okay? Thank you. That will conclude the hearing.
Counselor Anello, I just wanted to say,
Excuse me. Yes, Counselor Hurley. Counselor Hurley.
yes. I just wanted to say to Ramadan that I am the same age as you are, and I can't imagine having the attitude that you have, spending that amount of time in a correctional facility. I think your story is worthy of a yes vote, and I'll be voting for you tomorrow. Thank you.
Thank you. Thank you.
call the call. Council Mary Hurley is on Zoom, on WebEx. My name is Terrence Kennedy. For those of you who do not know me, I am chairing this hearing. I do recognize a lot of people over the years here today. I've had a lot of discussions over the last 2 weeks with counsel for the petitioner as well as Attorney Hardoon about how we're going to proceed. And everybody's in agreement, I believe, in terms of the manner in which we're going to do this. And I just want to make a couple of comments before we start. We are not here to try the in-laws of the Phillips Acre case. This is not a trial. And it's not about guilt or innocence. Nobody in Massachusetts can get a pardon or be nominated for pardon unless they have been found guilty. And as they sit here today, as the lawyers sit here today, they are guilty. The issue is whether they're eligible for a pardon or whether this body decides to grant the governor's request for a pardon. That's number one. It's about what they've done since their conviction, really, when we look at parts. It has not been our recent practice to have hearings for pardons. We decided that it was appropriate in this case, obviously because of the strong public interest, as well as the emotions involved. Very high. I've seen it over the last 2 weeks, exactly how strong the emotions are. And we recognize that the students and the parents of the group should have an opportunity to be heard. Everybody is going to get their opportunity to be heard. Couple of rules. I discussed with the attorneys that they are going to give a presentation, each one, and I've asked them to keep it to 10 minutes. I'm not going to cut anybody off, but I'm suggesting they try to keep it to 10 minutes because this is going to be a very long hearing. I've asked for witnesses to keep it to 5 minutes. Once again, I'm not going to cut anybody off, but I am asking you to try to keep it down to that. I'm going to start by reading the letter from the governor. And it's unusual to do 2 pardon hearings at the same time, but I saw no reason that we shouldn't be able to do that because it's the same witnesses, it's the same case. And do this twice, I think, would be a burden on everybody. So the first letter is dated November 18th, 2022. It's to the Executive Council. The council is pursuant to Article 3 of Section 1 of Chapter 2 of Part the 2nd of the Constitution of the Commonwealth of Massachusetts as amended by the amendments to the Constitution. I submit your advice and consent my decision to pardon Cheryl Amirault for the following convictions: rape of a child, 3 counts; indecent assault and battery under the age of 14, 4 counts. Signed, Charles Baker. The second letter, November 18, 2022. Pursuant to Article 3, Section 1 of Chapter 2 of the Constitution, I submit for your advice and consent my decision to pardon Gerald Amirault for the following conviction: rape of a child, 8 counts; indecent assault and battery on a child under the age of 14, 7 counts. Sincerely, Charles D. Baker, Governor. We're going to start the petitioner's attorney, and then we're going to call the witnesses that they've indicated they would like to have speak on behalf of the petition. After each person speaking, the council will have an opportunity to ask them questions. Then we are going to shift, and we are going to hear from Attorney Larry Hardoon, who is the main prosecutor in this case, as well as Janet Fine, who is the victim witness advocate in this case. And they gave me a list of witnesses that would like to testify against the pardon. So that's how we're going to proceed. And everybody, the councils will get to ask questions at the end of their testimony. So we are going to start with the attorney. Please identify yourselves and give us your presentation.
Thank you, Mr. Chairman, members of the council. My name is James Sultan, and I'm attorney representing both Cheryl Amirault Lefebvre, Gerald Amirault. Let me just say at the outset, I'd like that the fact that Cheryl and Gerald are not present today is that the express.
Let me say that. I asked them, and we discussed that, I discussed it with Attorney Hart, I meant to say that, is I asked them not to come, because it's not a trial. I think everybody, the temperature would be a lot lower without them here. I think it's everybody would have a pretty good idea what they would say, because they've been saying it for the last 38 years. So I saw no need to bring them in, and I asked the attorneys not to bring them in. That's why they are not here. Yes.
Could I just respond to that?
You certainly can. I know the
Just-
council, I
just very-
did want them here.
Just very briefly, in all the commutations that we always have had for a number of years, we allow the victims to come in. We always allow that. So then they can, excuse me, so the victims can hear. Sometimes the victims will say, I approve of the commutation. Sometimes they say, I don't. Same thing with a pardon. I would have liked them here, especially due to the fact that I think it was in your brief or some information I read, you had an issue with confrontation, that the victims, or I should say, the Amiraults weren't able to confront them in the courtroom. Their backs were turned. So I would have liked them here, but that's just me.
Counselor.
Thank you.
All right,
Counselor,
Sarah, if you-
Counselor Kennedy, I agree with my colleague. I've been here 23 years. We deserve to see the people that we're having this meeting for, this hearing.
Thank you.
Counselor Kennedy,
Thank you. And I
this is
just-
Mary Hurley.
uh,
I agree as
respond
well.
With respect to their presence here, we deferred to the wishes of the chair, and I felt that as a matter of decorum and that was the appropriate thing to
Not the
do.
vote
I
of the
hope
chair.
that none of you will hold it against them, that we did defer.
They can
to
hold
the
it
chair.
against me, not against.
Okay,
If we
okay.
can vote of the
And
council.
with respect to confrontation, Counselor Iannella, we didn't have a problem with it. The Supreme Judicial Court said in its decision in 1997 that there was no doubt that their constitutional rights of confrontation were violated. So I'm happy to answer any
But that
questions I
was
can.
not, very briefly, that was not an issue with any of the defense attorneys, and they were respected defense attorneys, some of the best in the state. They did not have that issue.
That's right.
Now,
Thank you.
if we could let him give his presentation
Sorry.
at this point.
Thank you. I will.
Counselor.
Thank you.
Thank you.
In 1692, 330 years ago, a wave of hysteria led to the unjust conviction of more than 30 Massachusetts citizens for witchcraft. The evidence against them came largely from witnesses who claimed that the defendants appeared to them in spectral form as demons and assaulted them. 19 of those convicted were hanged. 5 others died in prison, and one accused man in his 80s refused to enter a plea and was pressed to death with heavy stones. In 1984, 38 years ago, another wave of hysteria led to the unjust conviction of preschool teachers and staff members for mass sexual abuse of young children in New Jersey, in North Carolina, in California, and elsewhere. And here in Massachusetts, Violet Amirault, a woman in her 60s who owned and operated the Fells Acres Day School in Malden, and her 2 children, Cheryl and Gerald, who worked at the preschool, were accused of sexually assaulting numerous young children there in a magic room or a secret room. Those young children, mostly between the ages of 2 and 5, were subjected over a period of many months to repetitive, suggestive, and coercive questioning by well-meaning law enforcement officers, therapists, and even their own parents, who were told that no does not mean no. As Superior Court Judge Isaac Bornstein later found, following a lengthy hearing, the investigation was permeated with bias. The pediatric nurse who conducted many of the interviews, quote, violated every requirement of a fair interview, seeking truthful answers in a neutral investigation, and, quote, every trick in the book was used to get the children to say what the investigators wanted them to say. His written decision included over 20 pages detailing the blatant manipulation and coercion of just one of these children, now grown up, who I expect you will hear from today. And I urge you to read it if you haven't already. After repeated denials, a number of these children eventually were persuaded to make allegations of sexual abuse against the Amiraults, which they repeated at trial. Cheryl and her mother, Violet, were accused, among other things, of putting a purple and white magic wand into the vagina and anus of a child and a stick into the anus of another. Gerald was accused, among other things, of putting a magic wand in a child's vagina, a fork into another child's vagina, and a knife with a foot-long blade into the anus of a third child, while dressed as a clown or as a lobster. These children also claimed that they were tied naked to a tree outside the school by all of their teachers every day. That all of the teachers gave them white pills to make them drowsy. That several of the teachers were naked at school. That Violet and Cheryl punched children with their fists. That Cheryl killed a bird, a squirrel, and a dog in front of the other children. That 16 children died at the school. That a silver robot threw a child and bit her, and that another child was threatened by a talking robot with big wheels and chased by balls of light. A number of the children said that they were photographed while naked. No such photographs were ever found. There was testimony about behavioral problems experienced by some of these children at home, as well as physical conditions, all of which are commonly found in young children from a wide variety of reasons. But no scientific or physical proof of sexual abuse was ever presented, let alone abuse committed by the Amiraults. As Judge Bornstein concluded, quote, "In no way do the behavioral or physical symptoms of these children serve to corroborate their testimony." Now, at trial, dozens of teachers and aides who had worked at the school testified that they had never seen or heard anything indicating that any sexual abuse or violence had occurred, that they never lost track of children in their care, and that they never heard of a magic room or a secret room at the school, or saw a robot, or saw Gerald dressed as a clown or as a lobster. A number of parents testified that they made unannounced visits to the school and never saw anything that concerned them. Nevertheless, amidst the hysteria of the times, Gerald, Violet, and Cheryl were all convicted of multiple counts of child rape and indecent assault and battery on a child. Although 3 highly respected Superior Court judges subsequently ruled in their favor, their convictions were affirmed by the Supreme Judicial Court. In 1997, the SJC wrote that they had, quote, "no doubt," close quote, that the Amirault's constitutional rights to confrontation were violated at trial, and the court condemned the suggestive investigative practices that took place. Yet despite a sharp dissent by Justice Francis O'Connor, the court overturned Judge Barton's grant of relief due to defense counsel's failure to object to trial and, quote, "the community's interest in finality," close quote. 2 years later, the SJC overturned Judge Bornstein's grant of relief without reaching the merits of his decision, because it found the scientific evidence he reviewed in 1998 was not sufficiently new under the law to outweigh the system's interest in finality. Violet served 8 years in prison and died of cancer in 1997, shortly after her release. Cheryl also served 8 years in prison and 10 more years on probation. She remains on the sex offender registry today. Gerald served 18 years in prison and has served 18 more years on parole. He still wears an ankle bracelet to monitor his every movement, is subject to regular polygraph examinations, and remains under strict parole conditions. He too is on the sex offender registry. So how did this happen? As Judge Bornstein explained, quote, "The disclosures and testimony of the child witnesses were the product of coercive and overly suggestive interviewing techniques, as well as a number of other unacceptable influences. Those interviewing techniques have now been found to be grossly improper and would never be used today. As we now know from scientific research done over the past 3 decades, those manipulative techniques used with young children can result in implanting false memories, which will thereafter remain. The unjust conviction of the Amiraults based on such tainted testimony are a relic of an earlier time, the product of widespread hysteria and investigative blunders that will never be repeated in our state, because law enforcement learned from their mistakes in this case, which has become a textbook example of how not to investigate such charges involving young children." Excuse me. All of those convicted of witchcraft in Massachusetts in 1692 were later exonerated. The last one, Elizabeth Johnson, was pardoned only earlier this year. In the words of the statute enacted in 1957, in that case, quote, "Although the facts of such proceedings cannot be obliterated, such proceedings were and are shocking and the result of a wave of popular hysterical fear, and the laws under which said proceedings were legally conducted have long since been abandoned and superseded by our more civilized laws. The convictions of preschool teachers and staff members of child sex abuse in New Jersey, North Carolina, California, and other states have been subsequently overturned as well. Yet here in Massachusetts, the conviction of the Amiraults in the Fells Acres case remains on the books to this day. Now, members of the council, I understand that not everyone agrees that the Amiraults should be pardoned. You have all undoubtedly already heard from and will hear today from opponents, including those who fervently believe and will always believe that they or their loved ones were sexually molested at the Fells Acres Day School nearly 40 years ago. I feel badly for these folks because they have suffered and continue to suffer the trauma of having been victimized, not by the Amiraults, but by those who investigated these allegations with good intentions and in good faith, but did not know how to do their job properly at that time. I know we will never change their minds. I also know that you are not here today, as Chairman Kennedy said, to retry the case, to decide whether the Amiraults are guilty or innocent. That's not your task. We rely on the criminal justice system in Massachusetts to adjudicate guilt or innocence. But occasionally, that system fails, as it did here, because the evidence underlying these convictions was the product of grossly improper, biased, and suggestive interviews of very young children, which rendered their accounts forever unreliable. As a result, the Amiraults did not receive fair trials, so their convictions were unjust, and they and their family have suffered grievously and still suffer as a result of those unjust convictions. In such cases where the court system fails, executive clemency serves as a necessary and proper vehicle to rectify injustice. And I understand that the members of this council have strongly supported, in a general sense, the use of executive clemency, which has been badly underutilized in Massachusetts in the past. Now, I realize that these two pardon applications did not follow the usual course, which involves, as you all know, a hearing before the parole board acting in its statutory capacity as advisory board of pardons, followed by a favorable recommendation and report, and then endorsement by the governor and submission to the council. Now, since Attorney Hardoon has raised questions about the process in his written statement, I submitted today to the council copies of all of the relevant correspondence that, and I have copies with me if you haven't, if you didn't get it, but I believe that you all have copies of that documentation.
Say two things. Number one, we haven't had a chance to look at anything that you submitted today. We've been working all day. And I'm going to ask you to wrap up. You're going pretty far past the 10 minutes.
Okay, I will. Thank you. As you can see from the documentation, Gerald and Cheryl filed their pardon applications in early February. They were referred to the board. We sent courtesy copies to District Attorney Ryan, so she would be on notice and could notify others if she chose to do so. Cheryl and Gerald hoped and expected that hearings would be scheduled so they could appear and testify. But in August, the parole board notified them they were not going to hold a hearing on either pardon application, and they recommended to the governor that he reject them. Fortunately, the governor chose to conduct his own independent investigation and ultimately decided to reject the parole board's recommendation and grant both Cheryl and Gerald executive clemency, subject to this council's approval. It's ironic that he did so because then acting Governor Jane Swift rejected the parole board's unanimous recommendation to commute Gerald's sentence 21 years ago, consigning him to additional years in prison. So the parole board's recommendation of in executive clemency cases, either positive or negative, is not always rubber stamped by the governor. And that's as it should be, since our Constitution grants the governor unfettered power to grant clemency subject to this council's approval. Now, and the suggestion that these pardons were the result of some improper backroom deal is patently absurd. These people have no money or power other than the moral weight of their cause.
I'm going to ask you to wrap up.
Okay.
Way out there.
In sum, the pardons recommended by Governor Baker would bring a fitting end to this tragic case by allowing Cheryl and Gerald to live out the rest of their lives in peace and promote healing and closure for all involved. I may have 2 minutes because to respond to Attorney Hardoon's statement because it's my only chance to talk today. May I have 2 minutes?
You're going to be asked questions.
Okay.
Okay.
All right.
So
All right. So I will not, I hope I have an opportunity to address his statement in questions. In closing, I urge each of you to approve these well-founded grants of executive clemency and wipe a stain from our legacy of criminal justice. Thank you, Mr. Chairman.
Council DePaulo, do you have any questions?
I do.
Good afternoon.
I want to dig into some of the details here. So.
Let me turn my microphone on. So I know that we're not here to relitigate the case, but the details of the case are being presented as part of the argument here, that there's an underlying problem with the trial. So around the issue of right to confrontation, the child victims were seated improperly in such a way that the right to confrontation was denied. And do I have that accurate? And if so, what could you describe the seating that was inaccurate or improper? I'm sorry.
And this is discussed at length in the SJC's 1997 decision.
If you could just summarize it.
Sure. So the children our Constitution requires face-to-face confrontation.
Sure.
And rather than doing that in this case, as I recall from the record, the children were seated at small tables in front of the judge or in front of the jury. They were not
in the courtroom.
In the courtroom,
Okay.
They had their backs to the defendants, and
now
that in general, that was what the SJC found to be a constitutional violation.
Okay, and so they were in the courtroom. The child victims.
I think there were several children who testified by videotape. but the majority were in the courtroom.
Okay,
Yes.
so a majority of children were in the courtroom.
Yes.
They're sitting before the judge
In front of the jury box, I'm sorry.
and in front of the jury box.
In front of the jury box.
Okay, so they're in a very intimidating situation for a child, for sure.
Absolutely.
Now, what would be the suggestion of proper procedure today? Would a child have to face the alleged abuser or rapist
Well, I believe that.
in the courtroom, as I'm facing you now? Is that what is expected of a child victim?
Well, while there are accommodations that a judge can make for child witnesses, the SJC basically said in this case, in keeping with its precedent, that there would have to be some way of accomplishing the face-to-face confrontation.
Are you aware? I apologize. My only experience in this area of law is a summer internship in law school in the child abuse division of the Suffolk County DA's office. But I'm wondering what happens today specifically. I honestly don't know. How would the right of confrontation be met by a child who's an alleged victim of rape?
I think that's a great question. I have
Would it be
not-
different than
I-
what
I have
happened?
not-
I need to know if it's different than what happened, because this seems like to be a crux of the matter.
Well, I have not tried, I do try cases. I have not tried a case involving children this young. There would have to be obviously a competency hearing to make sure that the child was able to testify. Again, I think the law has evolved over the last 30 years so that the judge can make accommodations, appropriate accommodations, balancing what would be uncomfortable for the child with the defendant's constitutional rights. How that comes out in a particular case, I really cannot, I don't have the expertise to tell you how that would work in practice. But I agree with you, it's a very difficult problem. And frankly, it is, while the SJC did find that that was a violation, I mean, that is only part, obviously, of our substantive argument.
Of course, but it is one point, right?
It is.
So, and I want to say you've been very helpful and forthcoming with materials, and I know we received a lot of materials today. And it's no fault of your own, but your materials are really the only materials we received other than unsolicited commentary. And so that's not your fault. You've been a tremendous advocate, I think, for your client. But one reason why I would have liked to see more people involved in the case here today is because there was no parole hearing, as you noted. There's been no public hearing to address this. And here we are on a pretty tight time frame with no parole board hearing, being asked to rely on the petitioner's attorney to make our determination. In other words, I have no recommendation from the governor explaining why we're here. I have your arguments, which again, I think you've done a tremendous job for your client. But I guess that's neither here nor there.
Well, I appreciate your saying so. Obviously, we asked for a hearing. That's what we asked for. We filed in February. We said, give us.
I'm sorry.
Yeah.
You've done everything proper.
Okay.
I have no question, zero question about that. I want to make that very clear.
Thank you, and I appreciate that, but it's more than that. It's that the parole board refused to give them a hearing. I mean, honestly, Councilor Paulo, that's on them, and I think it's a shame.
I'm sorry, I can't hear you, counsel.
That's Councilor.
Counsel, is your microphone on?
I'm sorry. I
You're
apologize,
too far
Councilor.
away from the mic.
I'm sorry, Councilor.
Okay. And I
So-
appreciate, I don't want to get too far into what the parole board did
So
or
they
didn't
didn't
do,
give us
because
a
I know
hearing.
that'll come up later. But
I
I
think-
wanted to ask,
Yeah, sorry.
I'm sorry. So, around the matter of hysteria, I understand the eloquent comparison to a witch trial, but I don't see the connection here. I understand, and I was too young at the time to be aware of what was happening, but I'm told there was hysteria around the country around this. As you indicated, other states had folks who've been since exonerated in one way or another. But we're Massachusetts. So I think about the clergy abuse scandal, which was alleged to be hysteria until we found out it wasn't. I think about the Me Too movement, where all of a sudden we started believing victims. So I just don't know, for me, that the witch trial thing lines up.
Okay, well, can I respond?
Yes.
Okay, so I don't think this is anything like the clergy scandal, which came out honestly in, dribs and drabs, or the Me Too movement. Here, as far as where this came from, there was an allegation against Gerald Amirault by a child. He was arrested. The school was closed down. A week later, on September 12th, 1984, a meeting was called at the police station. I think it was at the police station, for all the parents. And at that meeting, and this is not what I'm saying, this is what the SJC says.
Sure.
In its 1997 decision, quote, "The police advised parents to undertake their own investigations of possible abuse of their children and were told some of the details of the abuse reported. This obviously opened the door to parental suggestions of charges that might otherwise never have occurred to the children. It might also explain the similarities in some of the charges the children eventually made." And the court added, quote, "We do not hesitate to condemn such practices as took place," close quote. So the hysteria was generated in these parents who understandably were totally freaked out.
But so the suggestiveness may indicate why there was similarities, but it might just be the circumstances that elicited those similarities, right? I mean,
that's right.
Where it started somewhere, right? Like because there were 8 counts, depending on which petitioner we're talking about. One had was convicted of 8 counts of rape of a child and 7 counts of indecent assault and battery. And there were multiple victims, right?
Allegedly, yeah.
So were there 8 alleged victims of, for example, on the 8 counts of rape of a child, were there 8 victims?
I believe there were, I believe there were a total of 9 children who ended up testifying at the trials.
Yeah.
8 against Gerald. I think there were 4 against Violet and Cheryl. There were 3 children who testified at both trials. So, I mean, and there were other children who made allegations at different points.
Sure.
Who were not called.
And some of the allegations that were similar, were they amongst children who were not contemporaneously at the daycare facility? Were there similarities between any children's allegations that weren't contemporaneously at the daycare facility?
Well, I think that most of them were there kind of, at the same time.
But not all, right?
Well, I don't have the answer to that. But
Okay, I
some of them-
apologize. It's my
some of them-
understanding they were not
some-
all there at the same
Some of them were only there part-time.
Sure.
But what happened during these interviews is one child was told, well, Susie told me that
Sure.
XYZ happened.
Sure.
Can you help me with that? So there was cross-fertilization by the interviewers.
But the underlying thing, one thing I'm being asked to consider potentially, which I don't even think is part of our purview, is that all of them were wrong. All of there wasn't a grain of truth that spread and rippled, that all of them were wrong. The initial thing and everything else.
Well, the initial child, who was questioned for repeatedly within his family, because he had a relative who had been sexually abused as a child. He was repeatedly questioned by his mother, by his uncle, and he is a child who had gone to the bathroom in his pants at school and had been changed by had been cleaned and changed by Gerald Amirault. And that somehow morphed into sexual abuse. That was what got this whole thing started. And after that, it mushroomed.
Okay. I just have thank you, Mr. Chair. I just have one more thing I want to hit on before we move on. So, in your memorandum of February 2022 for the parole board, right? In the opening section, it's written that the law, can we mute Counselor Hurley? The law provides that the parole board, acting as the advisory board of pardons, reviews each petition for pardon and makes a recommendation for the governor. But in this case, as you indicated, that didn't happen. Is it your understanding that that the law does not provide for the parole board to do that, or what's your takeaway on that? And again, you acted entirely properly. I'm wondering, has your view changed that the law no longer requires the parole board to do that?
The law, as I read their statute, requires them to review all petitions for executive clemency that are submitted and decide whether or not to hold a hearing, and that's their call, and then B, to make a recommendation to the governor as to whether the petition should be granted or denied. And that's what they did in this case. They made a decision not to hold a pardon hearing for either Cheryl or Gerald. And then they wrote a letter, which I've submitted this morning. I know you haven't had time to look at the documentation. They wrote a letter to the governor saying, we recommend against it.
And I don't think
they followed their statutory.
I don't think it's on you, but I'm not so sure they did. And I bet we'll hear more about that later today. Because when I read in the Constitution of Massachusetts, the Constitution says that the general court shall have power to prescribe. I'm cutting out here, but the general court has the power to prescribe the terms and conditions upon which a pardon may be granted. That's the Constitution. And then in the statute, it talks about what the parole board is supposed to do. That's what the legislature has prescribed. That's my understanding of the law. We're not here to argue that, but again, the process stinks. I think it does no good to your client, to be frank.
I agree.
I mean, we just had a commutation hearing this morning. I got a huge packet from the parole board offering their arguments and recommendations. I didn't just have to rely on the attorney for the petitioner, you know? And the only thing I have from the governor's office, if I can find it, is buried in a press release about other stuff. There's a paragraph which essentially says, I'll summarize the key point. I'm left with grave doubt regarding the evidentiary strength of these convictions.
Well, look,
I don't know that that's a high standard for a pardon.
well, I
Just
agree.
to have some doubts.
Counselor DiPaolo, I agree that the process stinks. They should have been given hearings, and that this would have been totally aired before the parole board. And shame on the parole board for not giving them those hearings. But you're not just relying on me, you are relying on Governor Baker. And I wish he had written you something.
I don't want to besmirch the parole board members. I've had issues with the parole board and how they've conducted things. I think the current board takes their job very seriously.
I'm not suggesting I don't take it seriously. I'm suggesting in this case, they should have given these two petitioners who presented very serious petitions for relief.
Right.
They should have given them a hearing, but I think you are relying not on me, but you're relying on Governor Baker, who investigated, vetted this himself, and made a determination. And I wish he had written more.
I trust that he put. Okay, then I'll stop there. I'll say this. Salute the governor for taking something like this up on his own, if that's what happened via parole board. I mean, we have plenty of people in Massachusetts with convictions for simple possession. And I've seen in the press, the governor says, no, the clemency process is too long, that I can't do that. I can't make that happen quickly, but this seemed to happen quickly. So those are things that are in some ways tangential to the decision on the pardon. But I think it's really important for the public to understand that this hasn't been done in the right way.
Well, again, we filed in February. The parole board sat on this for 6 months.
Yep.
In August, they said, we're not giving you a hearing. The governor then sat on it for, 3 months, and then he made his decision. What went into his investigation, I can't tell you.
Neither can I.
But I agree
Neither
that, it should be more transparent. There should be hearings, and all those people out there who are seeking executive clemency should be given a shot. And my client's got a shot because this is a case which cries out for justice, and good for Governor Baker for seeing that an injustice has occurred and for recommending relief for these people. The fact that a lot of other people should get relief, and they should, is not a reason, in my opinion, to deny these two people relief after they and their family has suffered for 40 years.
Thank you. I appreciate your answers, and I appreciate your advocacy as well, as I said. Yes.
Counselor Kennedy?
Yes.
Council Hurley, go ahead.
Thank you. First of all, could you take your microphone and bring it towards you, please?
I apologize, Councilor Hurley.
That's okay. So we have a situation here where the parole board recommended denying the pardons. Is that correct? Just yes or no? Okay, I'm not hearing anything.
His answer was yes, Mary. Can you hear it?
I think he had his thumb on the mute button. Okay. I'm not hearing anything.
Mary, can you hear me?
Okay, there. How about now?
Sorry.
Can you hear me now, Councilor
Yes.
Okay.
Yes, I
okay.
can.
Sorry, my fault.
Okay. All right.
So the answer to
In any
your
event.
question, Counselor, is yes. The board
Okay.
recommended denial.
All I'm asking for is yes or no, because if I ask you what time it is, you're going to tell me how to build a watch. Okay?
Yes,
In
Counselor.
any event. So what you're basically asking us to do, in light of the fact that the governor ignored his parole board, is to also ignore the parole board. Is that correct? Yes or no?
Yes.
Okay. And if I told you, in spite of all of your discussions about what happened with the parents and everything, I got a call from a mother when this first came out. And she told me about her child having problems long before the accusations came out, where that child at one point was bedwetting, having nightmares, and because of employment issues, she could no longer take the child to Fells Acre. She had a discussion with the mother, Amirault, who said, "Well, that's no problem. I'll come and pick the child up every day." And when she came to pick the child up, after the child not attending for a few days, the child became emotionally almost violent in not wanting to go with Mrs. Amirault. So now I'm presented with a situation where I've had discussion with one of the mothers of an alleged victim, as you call them. And in addition to that, the parole board has recommended against the pardon. So in 100 words or less, tell me what you're going to say to me that's going to persuade me to change my mind.
None of these children reported behavioral symptoms, or none of the parents did, that were consistent with sexual abuse before the meeting at the police station in September of 1984. Some of these children, including I think the one you're referring to, was 1 to 2 years old when she was at Fells Acres. She left 18 months before these allegations were made. Many children don't want to go to school. Many children cry when they're being asked to leave their loving parents. That doesn't prove anything, respectfully, Counselor Hurley.
Okay. Except that she didn't have those problems until after she left the school and didn't want to go back.
There are a host of reasons why she might have been bedwetting. One of them is that she was sexually abused, but you know, there are dozens of others as well.
All right, and you can't tell me with any certainty, because you weren't there, you weren't a part of it, and you weren't involved initially as to what really happened.
I wasn't there, Counselor. That's correct.
Thank you. That's all the questions I have.
Counselor?
Thank you. I'm going in the order immediately to my right as we in accordance with the
Right,
rules.
that's right.
So that would mean it's Counselor Ferrera's turn.
Thank you. I come from a perspective that's a little different. I spent 30 years in law. I've been a lawyer for almost 30 years. I've actually was a special prosecutor. I've done some defense work now since I retired as a police chief. And I was a law clerk at the Superior Court in 1992, 1993. I have read your submittals. I've also read Mr. Hardoon's submittals. They differ vastly. But just, I want to touch on a couple of things, because I know it's going to be redundant just because of the way it's set up today, that I have to ask you questions now before Mr. Hardoon explains a lot of what I might ask you. I don't know. So and I'll just go down the list quickly. The Confrontation Clause was not objected to at trial by counsel, correct?
Correct.
And the SJC said, in that case, it might have been a strategic thing, that the lawyer was okay with it, and it might have been strategically okay, and it was favorable to the defendant at the time. Is that correct?
They said that it could have been a strategic decision and that they were not going to grant relief. Yeah.
Right. And it was 10 years later when Judge Bornstein, about 10 years later?
That was Judge Barton's decision.
Judge Barton's, but it was 10 years later when Judge Bornstein visited the case?
Judge, I'm sorry, the chronology was that the issue of confrontation was raised before Judge Barton, who in 1995 granted a new trial to Violet and Cheryl. The Commonwealth appealed. In 1997, the SJC overturned Judge Barton based on the doctrine of finality. In 1998, after that, Judge Bornstein held his evidentiary hearing on the issues of science and the suggestiveness of the questioning, and he issued his decision and he granted a new trial at that point it was Cheryl because Violet had passed away, and then that was appealed to the SJC, and in 1999, without reaching the merits of what or in any way disagreeing with any of Judge Bornstein's findings, they said, the SJC said, this science is not sufficiently new, and finality trumps the evolution of science, and they reinstated the convictions. That was the chronology.
And, well, thank you for the lengthy answer, but the SJC said at the end of the day that although a constitutional violation occurred, it was not objected to, and there was not a substantial miscarriage of justice. That's the standard, correctly?
That's what they said.
And that's
Yes.
how they ruled.
Yes, sir.
And this was after 32 people convicted them, right? 2 jurors of 16 people, correct?
Well, there were 12 sitting jurors, yeah.
There were 16, sworn in at each trial.
I don't know.
Been to the SJC 6 times with different jurists on the Supreme Judicial Court, correct?
I think that's right. There were six SJC decisions, yep.
And the parole board just this year, well, previously they said no to a pardon, correct?
No, they unanimously recommended a commutation for Gerald in 2001, and then Acting Governor Jane Swift refused to accept their recommendation, and therefore they never came before the council.
And this year, when they denied the pardon, they spoke loudly about that, but they opened the door for a commutation. Is that correct?
Well, they did offer Gerald 21 years after they first approved a commutation for him. They did offer him a commutation hearing 21 years later. And respectfully, after 18 years in prison and 18 years on parole, he was not interested in a commutation.
So it would be your testimony today, sir, that if we say no to a pardon, he's not interested in a commutation next week?
That's correct. He seeks a pardon, as does his sister, who was not offered anything by the parole board. They offered her nothing. They told her to go back to court, and which is a useless suggestion because both of them have long since exhausted their judicial avenues of relief, which is exactly what executive clemency is for, and that's why we're here.
Most of the time, and if and I've done some research on pardons, and if you ask probably a lot of people in this room, what a pardon is, would have different definition and what it means in the long run. But if you look at the governor's order about clemency, it talks about a pardon equals forgiveness. That begs the question that something happened, doesn't it, if they're begging for forgiveness?
I think in the ordinary course, under his guidelines, most people who seek a pardon say, a long time ago I committed a crime, and now I'm a different person, so, please pardon me. This is not that case. This is not the.
I understand they're still claiming their innocence.
That's right.
Now let's go back to the disclosures. I have spoken to the prosecutor in the case, and he's going to speak later, but he tells me very clearly, and I've done SANE interviews, I've done sexual assault investigations, I've put people in jail for it personally. He tells me that these kids manifested problems long before Tukey got arrested, and they disclosed it to their parents who were not related in time or geography. Some were, different grades, lived in different towns, and they spoke similarly of things occurring. And it would just be like an incredible coincidence that the same kids would tell the same stories to different parents long before Tukey was arrested.
it's not a coincidence because they didn't tell those stories before Tukey was arrested, Gerald was arrested. After this meeting at the police station, when all these parents were deputized to be investigators and they were all fertilized with each other, that's when this spread around. And all of a sudden, oh yeah, I remember 9 months ago, my
So,
child.
all right, let me
was
stop you
having
because
problems.
there's not a question in front of you, actually.
Sorry?
But he's going to have a different story. And he
Well-
talked about how the children were disclosing things to their parents and acting weirdly before Gerald was arrested.
Well, none of them were.
He then tells me, hear me out, please.
Sorry.
He then tells me that the parents were told to go home and ask open-ended questions and just listen. They weren't, I know you read from the SJC decision on one of them that it was unduly suggestive. He tells me later on, and I want your thoughts on this, that at some point they did hire a nurse and she did ask leading questions, but that was only a compilation of prior disclosures that were not suggestive. What do you say about that?
I say that is exactly the opposite of what happened. You've done criminal law. I've had cases where, a detective will lean on a suspect, and then after finally the suspect breaks down, then they turn on the tape recorder. That's exactly what happened in this case. If you read Judge Bornstein's detailed account of how each of these children was manipulated over a period of months, that's what happened. They went at these kids over and over and over. They denied. And then finally, when they said, oh yeah, Tookie did X to me, it's like, okay, let's turn on the tape recorder. So the tape recording was the product of all of the suggestive questioning.
That's, all right, I understand that's what you've written and that's what you,
Opposite of what he.
I understand that's what you've written and that's what you're advocating.
It's not what I'm reading. It's what Judge Bornstein wrote, and you're going to hear from both
All right,
him and.
let's talk about Judge Bornstein for a minute.
Okay.
I was a Superior Court law clerk. I wrote decisions for judges.
I
Will
understand.
you agree with me that it could have gone to any other Superior Court judge who would have found the opposite outcome?
I don't believe that. I believe.
You don't
any-
believe that a different,
I don't.
when I was a law clerk, there were 81 Superior Court judges. You're going to tell me that each and every one of the 81 Superior Court judges would have identified exactly and stated exactly what Judge Bornstein said. Is that your testimony, sir?
Counselor Ferrer, as you know better than I, all of these judges are individuals. What I would say is that any judge, any fair-minded judge, objectively looking at the evidence that Judge Bornstein reviewed, and there was a prosecutor there who fought very hard on the other side, any fair-minded judge would come to the same conclusions that he did. That's my opinion.
My understanding, and it's written in Mr. Hardon's brief, that Judge Bornstein didn't hear from prosecutor witnesses, that he only heard from defense witnesses. And he wasn't a trial judge because the trial judge had passed, right? So he just got this motion randomly, correct?
It was assigned to him by the regional
Yes.
justice, yes.
But will you agree that he didn't hear from prosecution witnesses and the children and anyone else?
Counselor Ferrer, you're a practicing lawyer. This is an adversary system. Lynn Rooney could have put who was the prosecutor, she could have presented any witnesses she wanted.
Not that she
chose
could have.
To do that.
So they did not hear from the prosecution at all. So
Well,
Judge Bornstein's decision is written solely on after hearing just the defense side, is that correct?
That was a strategic decision because they weren't.
Was
they
that
were
yes or
gonna-
no? Was it?
Yes.
Yes.
Yes, they didn't present witnesses. That was their choice.
Okay.
Because they didn't have anything, they didn't want to defend what they had done. So they just didn't defend it.
And my first question was, when I started talking to people, like, when was a search warrant done? You know the answer to that?
I believe.
Sure. They
that-
go to lock up Gerald
Yeah.
on a certain date and time.
Yeah,
You would think that the police would have brought a search warrant with them.
I don't believe that happened.
It didn't happen. It happened 3 weeks later. Do you know that?
That's what I've read, yeah.
I have no further questions right now. Thank you. Thank you. Councilor Julie.
Thank you. Attorney Sultan, you said that your client, Gerald Amirault, decided not to go to the parole board for the commutation hearing. Why wouldn't he go to that?
Because after enduring 18 years in prison and 18 more years on parole, and almost being finished with his term of parole after all of that, he honestly felt it was kind of the slap in the face to say, we're not even going to give you a hearing on your request for a pardon, but we'll give you as a little kind of bone, we'll give you a commutation hearing. He didn't ask for a commutation. I mean, they denied him what he asked for, and he did not want he was not interested in that at this point. He was very interested when he was locked up in 2000, being abused by fellow inmates and correctional officers on a daily basis. He was very interested in a commutation then. But now he's been out in the community for 18 years, living with these parole strictures. And frankly, that's not what he was looking for. And his sister, they didn't offer her anything. And, there's been a lot of focus on Gerald. Cheryl is a separate person, okay? She was convicted. She's lived for all these years with this badge of infamy of being a convicted child molester. She can't travel where she wants to travel. She can't live with her romantic partner in New Hampshire where he has a home. I mean, she's on the sex offender registry. This is an extremely onerous, her nieces and nephews have to answer for this, just like Gerald's grandchildren have to answer for it. So I fully supported his decision not to accept a crumb of a commutation hearing. When he was asking for a pardon, he submitted in good faith a serious application for a pardon, and they wouldn't even give him a hearing.
Well, I can appreciate that, but to me, what did he have to lose by going back and saying, okay, I'll do it? He's out on parole, right? He's got all these restrictions. They could have commuted his parole time, couldn't they?
If he had been, I suppose if they had had a hearing and they had recommended.
Well, it would have come to us.
Yeah,
and
eventually it would have come to you.
They could have said, look, okay, you're out, but you got, well, that was in September of this year, right?
That's correct.
So he could have gone there, and if they gave him relief and said, okay, we'll recommend termination of your probation, we'll recommend the commutation to the council, he would have been off probation.
He'd be off parole. He'd still be, if assuming that the governor approved it and you all approved it, he'd still be on the sex offender registry for the rest of his life. He'd still be a convicted child rapist. Those are the things he was interested in doing something about.
So my understanding of a pardon is when you receive a pardon, you get a benefit of going forward. A pardon does not wipe out those charges on his record. In fact, once in my 43 years, I asked for a record, and I saw the record, and I saw the guy had been convicted of this, pardon. So the record doesn't go away.
Absolutely not. It's not an expungement. You're absolutely right.
It doesn't. Right. People have this opinion, I get a pardon, I'm wiped out, my slate is clean. It's not true. So he's still going to have a record whether we give him a pardon or not.
It doesn't change history.
Right. And he's got how much to go in probation?
I think another year.
Okay, so his pardon, if allowed, will terminate the year probation.
Correct.
Correct?
Parole, yes.
Parole, I'm sorry. And I've done some research and I don't have an answer yet. Maybe you do. I don't know whether a pardon takes him off the sex registry board because that is an independent finding by a different agency.
It would. He would no longer have a valid conviction under Massachusetts law. Therefore, under the sex offender registry statute, he would no longer be subject to registration.
Well, I would disagree. He would still have the conviction on his record. That does not get expunged.
Well, I guess we'll litigate that with the sex offender registry board if we're fortunate enough to be in that
I
position.
throw it out because I was thinking about this
Yeah.
morning.
Yeah.
In reading about the pardons, and I know they're somewhat limited in what they do.
Well, I think a pardon is, it vitiates, I believe it vitiates the conviction. It doesn't change history, but it vitiates the conviction. Just like the SJC vacating a conviction, it vitiates the conviction.
Well, that's different. The SJC can overturn a conviction and send it back or do what they want with it.
Yeah.
But a pardon does something different. And I know it does not get rid of the record. that will always be on his record, the convictions that he suffered.
It'll say, I think, just like the record that you were describing, Councilor
With the pardon,
Giovanville,
right.
conviction pardoned. That's what it will say.
Right.
I agree.
And that record would be available if you were to apply for a job somewhere and the employer wanted to see his record, that record would be there, showing the charges, the conviction, and the pardon.
So why not give him a pardon?
Well, that's not a bad point either, but I think, I've heard so many people and calling me saying, from both sides here. On the side against it is, they're wiping out the conviction. It's like it never happened. It's like he was never prosecuted, like he never did the time in jail. And I try to tell people that's not the case. He's not wiping off the record. You're not wiping out that he did, 17, 18 years in jail.
18.
And you're not wiping out that he did probation up to this point in time.
18 years of parole. His life was ruined for 40 years, as was the life of his wife, his children.
No, I get your point
None of that disappears. I agree.
Yeah,
That
I
happened.
get your point on it. Was he convicted? You said there were 9 children?
I believe that there were 9 children who testified at one trial or the other or both. There were.
If you know the answer, if not, maybe Attorney Hardoon would know it. Were there any cases where he was charged with 2 counts on the same child or 3 counts?
I'm sure there were, but I have not looked at those papers in a very long time, Counselor. I can't.
And how many convictions for rape did he have, if you remember?
I forget the exact number.
Was it 8?
I think that's right. I think that was for, I mean, there were 8 children who testified at his trial. I don't know whether that was 1 count per child. I have not focused on that, so I can't answer that.
Okay. Well, one thing I've learned doing criminal work all my life is I have never been at the scene of the crime that my client has been charged with.
Me neither.
And I don't think any prosecutor or police officer, well, maybe a police officer now and then, but not a prosecutor has never been at the scene of a crime. Maybe there's some exceptions to that, but so all we get is what our clients tell us. And then we get reports and so forth and investigative stuff like that. And I'm sure you'll agree with me, there are times you get, the client says you didn't do it, you get the reports, you can read, you can figure out, and you say to yourself, man, that's the tough road to go here.
Counselor, I never rely, I've been doing this work for a long time too. I never rely on what my clients tell me. I want to see the evidence.
Well, I
look
don't,
at the evidence.
I
That's
don't
what I look
either,
at.
but I don't have to make my client confess to me. I'm not
No,
a confessor.
I look at the evidence. That's what I care about. And that's what I care about. And in this case,
So-
and that's what we're focused on, is the unreliable evidence.
So when lawyers and prosecutors aren't at the scene, you're relying on what you get from others and from police and
Witnesses, statements, discovery, scientific evidence, physical corroboration, or lack thereof. Yes, sir.
Okay, so we can go back and forth on this issue about did they do it or they didn't do it from now until your client's dead.
That's not what I'm here for. Right.
Okay. And we're probably not going to change anybody's mind on which side they're at.
Correct.
I look at pardons differently. I look at pardons, almost all pardons we do, the person has been found guilty, right?
Yes, sir.
So whether they're guilty or not, who knows? But they're found guilty. So that's a given in the case. I don't have to hear all this evidence that's coming in about what happened and who did what. And I've read every document sent to me by Mr. Hardoon and by you and Judge Bornstein, who I think is a great jurist and always was. But my feeling is different. I believe that a pardon should be given on what he did before this case. Did he have any record before this case?
No, he didn't.
What he did in the prison, how he behaved and what he did.
He had a good record in prison, although he was constantly being victimized. That's why he was paroled. They wouldn't have paroled him if he didn't have a good record in prison.
well, you know, I've been in, like you, I've been in hundreds of prisons in my life, and there's no way I'd want to be in there one day with charges like this.
Me neither.
However, he's been on parole now for 18 years.
Yes, sir.
Has he had any violations of parole?
I believe there was one violation a few years ago. That's 1 in 18 years. It was, and that was it. And he's got very strict conditions of parole, so.
Yeah, I read those. And if we do vote to grant him the pardon, basically he gets off probation a year early.
Gets off parole a year early. Yes, sir.
Parole a year early, and he'd be off the sex registry.
I
if
believe
you're
he would.
correct.
I believe, but
But
I have not
if we
reached,
give it and he doesn't, well,
that's his
too
problem.
bad.
Right.
But let's assume it happens. I guess I come from the view that how much is enough? How much punishment does somebody have to endure before we say he's paid his debt to society? Every case is different, I guess. But I think pardons, I like pardons. I think they're a good mechanism for a lot of inmates if they meet certain criteria. The issue with the pardons in this case, in my reading of the Constitution, the governor can issue a recommendation to us for a pardon without ever talking to the parole board.
I think that's correct, sir.
But you can wrap up.
So okay, Terry. So in any event, I thank you for your testimony and answer my questions. Thanks, sir.
Counselor Devaney.
Thank you. I first want to make a public statement that this is the first time in the second longest with my colleague, Councilor Ianella. And this is not a hearing. We don't have the we don't have the principals here for the hearing. This is not a hearing. We have a hearing and the people that are, you couldn't hear me at all? Okay. This is not a hearing, okay? Because when we have a hearing, and Councilor Ianella knows because we're the longest serving, we have the principals here. One member does not have the authority to say they're not allowed. I didn't know until I sat here that they weren't coming. And I want that on the record. It's wrong. This is not a hearing. Okay, having said that, I want to ask you, how long have you been representing the Amirals?
I would say about 30 years.
You were not at the court 1986 when this first came up, this case.
I was not involved in the trials.
Okay.
No, Counselor.
Well, we have an attorney, Hardoon, that has been there all these years, since 86. I want to tell you, very hard for me to hear all of this. And I want to dismiss the fantasy stories about birds being killed and everything. I'm listening to those 9 children. I'm listening to reality. My friend's child was at that daycare, and she was sexually abused. And it's so hard for me to sit here and say, hey, enough time. What's enough time for a child to be sexually abused? Some of them are drug addicted. And you know what's sad? There's 10 of those mothers that have died that fought for justice. They fought for justice, and they didn't get it, okay? Now, these people can't come here. I don't want my friend coming here to expose her daughter, who is 41 years old now. Enough. They're punished enough all their lives. These girls have trouble having relationships with people, breaking engagements, and all of this. They don't have any pardon. And the parole board was right. They had all this evidence, and they didn't need to have another hearing. Enough's enough. Now, let me tell you about this little girl, okay? My friend's little girl. And I can't tell you how many mothers I talked to in this last month, all right? I even talked to a victim She was 3.5 and she remembered. Imagine, she remembered. And I didn't say my friend's name. And she says, I know who he is. I met him and his wife, and I know who the girl is. Each of these 9 children, they weren't under any investigation. They came home innocently. One of them told their mother, and that one child that told the mother set this all up. And the mother called the police. And that's how it started. My friend's little girl liked to go to daycare, and she wasn't the only one that liked to go there. And she, like other children, started crying and screaming and didn't want to go. I talked to these mothers. I talked to my friend. They are filled with guilt that they forced them to go to this daycare, okay? Now, you've got documentation from people who worked there, and they said they never saw it. You know why they never saw it? Because they took certain children and kept them in the daycare where others went on trips, or they went outside, or they went on field trips. So they didn't know. So they gave you honest testimony because they never saw it. And about you said that there wasn't any pictures. Do you know why there wasn't any pictures? Because the police did not go into daycare and get them. And it was after 3 weeks or 4 weeks, and there wasn't any. They destroyed them. And those children each told their parents. There were pictures which Cheryl took them and all of this without the clothes on, doing different acts. And some of them are very graphic, and it's very hard for me to talk about. But these children talked about the elephant on Tuki's lap, and they licked ice cream off it. There was a 4.5-year-old boy, and that little boy told his mother about what Tuki had done. And, I have 4 children, and when you bathe children, you don't look in their rectum or their vagina. I'm being graphic, okay? This little boy had pencil shavings and everything up his rectum, okay? This little boy told his mother, but Tuki told him, if you tell your mother and father, I'm going to kill both of them. 4 months later, his father was killed in a motorcycle accident. That little boy was filled with guilt. He told, and Tuki killed my dad, and he's going to kill my mother. You don't make up these stories. This little girl, my friend's little girl, she would come home with her panties inside out, someone else's panties, blood in her pants. And when she went to the doctor said that it was some knife or fork, something up her vagina. Now, there was another mother who testified that when she bathed her daughter, it was all red around her vagina. I'm talking about reality. I'm not talking about children make up things and the parents told them these vile things. No way. And police didn't come in uniform and question them. They came in later and they were in plain clothes, and they treated them kindly with dolls, with everything they could. One little girl came home, and she said, I want to show you what Tuki and Cheryl have me do. She went in the closet in her home, and she came out without any clothes on, and she went into all these seductive postures. And an uncle overheard his nephew talking to another cousin about what Tuki does and what Tuki has me do. And he taught me how to kiss with my tongue. This is not a pardon. This person doesn't deserve a pardon. I read his letter to Governor Baker. I can't wear shorts. I feel bad for him. There are people that are drug addicted. There are people that he ruined their lives forever, and he can't wear shorts because he's an ankle bracelet, okay? He can travel, but he has to go through certain things. He has to tell them that he's going someplace or whatever. He doesn't have such a terrible life, but those people live with it. And those poor 10 mothers died not finding justice. This man doesn't, and Cheryl, no. And when they took the pictures, they had them nude, they had them in different sexual actions. And every one of those children, when they were interviewed separately, they all talked about the camera with the red button. Okay? Can't make that stuff up. And they all said it. And there wasn't any pictures, and they're not digital in those days because, and they destroyed them. So by the time the police came, there wasn't any evidence. So you tell me there's no pictures, okay? But you haven't, and you know what? Judge Bordenstein, I really admire him, but he wasn't even there. He doesn't know. Was he there? And to accuse these people of making these children say these things? 9 children. And they were even taken out when they were napping. When they were napping, these selective children were taken out maybe 2 hours. So, no, I could go on. Some of the cases are really so vile to even talk about, and I find it very hard to talk so graphic. But these parents will never get over it. I talked to a victim. She was 3.5, and she remembers. And you know what she said to me? And this scared me, and maybe I shouldn't even say it publicly. She said, if Tukey could get me, I think he'd kill me for what I'm saying. These women were brave to talk to me. If they talked to any counsels, I don't know. I read the reams of material you gave me. None of them are substantiated. You had a what do you call, lie detector for him. That's not permissible, and you didn't even show it. Yet, when they went to court, they said they were going to have a lie detector for Tukey, and then they didn't. I stand by the parole board. God bless every one of them for voting no. And you know what? Counselor Ianella were the only ones here when it came up before Governor Swift. And we were going to vote for a commutation. And you know how it works. If the governor says yes, it goes to the council. If she says no, she said no, and that was it. I was ready. I was ready to vote no. I've probably been the only one of those days. But you know what about today? The governor didn't even tell the people affected. In fact, all of those parents, not one of them know. This was a backdoor process, this whole thing, and I resent it. And I'm not going to be voted miscongeniality, that's for sure. But I'm going to tell you, I'm with the people, I'm with those children, I'm with those mothers. And when we hear from Attorney Hadoon, those are the facts. He gave me material, all factual, what the children said, courts, all documented. Yours was all hearsay. Bornstein wasn't even there. You weren't there. You just started recently. He's there from the beginning. And I just, this hurts me so much to bring this up because I know I talked to my friend the other day, and, you know, they have no evidence to bring. I mean, they went to the hospital, but those records, you know, 37 years ago, whatever it was. But, you know, these young girls have had a hard time getting on with their lives. You know, to have 4-year-olds lose their virginity by some pig. I've said enough, and I've really said off the record, but I'm very upset. And I listened to all of this. And with the help of God, he won't get a pardon. And I plead with this council, do not give him a pardon.
Most of my questions have been answered, but I have a few. You know, as I sit here, you know, we had a commutation hearing this morning. That person who sat in that chair there has been in prison for 50 years. He was so remorseful. He was so remorseful. He was so forgiving. And he said, just give me a chance and I'll prove you all right. Just give me a chance. This is a totally different hearing. Totally different hearing. I listen to you and you say, oh, alleged victims. No, they weren't alleged. They are victims. They weren't alleged victims. They were, the Amiraults were found guilty. They were found guilty. How many trials were there? 2?
Yes, sir.
In the Superior Court.
Correct.
And how many cases were appealed to the Massachusetts Supreme Judicial Court?
They each appealed, and when there were 2 new trials granted, the Commonwealth appealed, and And there were further appeals to the Supreme Judicial.
So there were 6 appeals to the Supreme Judicial Court. And there's how many members on the SJC?
7.
7. Granted, they weren't all the same, but there was a lot of different members, justices of the SJC. And a majority of the SJC said, guess what? We're not overturning these convictions. So when you say alleged victims, that's troubling to me, and I'm sure it's troubling to the family here. They're not alleged victims, they are victims. And when you say, oh, he didn't want a commutation, that's a crumb. Are you kidding me? A crumb? And when you say, oh, you know, I can't believe he didn't have the parole board didn't give him a pardon hearing. Why the hell should they have given him a pardon hearing? I'd like to hear that from you.
Because he presented a compelling case, and as did his sister, and they deserved a hearing.
Okay, do you know how many pardon requests we had this year? The parole board, do you know how many pardon requests we had this year?
I don't.
Take a guess.
How many people filed pardon requests?
Yes. Yes.
I don't know, 100, 200?
Over 300.
Okay,
And you know what? Do you know how many they approved, the parole board?
don't know.
Guess what? Less than 15%. 15%, 85% of people. And you know what? Those 85%, they all think their case is legitimate. They all think their pardon is warranted. But the parole board said no. I mean, to give the impression here that your guy, these automatically deserved at least a pardon hearing, I disagree.
Not automatically, no.
I
not
have,
automatically.
you kept saying compelling, there's a lot of compelling cases. I go with the parole board. The advisory board of pardons, they do a fantastic job. I have the utmost confidence in them, and if they say he shouldn't have, the Amirault shouldn't have had a pardon, then I'm with them. Here's the other thing, the process. Governor Baker, I have a great deal of respect for Governor Baker and Lieutenant Governor Polito. They've been in office almost 8 years. Why the 9th inning with 2 outs and a 2-strike count did they ever put this pardon request on the governor's council? What, have the facts changed?
No, the fact has not changed. We filed in February. The board refused to hold a hearing and made a recommendation in August and September, and it was on Governor Baker's plate, and he made a recommendation. I don't see what's irregular about any of
Oh,
that.
you don't? I've been here a number of years, and you know how many pardons we've had without going to the advisory boards of pardons? I can't recall one.
No.
And you think, oh, it's not unusual. It's real
I
unusual.
didn't say that wasn't unusual. I don't think there's anything unusual about our filing in February, the board sitting on it for 6 months, deciding not to give them a hearing, and the governor, after a 3-month investigation, decided that the board was mistaken and that these people should receive a pardon.
Mistaken. Could the governor have been mistaken? Why, you always say the board. Could the governor have been mistaken?
Of course, but he has the power to make that recommendation, and he did.
And the advisory board of pardons has their power to either deny a request for a hearing or not.
Absolutely, but under the Constitution, it's the governor's decision, subject to the advice and consent of
Totally
this body.
agree. And the governor could have granted this pardon 2, 3, 4, 6 years ago, right? Could have taken it.
It wasn't filed 2, 4, 6 years ago. It was filed in February of 2022.
Okay, okay. This case has been going along for a long time. Help me out. What facts have changed? That's what I'm trying to get at that. I mean, you say you don't want to relitigate it, but you're talking about the coaching, that there's, what facts have changed since their conviction? We hear a lot, just so you know, I chaired a commutation hearing 25 years ago. Joe Salvati and 3 other, the facts changed. The facts changed. What facts have changed in this case?
Well, in this case, it wasn't the underlying facts that changed. It was the science that changed. Because we were in the dark ages back in the 1980s of how to properly question young children in a non-suggestive, non-coercive fashion. And since then, a tremendous amount of scientific research was done. So now we've learned how to do it wrong, which is what happened in this case, and how to do it right, which is the way it would be done today. So that's what's changed.
Well, the SJC didn't agree with you. The SJC didn't overturn these convictions. They said the facts haven't changed. Yes, maybe, with the pediatric nurse and with the videotape them. Yeah, and I even agree with you. I'll give you that. I wouldn't have done it that way, but that wasn't the overriding issue. I mean, the facts of this case have not changed.
Of course not.
Okay. And the other thing is, how did this all come about? Who went to the police? How did that happen right from the start? Just help me out so I can better understand. It's not like these people went with the pediatric nurse in this room, videotaped it. I get that, but that's not what happened. What initially happened?
As I think I explained earlier, one child whose mother was concerned about his, he kept asking him over a period of months, what's wrong, what's wrong, what's wrong? Her brother had been sexually molested as a child, and she was concerned about her child because of that. And she and her brother both questioned the child about the possibility of molestation. The child made some allegation. Again, my understanding is that this was a child who soiled his pants at school, and Gerald changed him and cleaned him up. He alleged sexual abuse. That was reported to the police. The police brought charges against Gerald, closed down the school on September 4th, 1984. And 8 days later, they held a meeting of all the parents to talk about, go home and investigate whether or not your child may have been sexually abused. That's my understanding of how it started.
Were there any investigative interviews?
Yeah, there were.
Okay, and were there different teams?
Yes.
Okay, well,
Yes.
how many different teams were there?
As I recall, each child had a different team assigned, although some of them included the same individuals. The patterns of these, some of them had therapists. They were questioned over and over again in therapy. All of that is addressed in detail in Judge Bornstein's decision, child by child.
Okay, so my understanding is I think there were 4 investigative teams, 4 different teams who would investigate.
I don't know the answer to that question.
That's my understanding.
Okay.
And the reason why it's important, because you rely on the videotaping, the pediatric nurse, you mentioned that a few times. It was suggestive, it was bullying. But my understanding is there were investigative teams, 3 or 4, and they'd bring one child in, another totally different team, and they all basically told the same story.
Well, they all told different stories, but unfortunately, the law enforcement chose not to record those interviews. So the only interviews we have on tape that were preserved were the ones at the very end. So we don't have a recorded record of those earlier interviews, although we have a lot of information about the patterns because we have reports from therapists and investigators who said child A didn't disclose anything today. Investigation will continue. Didn't disclose today, didn't disclose today. And then on the 7th occasion, the child makes a disclosure. That's all laid out in the notes of these investigators.
That's not my understanding. We'll ask Attorney Hardoon about that. I understand about the videotaping. That's not.
I'm not talking about the videotaping and
I understand. I understand what you're.
Well, I would suggest that you look at Judge Bornstein's decision and Dr. Bruck's very detailed affidavit, which describes the pattern of used to question each of these children.
Yeah, no, I get it. I get it. What about, hold on one second here. These kids, did they ever, and I don't know this, I think I read it somewhere, but I'm not sure. During the course of the trial, did the kids and the defense and prosecutors or whoever, the judge, did they ever go back to the Fells Acre, what do you call it, the daycare center?
I believe at least one of the trials, a view was taken. Yes, sir.
And how many kids went back there?
I don't have the answer to that. I'm sorry.
Okay, to me, it's real important. And when they went back there, what did they go for? What did they look for?
I don't recall seeing a transcript of the view. Maybe there exists one. I wasn't present at the trial, so I can't tell you about the view, but I believe one was taken.
Okay, and you don't know What rooms, what area, you don't know anything.
I believe they went to different rooms within,
Okay.
on the different floors.
So if I told you that the kids went with, you know, the defense attorneys, the judge, whoever else, and when they got to the daycare center, and they all didn't go together, and they were asked, let me see the secret room or the magic room. Would it surprise you if I told you, guess what? These kids, as you call them alleged, I call them victims, went upstairs in a locked room, lock, okay? And says, that's the secret room, that's the magic room. Would that change why you're here today?
It wouldn't surprise me at all, because by the time that happened, years had gone by where these kids had been questioned over and over again, and it was implanted in their heads that this had happened. And so, of course, there's whatever they say is going to be consistent with those suggestions that have been made to them. So no, it would have surprised me if they did the opposite at that point.
Okay, so if the kids, and how old were the oldest and the youngest kids at this time of the viewing?
By the time of the viewing, there were some who were probably as old as 7. I don't remember.
Okay, old as 7, as young as what? 3?
4, maybe.
Okay, and you tell these kids, you folks have kids, okay, Johnny, Mary, show me where the secret room is. What? What are you talking about? Oh, no. They walked up the stairs. Oh, really? I could ask you, can you tell me where so-and-so room? You couldn't find it here. So they walk up the stairs. There's the room. There's this small room, and there's a lock. And they're all lying.
If I practiced enough, no, they're not lying, sir. If I practiced enough time with somebody, and if I had planted a suggestion through coercive, repetitive questioning on a young child enough times, it would surprise me if they didn't do exactly what they had been
Okay, so
trained to do.
do you think before they went on this occasion that they had dry runs with the law enforcement? It says, okay, when they come here, here's the room. Don't forget, let's practice again. You're not suggesting that, are
I'm
you?
suggesting that, as they do in every case, the prosecution would have met with their witnesses and prepared their witnesses for trial. So I don't know exactly what happened during those sessions, but if they didn't do that, I would be shocked based on my 40 years of experience as a criminal defense lawyer.
And let me ask this. What restrictions do the Amiraults, well, we'll just go Gerald with team. What restrictions does he now have, now being on parole?
There's a whole list of sex
See if
offender.
I have them right. I have a few of them.
Okay.
On Halloween, he can't open the door. I think he can't use the internet. He can't go to playgrounds. He can't, what else do I have here? Can't leave the state without approval, periodic drug testing. And if we pardon him, that's all wiped out, correct?
Those are some of the conditions. He can't have any contact with children under 18, although the board made an exception for his own grandchildren. So there are many other restrictions that apply to him.
Got it.
That's correct. And those restrictions are going to go away in a year anyway, because he's going to be off parole. Because his sentence was 40 years, and he will have done his 40 years.
Yeah, well,
Yeah.
that's what everyone, all these judges and parole people, that's what they said was fair. Okay,
Wow.
that's what they said was fair, because they could have overturned the conviction. And if we pardon him, he's no longer on the sex registry, correct?
I believe he would no longer be
And I
required to
believe you are
register.
correct.
I'm sorry?
I believe you are correct. If we do not pardon him, then he would be on the sex registry for life, correct?
I believe he would,
And
yes.
he would be a level 3,
That's what he is now. They could
and
change,
that's the highest level.
they could change the level, but that's his level.
That's my next question.
Yeah.
If they felt like you did, I mean, you feel like this guy should have been out years ago. If they feel like you, they can reduce his level from level 3 to level 2 or to level 1. Is that correct?
I think based on what he's been convicted of, I think there are restrictions on what they can do to change his situation.
No, you're right. You're correct on that. So if he's denied a pardon and the governor's office contacted you, hey, listen, sorry, disappointed, we did the best we could. I'm willing to put in a commutation. I can do it next week. We only have 3 weeks left. And I know it's only going to be a year because all these restrictions end in a year. What would you recommend to the Amiraults if that occurred?
Well, I can't recommend anything to Cheryl because she can't get a commutation.
Okay,
So we're talking about Gerald.
yeah.
It would be his decision.
No, I understand. What would you recommend as his attorney?
I would recommend that he do whatever he wants to do. And I would tell
But
him,
he says to you guys, just James, you gotta help me out. You're the lawyer. You're one of the best lawyers in the state.
Do
Come
whatever
on,
you
what
want
do
to.
you think? No recommendation?
I would recommend that if this body fails to grant the pardon that the governor has already approved, that, well, I'll tell you what I think he will do, okay? I have to speak to him, so forget my advice, but I believe he would remain on parole and wait for his sentence to end, and that's what he would choose to do, rather than come hat in hand and ask the parole board, which already turned him down for the pardon he requested and turned his sister down, rather than come and beg them for a commutation. I believe Gerald would say, thanks, but no thanks. I will finish my term of parole, and that's what I believe he would do. You know, he's a man of high principle. He's always taken the same position in this case for 38 years since he was accused, and I don't think that's going to change now.
To me, he may be high principled, as you say, to me, he's really arrogant. I consider that really, really arrogant.
I disagree, Counsel.
You can disagree.
I think that's.
We can both be
I think it's a matter of self-respect. It's not a matter of arrogance.
You believe that the Amiralts didn't commit this crime, am I right?
Do I believe it?
Yeah,
I think my belief is irrelevant because as you.
I'm curious.
Yeah, I believe they didn't do any of these things.
Okay.
I've known them for 30 years, and I believe that none of these allegations are true. That's my personal belief, but as you said, or as Counselor Devaney said, I wasn't there, so I'm not omniscient. I don't know.
I wasn't there either, but when I hear from several, to be specific, 6 SJC opinions, the 2 trial judges, the parole board, a lot of people who
Well, that's
disagree with, excuse me.
Sure.
There's a lot of people who disagree with you. And I don't have any more questions, but I do want to say it took a lot of courage. And I don't know how many of you are here. Parents, victims. I don't know how many of you are here today, but it did take courage. And I can assure you one thing, you can count on me to stand up for you.
Counselor Bell?
Thank you, Mr. Chair. First of all, I want to thank both of the attorneys. You provided me with reams of information, each of you, every single thing I asked for, including from both court cases, including child testimony. I actually was able to find snippets of the actual children's tapes. If you dig hard enough, you can find things. So I want to be clear, we are not here today to retry this case, which seems to be happening right now.
Can I just say something about
Sure.
that before you go on? That's exactly what's happening right now. The reason that's happening was because of the opening statement that you gave, okay? I was extremely disappointed in it because we talked about not retrying the case on the phone several times. The reason you got so many questions about retrying the case was because you opened that door with your opening statement. What you didn't say was the things about what Cheryl and Gerald Amirault are doing with their life today, which is what we should be looking at.
Right.
Okay?
My witness.
I think you missed your mark. And we had conversations prior to this hearing that we're not going to retry this case. And I've been sitting here listening to it. It's exactly what's happening. And that's on you because of the opening statement you gave. You retried the case. You started retrying the case in your opening statement. We talked about it. You said you weren't going to do it, and you did it. And now you're getting questioned on it in a way that the case is getting retried. The Amiralts sit here convicted of these crimes. The issue is, do we apply the standards that we use for pardons to see if they are deserving of one today? Thank you. I'm sorry to interrupt.
No, that's fine, Mr. Chair. Full disclosure, and I've talked to a lot of people, I didn't live here when this happened. I was a citizen of Massachusetts, but I didn't live in the state. So this is all new to me. I'd heard inklings about it in the past, but I am looking at this through completely objective, clear lens on both sides of it. It's a very, very serious accusation that, you know, has been litigated and relitigated and relitigated. Here's the problem I'm having. You said the governor did a rigorous deep dive, I'm paraphrasing, into this and decided it was robust enough to hand to us for a pardon. He didn't give us anything. Zip, zero, nothing. And for a case like this, I'm shocked. Every bit of due diligence that any of these councils have done, we've done it on our own with assistance from each of you and on our own. I've been talking to experts from outside of the state who know nothing about this case. So I'm getting objective, clear opinions. I don't know people who were molested. I think that would make me, I think I'd have to recuse myself, frankly, if I did. I think, I also think, to be really honest, and I have read these guidelines over and over and over, Gerald is not eligible for a pardon. He was eligible for a commutation, and that is what he was offered. Now, I completely understand why he may choose not to do that, because he's timing out. I get it. But we're being asked to judge something that the rule doesn't even apply. The second part of that is, for Ms. Cheryl, the parole board, who was handpicked by this governor, I went back to see who was on it. These are individuals who were handpicked by him, denied her a hearing, 5-1. And the reason I was told was because she doesn't meet the standard of a pardon. Now, I think personally, and this is my own conjecture, and I can be completely wrong, I think the reason they judged that, not us, is because there is no admission of guilt. Now, if your client doesn't feel they're guilty and they really believe they're not guilty, they're not going to plead guilty, right? And nor would anyone advise them to.
Nor should they.
Nor should they, in just in a fair world. However, that puts this council in a situation where we can't give a remedy. We can't. Your clients fall into a limbo that there is no judicial remedy for, at least at this time, from my perspective. And I find it troubling that Governor Baker put us in this position. I really honestly do. If he was so, and I spoke to him about it, if he was so passionate, why didn't he give us some evidence, some compelling discussion from him and from his legal staff? We've got nothing from them. And so you have to understand the position that we're put in. Now, Governor Baker, apparently, people are telling me, made some deathbed promise to some person. I don't know. I don't pay attention to those folks. But so he's upheld his part of the deal. He made a promise, and he's met his promise. But look at us. We didn't make any promise, and we're being asked to make a judgment on rules that frankly don't even apply. And so I am here to sit here completely through the rest of whoever speaks on both sides and any witnesses, and you're going to have to convince me, honestly, that these rules even apply to this case, because I honestly don't think they do. And I have been reading and reading and digging and digging and digging for days. And I've read those clemency things over and over and over. I think we've been put almost in this council in a double jeopardy where we can't make a judgment on something. We don't have what we need to do it. And it is tragic for all parties involved, frankly. And I know what you're going to read from the clemency. Okay.
You want me to speak, or I don't want to speak?
No. That's all I have to say. I'm just going to sit here and listen to the rest of you. But I have to say, the two things that have disturbed me is this has become a retrial, and that is not what a pardon hearing is about. And it doesn't matter whether the people accused or convicted of the crime are here or not. That is not part of a hearing. That might have been how it was done in 1852, but we're not in 1852. We're today. Okay? And it's also, the chairman gets to make the rules. That's how it goes. And he's made good rules, and he's a good chair. I'm just saying that by the governor's own rules, this doesn't even apply. And one of the reasons why the Board of Pardons is so critical for us is because on that board are 2 forensic psychologists, and we depend greatly and deeply on their expertise. We are not experts in that stuff. We're not. And it makes it hard for either side, wherever you stand on this issue. It makes it really difficult because we aren't those experts. That's all. Thank you, Mr. Chair, for your time.
Councilor DiPaolo asked for another minute.
Thank you very much, Mr. Chair. Like, like Councilor Duff, I appreciate the efforts you've made to make this hearing run smoothly, very much so. And I completely agree that we're not supposed to be relitigating. And I did, in my previous line of questions, respond to the opening statement. But with due respect, it was the governor who opened this up, because in the one paragraph I received from the governor's office, the governor stated, "I'm left with grave doubt regarding the evidentiary strength of these convictions." The governor is looking to relitigate. We don't want to. Good point. I'm trying to get into the governor's head because he's giving me one paragraph. So I need to get in the governor's head. So I look at his clemency guidelines. It's the one thing I didn't bring up earlier. We had a gentleman this morning seeking a commutation, a convicted murderer, who not only, forget about guilt or innocence, he had an amazing record of community service, mentorship, all sorts of restorative justice. Now, in the governor's, because all I have is one paragraph, I look to the governor's own clemency guidelines, where it stated that pardons are mainly intended to remove the barriers sometimes associated with a criminal record. Parole ends in 1 year, so I know that. I understand sex offender registry holds up, but there's factors to consider in the governor's clemency guidelines. Acceptance of responsibility. We know that's not relevant in this case. Pending appeals and other litigation. The governor writes, generally a petitioner's pending appeal of a conviction to a conviction or sentence through litigation is inconsistent with acceptance of responsibility. So again, restitution and restorative justice. The governor will rarely grant clemency to a petitioner who has not made full restitution to the victims of the petitioner's crimes. The governor will give stronger consideration to petitioners who have made restitution. A petitioner's participation in restorative justice will be a consideration. Is there any restorative justice or service along those lines that either petitioner has participated in, to your knowledge?
Well, they are prohibited from having any contact with the children or their families in this case, so nothing like that has taken place.
So, and then substantial assistance to law enforcement. I don't know that that's relevant here, right? No cooperation.
Are you reading from the February 21, 2020 guidelines?
I apologize. I am reading from, yes, February 21, 2020, the executive clemency guidelines. I'm on page 2.
Okay, thanks.
4.2.3.
Right. No, there's.
And then military, public, or charitable service. Anything I should know about that?
Well, Cheryl has done a tremendous amount of community service. When she worked for John Hancock for many years. And
Okay.
she volunteered at the Boston Marathon every year. She's also done other charitable works. Gerald has done work in the community, helping people with painting and.
I saw in your shoveling the sidewalk.
And his wife, Gerald's wife, Patty, who is here to testify, will talk some more about their good works.
Sure. He snowblows, shovels, rakes leaves, paints, and fixes things.
That's
He's a
correct.
kind neighbor and friend who would do anything for someone in need.
That's correct.
Okay. And we've talked about compelling need. I'd like to hear more about employment, but I will stop that. I appreciate you indulging me, Mr. Chair.
A couple of points. You just mentioned a couple of things that Cheryl's done. That should have been your whole presentation. That should be what you're presenting to us, is what Gerald has done and what Cheryl has done since they've been out of prison. That's what a pardon hearing's about. And until Councilor DiPaolo asked you a couple of questions, we heard nothing about it from you. Nothing.
You missed your
Well,
mark.
Councilor Kennedy, if my opening was inappropriate, I apologize.
It was
I read
completely.
Mr. Hardoon's opening statement, which is all
Well,
about,
well,
all about
no,
the
excuse
case.
me.
And I felt,
Excuse me,
sorry,
okay? You're not here to respond to
okay,
Attorney Hardoon's statement.
okay.
You're here to advocate for a pardon for your clients. And what I want to hear is, what have they done that's good since they got out of prison? And that's what your presentation should have been about. Attorney Hardoon is here in giving that statement, and I talked to him on the phone about that, because he actually used the words, a witch hunt when I talked to him, that's what was going to be presented. That's why he's here. Nobody comes before this council for a pardon unless they are guilty. The Constitution says that. And that all judicial process has to go through. It's unlike the federal system where they can pardon somebody up front. So they sit here guilty, period. You should be talking about, and your witnesses should be talking about, what they've done since they've got out of prison that they deserve the benefit of a pardon. I've heard nothing. And we are retrying this case, which I didn't want to do. I said it to you 100 times, and I said it to Attorney Hardoon. I've been speaking to both of you on the phone.
I don't want,
And that's exactly what you did.
Well, I don't- I'm sorry.
Let me finish. You caused that with your opening remarks. You caused all those questions that did not, in my opinion, benefit meet your burden. It didn't help you meet your burden for what we're looking for, or at least what I'm looking for. I'm just saying that. We can move on to your next witness at this point, and I hope she can tell us some of the things
can I
that.
say that a lot of the material that you're referring to, and again, I apologize if I didn't focus on that in my opening, it's in the written materials, the petitions that we filed, both Cheryl and Gerald's good works over the past 20 years are summarized in there, along with the letters that we
I didn't
submitted as
think
exhibits.
about that. It's very clear, I think, that everybody's done their homework here.
Well,
Everybody's really looked into everything, okay? Every single member of this council. Why didn't you talk about that?
Well, if that was my mistake, it was on me. I felt it was impossible to separate that from the underlying convictions. So if that's a mistake, I apologize. It's my
Not only
mistake.
do I completely disagree with you,
Okay.
I told you that. We talked about it.
Well, I apologize.
All right, I'm going to call Patty Amirault at this time. We're going to go till 3:15. We'll take a 10-minute break. Huh?
No.
No,
No.
we'll go till 3:15, then we'll take a 10-minute break. Okay?
Hopefully get two of you. Good job. Hopefully get two of them. Jeez,
No.
You're right on that.
Yeah, it's always just, if you could just state your name, please. I know that I said it.
Yes, my name's Patty Amirault.
Bring the microphone.
Very close to you. I've been getting complaints that people aren't hearing it on YouTube. That they're not missing me on YouTube or Council Iannella because we're pretty loud. But if you could speak up, you have to hit the button to the green light's on.
It's on.
Okay, very good.
Okay, good afternoon, everybody, and thank you for this opportunity to speak on behalf of my husband, Jerry, and my sister-in-law, Cheryl. Though after what I've heard, I'm not sure some of you will be open to what I have to say. I am a former Fells Acres kindergarten teacher, as well as a public school teacher for 35 years. I currently work for the Malden Public Schools as a family coordinator. I am my husband's and sister-in-law's voice today, and with me are family members and others who have supported us since this all began in 1984. There are so many people that have reached out to us since Governor Baker's announcement, offering support and expressing their relief that finally someone is willing to acknowledge the terrible miscarriage of justice that took place. My husband and I have known each other since we were students at the Immaculate Conception School in Malden, where we spent from 1st to the 8th grade in the same classroom. Together as a couple since high school, we've been married for 45 years. We have 3 children who have blessed us with 7 grandchildren who all live close by. We are also part of a very large, close-knit family. We have lived in the same house, in the same neighborhood in Malden since we were 23 years old, where neighbors have embraced and supported us throughout our ordeal. We are truly blessed. Yet, the weight of this and the convictions looms large in our life still. Before all of this happened, we had settled into a comfortable family life with promising careers. Jerry and I had been married for 7 years. We had 2 daughters, ages 4 and 5, and we were anxiously awaiting the birth of our 3rd child, a son, who arrived on September 7th, 1984, just 2 days after his father's arrest. Life was good back then, until in an instant, it changed forever, and in ways that are hard for most people to imagine. It's been a difficult journey for more than half of our lives. It's impossible for me to describe the intense pain our family has endured and the crushing disappointments we have had to come to grips with over the past 38 years. From the first accusation until the present, my husband and sister-in-law have not only maintained their innocence, but have conducted themselves with grace and dignity despite the pain and injustice they've had to endure. It has been so difficult to watch helplessly as they faced false accusations, media hysteria, and were stripped of their reputations. They had to watch their mother's lifelong work destroyed, and they endured lengthy trials with devastating results. My husband served nearly 20 years in prison, being taunted and abused as a child molester. I spent 20 years without my husband, raising our children, supporting our family, all while visiting prisons and fighting for my husband's release. Had it not been for my parents, who were living on a firefighter's salary, helping me pay the bills and maintain a household, I never would have made it. I really wish each of you knew my husband on a personal level, that you had the opportunity to meet with him individually. You should. If you did, you would see that he's an incredibly strong, caring, good to the core kind of guy, a whatever you need kind of dad, a man who loves his family deeply. During his years of incarceration, there were many people, strangers to our family, who wrote us and asked if they could visit Jerry in prison so they could draw their own conclusions about the man the world had vilified, the man they had read about or seen on the television documentaries. He was always happy to meet them. Those visits always ended, without exception, with these strangers becoming good friends and ardent supporters. One of these visitors, a man from Connecticut, put our 3 children through college. One of the jurors in my husband's trial also contacted us many years ago, writing, "If I knew then what I know now, I would not have convicted Mr. Amirault." My husband would never hurt another being, let alone a child. Yet hurting children is what he was convicted of and what he's had to live with for 38 years. It's a terrible burden for an innocent man. The fact that this case has robbed us of years we can never get back is becoming more difficult the older we get. Jerry and I should be living a laid-back, spontaneous life, doing whatever we want to do whenever we want to do it, but that's not what it's like for us. Our life is still controlled by onerous parole restrictions that limit the things we can and can't do, where and when we can travel, what time my husband needs to be home at night. It's so hard to watch him tethered to an outlet several times a day so he can charge the ankle bracelet that he has had to wear and I've had to pay for so many years. A scarlet letter that he hides from the world. This and all that comes with being classified a level 3 sex offender, including having our home on the Massachusetts Sex Offender Registry, and that he's never been able to get employment, has been his life since he was paroled in 2004. Many restrictions will continue when parole finally ends. I have also borne witness to the devastating impact of this case on my sister-in-law, Cheryl. Cheryl was newly married when this case began. Her hopes and dreams of starting a family with her husband, Al, were replaced with 8 years in a prison cell with her mother, Violet. The harassment and the taunting was endless. Sadly, she was emotionally crippled by all she had to endure, and she's never been the same. Violet emerged from prison frail and sick, dying shortly after her release. Cheryl and Al maintained their relationship throughout her incarceration. After her release, she tried to conceive a child, but she had lost her viable years and it was too late. Cheryl's fragile emotional state led to their separation, yet they remained very close until Al's death. Despite the enormous barriers and stigma she faced as a result of her conviction, Cheryl worked hard at finding ways to cope with all she had lost and all she had experienced. After several job rejections, all due to the conviction, she was fortunate enough to be hired by John Hancock, where she established a 20-year career. This opened up opportunities for her to volunteer in the community. She began to rebuild her life. Excuse me. I have known Cheryl since she was 10 years old. We're as close as sisters. I know that even though she was able to reclaim some semblance of her life, she still suffers daily. Despite being an integral part of our family, she's been living a lonely life. It wasn't until she met and entered into a relationship with her partner, Michael, that she was able to begin to be truly happy again. They both recently retired, but as a registered sex offender, she is unable to have a full life with him. The complex restrictions on travel and residency present barriers for their future. So even after all these years, her life is far from normal, although she's technically free. Both Jerry and Cheryl have lost so much, but they still look forward. But they still have a lot to look forward to if you approve the relief Governor Baker found they deserve. It's time to put an end to this ordeal and let this good man, his amazing sister, our children, and our family finally have some peace. I respectfully ask that you vote in favor of these pardons. Thank you.
Council Hurley, do you have any questions? Council Hurley?
No.
Ferrara, any questions? Council Julian?
If you,
Yes.
tell me what.
Because he hasn't been able to have a job, he does anything and everything for anyone who wants something done. Helps with my daughter's children. He helps me take care of our 93-year-old aunt who needs to be shopped for every day, taken to appointments. He maintains our house and helps all the neighbors maintain theirs. He's been very limited in what he can do because of these convictions, you know, and he just does whatever he can to help people. Many times. He's always rejected because, he even tried to do DoorDash and was rejected. Oh, what do you mean going, like when he can? Yeah, he has a curfew at night. So between the hours, I think 11 and 6 in the morning, he's not allowed out of the house. He can't. He would. Now that she's retired, she's working part-time for a company where she works serving at functions. She's very restricted on where she can go. She can only leave the state for a certain number of days. So, you know, no, she never has.
I'm
she
sorry,
has.
but I can't hear the questions. Excuse me.
I didn't have my mic on, Mary. I'm sorry.
That's okay. I just wanted to let you know I couldn't hear the questions.
Has she had employment since she's been out of prison?
She has had several jobs leading up to her 20-year employment at John Hancock, and now works part-time for a serving company.
So she's got 20 years in at John Hancock?
Yes.
And what did she do there?
She was an executive secretary.
She retired from there?
Yes.
How old is she?
She's 64.
And how old is your husband?
68.
And what does a pardon mean to your husband?
It means everything to him. I mean, it's so hard to listen to all the things that I'm hearing here. We've lived this for so long. And we recognize all the victimization of everyone. I mean, those kids at that school were our kids. We raised them. None of us would ever hurt any of them. A pardon would at least restore for him some semblance of a normal life. Like, we are unable to do anything without taking steps, planning months in advance. You know, we have our family cottage that we would like to go to whenever we wanted to go. We can't do that.
Why? Where is it?
New Hampshire. Before this happened, we had always planned to travel to the countries that our families are from, Ireland and Italy.
Tell me, how many children do you have?
I have 3 children.
What are their ages and what are they doing?
My oldest daughter is 42. She's the assistant principal of a high school. My second daughter is 41, and she is an executive with Sun Life. And my son is 38, born right when this started. And he's gone from job to job, recently had open heart surgery, and is not doing anything right now.
Back in time when the daycare was operational, did you work there or go there?
I did. I worked there as a kindergarten teacher, and I was in and out of there all the time. When I was pregnant, my daughters were there, so I had time to myself, and I would come and go whenever I wanted to.
Were you ever interviewed by the police?
Never.
Thank you.
I don't have any questions. Your testimony was compelling.
Thank you, sir.
It was difficult for you to sit there. I'm sure Gerald and Cheryl.
I just want you to know,
Let me finish, one second.
okay.
That's okay. I'm sure they're going to be very proud when you get home, and you did as good a job as you could have.
Can I just say, like, I had to do it all by myself for 20 years alone, okay? I raised kids, I ran to prison. I was parenting at the same time that I was, being a warrior for my husband and his sister and my mother-in-law. Do you think I would have done that if I thought he hurt a child? My whole life has been working with children. I would have been out of there in a second. I know this didn't happen. I was there. I've read everything involved with this case, and I defend his innocence and will forever, and so will he, and so will Cheryl. And my mother-in-law would have as well. God bless her.
That's okay. Testimony.
Thank you.
And nobody disputes the fact that difficult life.
I'm sorry, I can't hear anybody except the witness.
Sorry about that, Mary. I was just telling the witness that I thought her testimony was very compelling. And we thank you for that.
Thank you.
We're gonna take a 10-minute break now.
So, and this one's coming in, so 1, 2, 3. Curran's next, and who's up? Who's Curran? Yeah, right here is John. This guy. You know? Yeah. Who's the guy in the uniform? Oh, my.
Good afternoon. Hi, my name is Andrew Curran. I'm a retired healthcare executive, and I live in South Dennis, Massachusetts. I'm here today to speak on behalf of my lifelong friend, Gerald Amirault. I've known Gerald since I was 12 years old. We both grew up in Malden, went to school together, and celebrated each other's weddings. I grew up with him and his family, who treated me as one of their own. When Gerald was serving his sentence, we stayed in touch regularly through letters and my frequent visits to him in prison. After each visit, I was always amazed at how he was never outwardly bitter or angry. Instead, he projected a positive attitude about his plight and was filled with the hope that one day he would be free. When he was finally released from prison, he confronted still more challenges. He found it extremely difficult to find permanent work to support his family. He was able to paint some homes for family and friends who would pay him a fair share for his work. It was tough to watch. He never complained, nor became discouraged because of the obstacles he faced. He forged on with his head held high. He also went out of his way to return the kindness to those who didn't forget about him while he was away. Many times when I needed help, he would drop whatever he was doing and be there for me. I witnessed the same kindness from him with many other people over the years. Gerald is a kind, considerate man. Gerald has been a model citizen over the 18 years he's been out of prison. He opens doors for people. He's very polite and appreciative of the little things he receives. I took him to a Patriots game a few years back after his release, and we had to leave before the end of the game as the Pats were making a comeback drive and an eventual win. The reason, he could not miss his parole curfew. Gerald has 3 beautiful children who are now adults and shares the love and joy of 7 grandchildren. He spends an enormous amount of time with them as they grow and develop. I think he's making up for the time he missed with his own children, who were young kids when he went away. He's been a wonderful husband to his loving wife, Patty, an active and involved father, and a doting grandpa to his beautiful grandchildren. Gerald harbors no bitterness about what has happened to him. I have never heard him say anything derogatory about any of the people involved in his prosecution. He's an inspiration to me in many ways. He doesn't drink alcohol, nor does he smoke. We often fish and golf together and laugh and reminisce about our early days. Gerald is a person of good character and a gentleman who I'm very proud to claim is my forever friend. I hope to shed some light on the person whose petition for clemency is before you today. Thank you.
Follow, any questions? Council Hurley, any questions?
Counselor Hurley?
Yes. I can't hear.
I asked if you have any questions of this witness.
Are you asking me?
Yes, do you have any questions of this witness?
No, sir. Thank you.
Council Ferrera, any questions? Council Jubenville?
Thank you. Okay, thank you.
I don't have any questions. Thank you very much for coming.
Councilor Duff?
No, thank you.
Thank you. I don't have any questions either. The next person we're going to call is Michael Murphy.
Thank you for this opportunity. I am Michael Murphy, and I've been Cheryl's significant other for the past 7 years. I'm a New Hampshire resident, and I have been a neighbor to Gerald and Patty for 35 years. I was fully aware of the family's ordeal that they had endured. They introduced me to Cheryl 7 years ago, and it was clear that Cheryl and I shared mutual interests, which led to dating. The woman I met was a confident person whose optimism was palpable. She was soft-spoken, a great listener, with passionate drive to contribute to the community. Her strong work ethic, solid moral beliefs, and ability to overcome the difficult times were clearly qualities instilled by her mother, Violet. She is loved by her nieces and nephews and great-nieces and nephews. Cheryl is the aunt they look to for biking, hiking, and kayaking. We have had many conversations about her 8 years in prison and the losses she had endured. Two of her most painful losses are not being available for her nieces and nephews, Gerald, Katie, and PJ, during their formative years, and her dashed hopes of being a mother. It pains me to see Cheryl when she is faced with the label sex offender. These moments can be gut-wrenching. She confronts the stigma of this conviction every time she fills out an application, always having to answer for her conviction, often having to repair the character assassination from 40 years ago. Cheryl retired in 2018, and we looked forward to our future. We planned to live together, spending half our time in New Hampshire and half out west. This came to a halt when we realized that being on the sex offenders registry presented obstacles. Any travel outside of Massachusetts is constrained by the intrusive and humiliating SOAR regulations. Spontaneity is missing from our lives. Even a visit to my house in New Hampshire is a challenge. We hope you will restore our faith in the system and close this chapter of our lives. Now is the time to let the healing begin. I respectfully ask that you support this petition to pardon Cheryl and Jerry. Thank you.
Councilor DePaolo?
Well, some of the things that Cheryl has accomplished over the past, which I was told didn't have to be mentioned, I think should be mentioned. She was, again, a 20-year employee at John Hancock, where she was an executive secretary, and she had great recommendations all along in her career. She volunteered for the marathon for 20 years with the elite runners, and she built houses for the Habitat for Humanity, and she volunteered for Dress for Success, and she volunteered at the Boston Food Bank. So that's how Cheryl is. She's a sweetheart, and she's my love, and she is the nicest person I've ever met in my life. I don't think that she would ever do anything to hurt anybody, and the same with her brother. I played golf with Jerry a fair amount, and he never swears. He never smokes or drinks, or he's just I call him a sweetheart. And he's a big part of my life as well. And I feel proud to be part of the family. And I feel proud to have Cheryl part of my family. Thank you.
Thank you.
Council Ferrara? No questions, thank you.
Councilor Hurley, do you have any questions?
Oh, thank
Councilor Hurley,
you.
any questions? Thank you. Councilor Juvenile?
You retired?
Yes, I am.
What'd you do for a living?
I was in the building material business here in Boston for 40 years for heavy construction.
Whereabouts in New Hampshire do you live?
I live in North Conway.
How long have you known Cheryl?
7 years. We started dating 7 years ago.
Was she still working at John Hancock?
Yes, she was.
Has she been 20 years of working there as an executive secretary?
That's correct.
And retired?
Yes, she did. An early retirement.
What does she do now during the day?
Well, she does do a serving job, a fair amount, which is serving at special events and occasions, which she's done for 20 years as well. Well, maybe not quite 20, but it keeps her busy 2, 3, 4 times a week in some weeks, doing weddings and special functions. And she likes to bike and hike and kayak when we get a chance. And she keeps busy going to the gym on a regular basis and walking.
You indicated that she volunteers for the marathon.
Yes,
What does she do there?
she does the elite runners. So all these elite runners have special drinks that they drink on at different stations. And she's at one of the and you can't get this guy's bottle mixed up with this guy's bottle with this one. So they all have to have their special drinks where they want them. And again, she's been doing this for 20 years. And she's, you have to be, it's an exact, you can't let somebody else drink somebody else's drink. And she's always been in the one spot, I think, over by Beacon Street, where it comes into Ave.
And you said something about, you did something in Boston. I didn't catch the last.
Habitat for Humanity.
Habitat for Humanity?
Right. She's worked on a number of jobs with John Hancock for Habitat.
And is that a volunteer thing?
Yes, it is. Yep.
Thank you very much.
Thank you.
We're not done yet. Councilor Devane?
I don't have a question, but thank you. Your testimony.
Councilor Duff?
No, thank you.
Okay. I just have a comment.
Sure.
That's what we need. to
I
do.
know, and I didn't
And that's what
know
we-
at the
that's
beginning,
what we
or we
haven't
would
here.
have been more,
You know what I,
more prepared for,
I appreciate your testimony.
certainly.
Thank you.
Thank you.
Next, we'll call Katie Hebert. We've changed the witness list up a little bit at the request of the petitioner's attorney. So she wasn't on the original witness list, so she is obviously speaking from her heart. Tell us who you are.
Sure. My name's Katie Hebert. I'm Gerald Amirault's daughter. I'm the middle one. I was about 4.5, 5 years old when this all began. And the reason I felt obligated to come up and speak in front of you is you really have to understand who my aunt and my dad are. And I know, and my heart breaks when I hear you talk about the victims because we know they're victims. We're all victims in this. And this isn't about guilt or innocence. This is about moving on in our lives. We have dealt with this for an eternity. Every day of my life, from the time I was 5 years old, I have been dealing with this. I've had to more recently deal with explaining this to my older children who are getting comments and questions with their friends and their families. All supportive, but still something that we live forever with. This will never go away. And that's what this isn't about. But I want to tell you, I know who my aunt and my father are. My father is the first person I call when I need something. He's there in 5 seconds. He will take my kids anywhere. He will pick them up, drop them off. He saves me every step of the way. My kids look up to him. They think he is like their hero. He is the most caring, loving person I could have ever asked for. My father, when he was in prison, he used to read the same books I was reading. So when we got on a call together, we could talk about those books. We could live the characters. We could be part of each other's lives while he was behind bars. We lost a lot, but since he's been home and he's been part of our lives, we've taken advantage of every step of the way, loving each other, being together, doing family trips. But every single time that we try to do something, it's always, what do we need to worry about? We can't go on that trip across the country because Grampy's going to have to stop at 4 different police stations and explain to 5 different grandchildren what's going on. It's heart-wrenching to not watch my parents be able to just do, like, they're old, they've dealt with so much. I'm not meaning they're old, but like, you know what I mean? They're
younger than me, so be careful.
Sorry, but they deserve the opportunity to live. And like, I know that it's very hard to hear about the victims and everything that's gone on because it's heart-wrenching to me this many years later. And I've done my own research. I have read everything. I have in my adult life, like, taken on the ownership of understanding all of it on my own. My dad actually recommended I do so. He said, I don't want you just to be part of this because, you know, this is your life. do it. And I did. And I have done my own research. I've written reports in college. I've done my own investigation. But the thing I need to just make clear is my aunt and my dad are good people. They have done for their community. They are always the first people we go to. And I just plead to you to understand that we need to put this to end. Like, our lives have just been with this forever. And I just need to have an opportunity to just not live this anymore. Like, I need to see that for my family. And I respect all the questions, and I respect, hearing about everything. But it's, every single day watching my mother for years work three jobs to take care of us, to send us to school. It's just enough. And if you all just had the opportunity, and let me tell you, like, I'm bummed my dad isn't here, because if you could hear from him, like, you would know his character. But I will tell you, he raised me. I am who I am because of him and my mom. Every ounce of me is because of them. They were a huge part of my life, even though he was behind bars. My mom's phone bill was really high, but he made sure he was an intricate part in our family. So if I could just ask that you give the opportunity here and just put aside the guilt and the innocence and all of the, all of that, and just look at who they are and who they've become. Like, my aunt is the first person to go volunteer at events. She's always out hiking, and the kids want to go with her, and everyone adores them. They're an intricate part in all of our lives. And I just want everyone just to understand, like, that's who they are.
Okay, Councilor DiPaolo.
Thank you for your testimony.
Thank you.
Councilor Hurley, do you have any questions?
Hold on.
Did she say none?
No, thank you.
Okay, thank you. Councilor Pereira?
I have no question, but thank you for your testimony.
Thank you.
Great daughter.
Thank you. I appreciate that.
Councilor Doolittle?
How old were you when your father went to?
My mom got it wrong. I'm actually 42. I'm not 41. But I was, she did. She helped me there. I was almost 5. I was like 4.5 years old when it all happened.
And for the first 4.5 years of your life, you lived with your father?
Yes.
And you didn't have any problems with your father?
They called me my dad's corsage. When I would cry, I'd be attached to his hip. He'd be rocking me till 3 a.m.
Yeah. You have children?
I do. 3. I have 3 children. I have a 16-year-old, a 14-year-old, and a 4-year-old.
Boys or girls?
I have a older boy and 2 younger girls.
Is your father taking care of those kids?
All the time. He is my number one provider of care. He's the first one who comes to help me out. Being that he is unable to get employment, he is always the one that first offers his time to keep busy and do things for us and take the burden of, daycare. He's literally raised 5 of our children, my 3 and my niece and nephew, sorry, my twin nieces, for, years. He's raised them and helped kind of bring them up.
Did your father take care of them when they were younger? Did your father take care of the kids alone
Yes.
in the house?
Yes.
Just him and the kids?
Well, we got permission for him to be around the grandkids
You have no problem with your father taking care?
he would be the first, not 100% with no regret.
Councilor Devaney?
I have no questions, but I'm so sorry for what you've gone through, really.
And
What
it
happened
does,
though, too.
I just want you to know that hearing your testimony does crush all of us, because we know the victims truly believe everything. And I'm not even going to even go there,
Well,
but
let me just
my
tell
heart
you-
breaks.
Let me tell you, I find no joy in saying it, but I owe my friends that. I owe that young woman that has lived through this, and for all of the people that have children that have been abused. So I'm sorry that you had to go through life like that without your dad and have all that burden. So I hope that your life will be better.
Thank you.
Thank you.
Councilor Duff? I'm sorry, Councilor Ionella? I forgot you. Yes, I'm a little distracted, sorry.
That's all right. I don't have any questions. You did a really good job today.
Thank you.
Especially not being prepared to testify.
No.
You did a remarkable job.
Yeah, to me, like speaking about my dad and my aunt comes easy because they are my life. Like I look to them for everything. So I really just want you to understand their true character.
Thank you for your testimony. It was
Thank
very
you.
compelling.
Thank you.
Thank you.
At this point, we're going to shift gears and I'm going to turn to Attorney Hardoon, who most of you know was the chief prosecutor in the case. I knew him back then as well. And for his presentation. And thank you for being patient. I've been sitting there very patient for many hours.
Thank you. I'm assuming, Counselor Hurley, that you can hear me?
Yes, I can. Thank you.
All right. Honorable members of this council, thank you for the opportunity to speak. I was the prosecutor in the Middlesex District Attorney's Office through 3 district attorneys from late 1970s to the early 1990s. I can readily say it was the most rewarding, certainly not financially, part of my career serving the public in that role. From 1989 to 1991, I founded and directed the Middlesex County Child Abuse Unit in the office. It was one of the first in the nation and introduced and implemented groundbreaking protocols that are now considered gold standard, many of which had their inception in this or from this case. I managed and supervised over 1,500 cases of alleged child abuse, and since leaving the office in 1991, I have continued in the same field and represented countless victims of abuse in the church, in schools, in camps, and in families. In 1996 and 1997, I was the chief trial counsel for both of the Amirault trials and led a team of 5 or 6 prosecutors and other support members from the office. I would say that no one in this room knows more about these cases, except maybe the next speaker. And so it is my intention to make my remarks briefer than I might have otherwise made them. I have submitted a complete statement to all the counselors, which references and addresses many of the points that have been raised by the other side. And I certainly am anxious to answer any questions that any of the counselors might have. I want to say I don't know what the governor's motivation honestly was in sending these pardon requests to this council. However, I do want the council to know that I approached the governor's office in an effort to clarify the misleading information that I felt they were relying upon, and they were not interested in hearing from me. Mr. Sultan has made this about exoneration, and that is all it has ever been for him. It tracked back his public statements. It's all about innocence, unfair trial, and that's what it was about today. That's what he made it about today. They want this to be memorialized as Salem Witch Trials #2. I do not want to let that happen, and that is why I am here today. There are several key points I would like to make, and then I'd like to answer any other questions. Number 1, the claims in this case from day 1 was that 19 children who were the basis for the 19 separate indictments in this case were coerced, led, coached, pressured, suggested to by overzealous police, social workers, and parents. And this is also what Judge Bornstein whose opinion you have and who was referenced many times here already today, bought into, and it is just not true. This claim of suggestive or improper investigation was the crux of the 3-month battle in court during the trial. The defendants had excellent, very experienced attorneys who I will note to you are not here today. I think over 60 witnesses were called, including at least 2 experts that the defense presented to try and support their claims about a faulty investigation. Absolutely, and I think maybe one of the counselors referenced this, absolutely every single thing that they are claiming now, they have claimed at the trials and through the 6 rulings by our Supreme Judicial Court. Their contention was rejected every single time, and that is because it is not supported by the evidence. And the quotes or information they're quoting for you was all quoted back then, and it is being presented to you out of context, and I suggest it's misleading, and that's why you're hearing from me. The reality of this case and the investigation is that efforts were implemented from the very beginning, from the very inception of this case, to enhance and to protect the integrity of the investigation. This was known to the investigators, and they went out of their way to ensure that there would be the least amount of contamination or anything like that between families, between children. Separate teams were created, and there were 3 or 4, I recall. Each team was made up of a police detective and an experienced member or experienced social worker, member of the Department of Social Services. The interviews of the children that took place after the children were referred to the investigators was always done at home for the children in low-key surroundings. Parents were there, and they all testified to how their children's initial disclosures came forward. They all testified to how the investigators approached their children. And I think you've all had the opportunity to actually see the 200-page report from the Attorney General that was created back in the 90s that investigated this very question of the integrity of the prosecution. And that report includes direct testimony, I believe, for all of the 9 children that ultimately were part of this case. And it explains exactly how their disclosures came up. And it is just night and day from what Mr. Sultan has described to you. The parents were never asked to interrogate their children. In essence, what the defense is, or the petitioners or their attorney is claiming, is that going back, that 19 sets of parents were literally clamoring to run home to their children, determined to implant wild thoughts of sexual abuse, and that they just persisted in doing this until the children caved in or they succeeded. And I'm saying to you that any kind of description that you hear that suggests that that was the way this case went is simply not true, and it's not supported by the evidence. And frankly, it's patently absurd. No parent would do that, and no parent would let any adult do that with their children. These cases, as you know, were tried before 2 of the most meticulous, cautious, thoughtful judges on the bench, before 2 different juries of 16 people. And one of those juries was brought in from Western Massachusetts in an effort to further enhance their impartiality in the case. The convictions were upheld 6 times by somewhat different 7-panel justices of the Supreme Judicial Court. All of everything you have heard today was presented at the trials and was presented to the Supreme Judicial Court. The suggestion, I suppose, that the petitioner is making is that somehow all of these people, myself included, were just deaf, dumb, and blind, who just could not see the forest for the trees, who were just hell-bent on convicting these people in spite of, the petitioners would have you believe, massive evidence of coaching and leading and other techniques that tainted the disclosure. Understand, this was the crux of a 3-month trial. They had every opportunity to pursue that. They had expert witnesses that testified to the very same things that they're trying to tell you Dr. Bruck would testify to, and that the Supreme Judicial Court, frankly, rejected as anything new in the case. And I think I just want to say one other thing. As a prosecutor, I was a prosecutor for many years, and I've sent many people to prison. I never took pleasure in convicting people. When the verdicts in this particular case came in against Gerald Amirault after 10 or 11 days of the jury poring over 3 months of evidence, members of my team were suggesting we go out for a drink and celebrate. And frankly, I declined. I went home by myself. I don't consider these convictions to be anything to celebrate about. And I do feel compassion for the family members. And I've always felt compassion for the family members that are sitting in the courtroom when a conviction is returned. And there are people in prison today that were probably sent there by me 45 years ago. You have my statement, and I think my statement addresses many of the issues that were raised. There is one area that I do want to speak to because it was so heavily weighted or relied upon by the petitioner, and that's the opinion of Judge Bornstein. As far as I'm concerned, Judge Bornstein drank the Kool-Aid in this case. I believe he is a nice person who thinks he is right, but he is not. He issued an opinion that ordered new trials in these cases back in 1977. His opinion, I believe, was relied upon by the governor, and it is often waved around as credible support for the petitioner's position that they are innocent and should be exonerated. I am telling you, it is not. When I read his opinion, I thought I was reading about a case I never heard of. The facts he cites are wrong or discredited. His language is about as biased as it could be coming from a judge. His opinion was characterized by the SJC as containing, and I am now quoting from the SJC, significant error, erroneous conclusions, inexplicably not considering relevant testimony presented at trial, and it was also characterized by the Supreme Judicial Court, and I believe you have this 1999 opinion. It was also characterized by the Supreme Judicial Court as meritless and giving inadequate consideration to certain facts. Judge Bornstein had absolutely nothing to do with these cases. He became involved a decade later after the trial judges had retired. The attorneys here today had absolutely nothing to do with these cases when they were tried. You might ask, did Judge Bornstein just fabricate the facts that he cited in his opinion? And I say, well, yes and no. Some of his statements, as far as I'm concerned, came out of thin air. But for some, he relied upon the videotaped interviews that you have heard about that were made of these children. I described them in my statement. These videotaped interviews, which I believe provide the basis for Judge Bornstein's review of the case and the experts they refer to, These videotaped interviews were a well-intentioned but doomed to fail as they did. If they had actually provided any of the basis for the prosecution, then maybe Judge Bornstein would have a valid criticism to make here. But these videotapes were presented during the trials. Experts testified about them during the trials. The fact of the matter is, these were intended to document what the children had previously said in an effort to spare these young children from having to tell it again. That's why these videotapes were attempted. In my statement, I go into detail about why they didn't work as the investigators hoped they would. These taped interviews, with only one exception that I can think of, were an effort made after these children had made their disclosures, essentially to record them. They have been misused and misrepresented by the defense from the beginning. They were fully explored and vetted at the trials by the defense and their expert witnesses, and it was apparent to the judges who were overseeing this case, who have an obligation to make sure that the evidence that comes in before the jury is admissible and reasonable evidence. It was apparent to these judges, it was apparent to these two panels of jurors, and it was apparent to everyone else, except maybe Judge Bornstein, that these videotapes were irrelevant to this case. I want to reflect on one statement I believe that Councilor Jubinville made. It is my understanding that a pardon once an individual is pardoned, there is no longer a requirement to register, and in fact, the record is sealed. So if that is a factor that you would be entertaining in considering whether a pardon is or is not a thing that should be applied here, I think that's an important factor. You have my statement that speaks to other aspects of these cases, including some of the many pieces of corroboration that was introduced at the trials, which have not been discussed here, nor should they be discussed here. This should not be an attempt to retry the case, but that is what Mr. Sultan has made it. This matter is not a public referendum. It's not a popularity contest. I am sure the petitioners are indeed very personable individuals. The letters they have provided in support speak to that. I'm not suggesting that they should be back in prison, nor is anyone else I'm aware of. They have served their sentences. Gerald does not need to be on an ankle bracelet. I was surprised, frankly, to learn that he still was. Regardless of that, he will complete his parole in 2023. However, there is no justification for a pardon that will be promoted by the petitioners and echoed by the media as a wrongful conviction that nullifies the long, solid legal history of these cases and that seeks to nullify the painful emotional turmoil that the victims and their families have lived with to this very day. It will also impose a distortion on the facts, frankly, that will have repercussions in the future by casting a pall over other children who will not be believed because of any misguided interpretation of a decision by this council to approve a pardon. It will be used that way. It's been noted by 2 or 3 of the esteemed counselors that these petitions for pardon are contrary to executive policy. They are unwarranted by the actual totality of the facts and evidence in this cases. And And frankly, I submit to you, it would be just plain wrong to approve them, particularly given the notoriety of this case and how a pardon will be misused. More than happy to answer any questions that any of the counselors might have about the trials, about the investigations, about anything else in conjunction with these cases.
Let you go on.
Can't hear.
As well about not doing exactly that. I've tried very hard over the last 2 weeks to talk to both sides of this, and try to keep the temperature down. The second point I just want to make is I have tried many, many, many cases in front of Judge Bornstein, both when he was in district court and when he was in Superior Court. And he was one of the finest judges I've ever been in front of. He was always very thoughtful. He was always very fair. He was always very professional and civil to all the attorneys and litigants that came before him. He is somebody I have an incredible amount of respect for, as do most of the members of the bar. And I have to point that out.
And I just want to.
You don't have to comment.
Well, I would.
You went after him. And I feel an obligation to set the record straight with that. He's a retired Superior Court judge who was an incredible Superior Court judge.
And
you can disagree.
No, I'm not
No,
disagreeing.
Let me finish. You can disagree with his opinion. I haven't always agreed with everything when I've been in front of him, but it doesn't mean that he was a bad judge. And it doesn't mean that he didn't do his job in this particular case. You can disagree with what he came out with, but he's a very thoughtful judge. Now I'm going to turn it over to Councilor DePaulo.
Thank you, Mr. Chair. And I'm not going to go down that line, but I do think it's important, Mr. Chair, to point out that the relitigation was brought up by the governor himself in his one-paragraph explanation of his reasoning for this pardon. The governor himself wrote that he's left with grave doubt regarding the evidentiary strength. And that's what really opened the door. So I want to respectfully disagree that the petitioner's attorney initially opened the door, however much he didn't follow Mr. Chair's guidelines. It was the governor who made this about the evidence. You're a prosecutor, or you're a former prosecutor.
Former prosecutor.
As a counselor, I'm sometimes outspoken about the fact that I think that the balance on the bench is skewed too much in the prosecutor's favor. That on balance, there's significantly more career prosecutors on the bench than career defense attorneys. It doesn't mean I don't like prosecutors. I hear a lot sometimes, and this is a roundabout way, I hear a lot sometimes about victims' rights. And it's a really murky phrase for me, but I hear it brought up as something that's considered in any manner of situations, including, for example, sentencing. What does victims' rights mean from the prosecutorial perspective?
I would probably answer that with one word that comes to mind, and I'm sure there's more to it, but I would say inclusion.
Okay.
What does
that
it means?
look like?
It means
in a very general sense.
It's very general. It means that victims should be engaged in the criminal process that's going on.
Mm-hmm.
Their opinions should be listened to. They should have an opportunity to express themselves. It means they have a right to know what is going on in a case. And for example, in this case, the fact that they learned about this in the news.
Learned about this pardon.
They learned about the fact that the governor had sent this to a pardon in the news, on the television.
Now, we've heard you were the lead prosecutor on this case?
Yes.
Were you consulted at all by the administration?
I was not consulted. I know the district attorney, that is the district attorney of Massachusetts, was not consulted.
Okay.
And other agencies were not consulted.
Okay. Earlier today, I pointed out my opinion that this whole process has been contrary to statutory mandate. That's how I interpret the Constitution. Others may disagree with me. Regardless of whether it was clearly contravening the legislature, at the very least, it was a non-traditional route to get here. As we all know at this point, the parole board held no hearing. And in fact, there's discrepancy even among the board about what exactly happened when they did see any petition. So that's what happened. Now, if the proper procedure had been followed, as outlined in the governor's own guidelines for executive clemency and by the legislature, Chapter 154, I'm sorry, Chapter 127, Section 154. So we are asked in the regulations that when the parole board holds its hearing, which I believe is mandated, that A, the victim shall be notified of the hearing date at least 30 days in advance. So what should have happened, instead of being sneaky about it, the parole board should have held a hearing, given 30 days notice to the victims. That's regulatory. When they issued their report, which is statutory, the regulations tell them that on the very next business day, they must inform the victim of their recommendation, whether it's pro or con. In this case, the governor snuck it through in the last, month of the administration. And from the council's perspective, we've been flooded with appointments for judges at the end of the governor's term. And that's no surprise. We had, I don't know how many hearings in the last 2 weeks, 5 or 6 in a day, I believe, at one point. And then we get this, with no statement from the governor of any substance of the reasoning, with a complete contravention of established norms, I would argue complete contravention of the Constitution of the Commonwealth, let alone the statutes. Tell me something, as a prosecutor, have victims' rights been respected in this case, in your opinion?
In my opinion, they have until now.
My opinion is that the governor has done a wild disservice both to the petitioners and to the victims and to their families and to the families of the petitioners by not following standard procedure, by making it smell to high heaven, by throwing it on the council with no rationale other than questioning the evidentiary findings of the trial, which, as we've ad nauseum gotten to today, is not even supposed to be a consideration in the process by the governor's very own executive clemency guidelines. Meanwhile, strike that. I have no further questions.
Thank you. Counselor Hurley, do you have any questions?
I believe you just called on me. Is that correct?
I did.
Okay. I read your full statement, and according to the way your statement was written, it was not you that was attacking Judge Borenstein. It was the Supreme Court in their decision. Is that correct?
That is absolutely correct. I was quoting from the Supreme Court, and honestly, I think Judge Borenstein is a good judge. I've never actually had the opportunity to try a case in front of him. I just think that he drank the Kool-Aid in this case. That's what I think.
Did the Supreme Court say that?
I'm sorry?
Did the Supreme Court say that? That he
The
drank
Supreme
the
Court
Kool-Aid?
did not say it. I'm saying that.
That's my point.
Okay.
That brings it,
Fair.
that makes it personal.
Fair enough. Okay.
No.
It was not my intention to make it
But-
personal.
Okay, I'm sorry, Mary, I didn't mean to interrupt. Go ahead.
But you always do, Terry, and I never take offense because it's you. But the point I'm trying to make is it's not this attorney saying the things that he quoted from the Supreme Court. You got the 7 supposedly wisest men and women in the state who took a look at the decision and said that the judge was wrong. But that doesn't stop the press from continually hammering away at something that was said. That's a real problem with our entire country today because of the way things are now emanated, not just in the press, but when I was a judge, I thought that the worst things in the world were Facebook, and the second worst thing was Twitter. I think President Trump has proved me right as far as Twitter is concerned. But I thank you for being here today. I thank you for being the spokesperson for the victims. You lived this case for a heck of a long time, and I appreciate your service. And I don't think that you were being disrespectful to Judge Bornstein. There are times when judges, even me, can get it wrong. So I thank you for that. And if you filed anything else today that I don't have in my possession, I'd appreciate you sending it to me.
Thank you, Councilor Hurley.
Councilor Ferrara.
Thank you, Mr. Chairman. Just a few things that I want to go over. We haven't talked about any of the letters that we got. We do have a letter that was given to all of us. Indeed, it was from the Middlesex County District Attorney at the time, Scott Hochbacher. And I just want to read a couple of sentences that he writes to us about. And he said he was the Middlesex District Attorney that initiated and oversaw investigations and prosecutions of the Amirault case in the mid-1980s. Is that who you worked for at the time, sir?
It is.
And he says, for 40 years, district attorney and attorney general appellate lawyers have painstakingly argued and successfully defended these conditions on multiple challenges of fact and law and multiple briefs and arguments before every appellate court, even as questions arose about the process. Right, sir?
Yes, correct.
And the SJC said, and you mentioned earlier that all of these things were talked about at trial by very capable lawyers for 3 months, and that just because a new expert comes down with a new opinion doesn't mean it's new scientific evidence. Is that correct?
Well, the only thing I would say is it's not a new opinion, but yes.
Right.
The opinion she had was the opinion that the experts they called at the trial expressed to the jury.
So this was a different.
It was a different.
Expert witness.
Different.
Who reiterated that there might have been a problem.
Exactly, and I think that's what the Supreme Judicial Court said as well.
But kind of disingenuous to say it's new scientific evidence.
They said it was not.
He goes on to say that it clearly seems to be a Hail Mary to get around all the legal history, to render it null and void. The posture claiming unfair trials and innocence is not consistent with the standards or ideals of legitimate pardons. I believe justice as best can be determined in a system was done. I believe the Amiraults were correctly found guilty of systemic child abuse of multiple children in their care. If it were a petition for commutation, I might have a different view, but that is not deserving of a totality of a pardon. And can you tell me, sir, your definition of a pardon?
Well, my understanding of a pardon is that, number one, it seals the record. Number two, if it's a sexual case, enables the person involved to get off of the register. And in most cases, honestly, it should be something that provides an opportunity for some compassion to an individual who may have screwed up some past point in their life, and they're in front of you, in front of the parole board, asking for a second chance. And that's not what this case is. And if it was, I wouldn't be here. And if it wasn't, and if I was not concerned about how a pardon will be misused by the public and by the press because of the way it's been presented, I would not have been here.
If you Google MassGov and you look at pardon, let me read you the very first sentence on the Massachusetts governor's website. MassGov, a pardon is a forgiveness of the offender's underlying offense. Doesn't that kind of beg the question that there was an offense?
Well, as I understand it, generally speaking, in order to obtain a pardon, an individual has to acknowledge what they've done and express remorse for it. That has always been my understanding of it.
That's been my understanding as well. And if you read on, later on, it says, upon receipt of a favorable recommendation from the board, the office of the governor will evaluate the petition upon that time after favorable. Have you ever dealt with a case where there's an unfavorable recommendation by the board that comes to our level as a pardon?
I honestly have never heard of one.
We also have a letter from a retired Malden police detective who states, and I just want to read a couple of sentences because it hasn't been made public, I don't think, but it's been sent to us. There is much made in the way in which the investigation unfolded and was conducted. As a career law enforcement officer and highly trained investigator, I can tell you that it was done extraordinarily cautiously, given the scope and the seriousness for all parties. The police meeting held once the office of the for the children closed the school was enormously challenging for parents. I recall how angry parents were at the school because it was closed, leaving them as working parents without anywhere to take their kids. They were also angry that none of the professionals present at the meeting were willing to share any abuse-related details from the initial cases that led to the closure of the school. To insulate against suggestive questions, parents were told not to have conversations with their kids or to feel that they needed to interview them. Quite to the contrary, they were told not even to have any conversations about this at home or watch TV in the earshot of their children. And I'll just go on to read a couple more sentences and then I'll be done. A team of DSS investigators and police detective jointly interviewed the kids identified through the screening process, with the DSS worker taking the lead. Steps were taken to keep the children apart from one another, and we absolutely knew to ask open-ended questions. There was much by the way of corroborating evidence and stunningly similar details disclosed, though none of those details had been shared. I have vivid memories of how the investigation was conducted and the compelling nature of the children's disclosures and the parents' description of their children's sexualized behaviors and more. I stand by the extremely careful and thoughtful way in which the investigation was conducted, and I fully believe that the juries at both trials rendered a just verdict. I strongly urge you to deny this pardon request. Do you agree with Detective John Rivers' synopsis, sir?
I do absolutely agree with him, and his description of the meeting that is so misrepresented by the other side is in fact accurate. And I believe following me, you're going to actually hear from a person that was at that meeting.
One last thing, because I also heard good things about Judge Bornstein as being a great jurist. Is it your opinion that he rendered a ruling based on the evidence presented to him and that he wasn't presented with some evidence from the prosecution?
I mean, that's the only conclusion I can come to. I was not there. I had nothing to do with the hearing in front of Judge Bornstein. But when I read his opinion, I feel like I'm reading something that Mr. Sultan wrote, not Judge Bornstein.
Did the prosecution make a decision not to put evidence in front of Judge Bornstein on some things?
I can't speak for the prosecution. I can only reflect back as the prosecutor and to what their approach might have been. And their approach might have been that they knew that there was nothing new being presented or being argued and didn't want to elevate it into something that it really wasn't and shouldn't have been.
I had the pleasure of working probably for 20 Superior Court judges. And I can name some of them: O'Brien, Ectofaris, Steele, Stedman, Tierney, Carey, Conley, Dolan, who was a trial judge, O'Neill. Do you think the same facts could have been presented to a different Superior Court judge with a different outcome?
Absolutely.
Thank you. I have no other questions. Thank you.
Thank you, Counselor.
Councilor Juneville.
Thank you. Counselor, I've known you a long time.
We have known each other a long
I
time.
think you were a wonderful DA. I never got the opinion that you were out for scalp, that you handled yourself in a courtroom professionally, no matter what the verdict was. And I never got the sense that you pulled any tricks or withheld any evidence. I really didn't.
Appreciate that.
Otherwise, I would have never let you park in my place down the Cape for the last 20 years.
I appreciate that too.
But I must say to you, I agree with Councilor Kennedy on your remarks about Judge Bornstein. I, in my 43 years, have been before him many, many times. He has always been a thoughtful jurist, takes the time to render opinions. And you disagree with some of his opinions, and so do a lot of other people. And we disagree with Superior Court judges that make decisions and SJC judges that make decisions. But that doesn't mean they're drinking the Kool-Aid And I think that's a shot at him. When you say drinking the Kool-Aid, that means it has a connotation that you're drinking something that's making you go off the deep end in your thoughts. And I've read his findings in the hearing that he had. I don't believe the Commonwealth saw fit to come to that hearing. I have no doubt that Judge Bornstein or any other judge that was assigned this case would have ever done the hearing without notifying the Commonwealth. That just isn't done. I think you would agree with me.
I would hope that's the case.
Have you ever heard it done in the Superior Court where just the Commonwealth gets to go or just the defense?
I certainly haven't.
I haven't either. And Judge Bornstein would have violated the rules of the Judicial Conduct Commission by not notifying the government and saying, hey, we're going to have a hearing and put on your evidence. I've been assigned this case. He didn't ask for it. He was assigned it. He wrote a rather lengthy report, which I'm sure you read.
I have.
Okay. You will agree with me that he cites page and verse of a lot of the exhibits that he mentions in the trials.
I will only say that I know he has citations in there. I don't know where they're from, and I believe they are selective citations.
Well, how do you believe, what is your basis for believing that?
Very simple, and the basis for my Kool-Aid remark, and frankly, I did not mean it in a disparaging way.
I know, but
I mean, no, but that's important.
if you
That
said Jubenville smoking the Kool-Aid or drinking the Kool-Aid,
right. That was my way. That was my way of expressing how incredulous I was that he was coming up with the findings he was finding based on the evidence in the case.
Then you should have said that.
Okay,
Phrase it
I'm
offensive.
happy to apologize about that remark. I mean,
Okay.
fine. I
Now,
did
let's-
not mean it to be
Listen.
an insult, and I certainly do not intend it to be.
I'll accept that.
Okay.
Let me, you're familiar with decisions by judges
Of course,
and briefs prepared by the parties.
of course.
And in this type of a case, you go over the trial transcripts. And I assume Judge Bornstein went over all the trial transcripts.
I have no idea.
Well, Larry, Mr. Ardone, you think Judge Bornstein got assigned this case and said, I'm just going to make all this stuff up. I'm not going to read any trial transcripts?
Nope, that's not what I'm saying, that he didn't read any trial transcripts. What I am saying is that the trial transcripts in this case would probably fill boxes from one end of that a desk to the other. And no, I do not think he read all of them.
So when he writes, about the case, and he notes Exhibit 2A at page 221, you dispute that that's true?
I have no idea what Exhibit 2A at page 221 is. It might be an exhibit that was introduced into the case by the defense that the jury heard about and decided was not worthy of
Well, that's not what I
consideration.
asked
I
you.
don't know,
That's not what I asked you.
but I don't know what it is. I can't say.
Well, please. Are you saying the judge made this stuff up?
Some of it,
Put
yes.
an exhibit on it so that it could be looked at in the exhibit?
I am saying that some of his remarks, from my perspective, seemed as if they just came out of nowhere. Because, well, let me finish. Because I don't remember any times during the trials where things like the things he referenced in his opinion were ever said. And I wasn't, by the way, involved in that hearing. So, okay.
But you would agree with me that you try a case and the case is over and the appeals lawyer does the appeal, and you get a transcript or a notice of his appeal, and you look at the sites and you go, geez, I don't remember that happening. That's because we move on to other cases. So we don't remember every detail.
Okay.
And you would be having to say Judge Bornstein fabricated the exhibits and the page numbers that he put in these sites.
No, let me clarify, because that's not exactly what I'm saying. What I'm saying is that he was misled, because from what I can see from reading his opinion, it seemed as if a good portion of his commentary about the investigation, the leading, the whatever else he might have said about it, was taken from the videotapes. And that's why when I said before, I think I said, did he just fabricate the facts? And I said, well, yes and no. Because
what's your proof to say that a judge of the Superior Court fabricated?
sure, I can answer that question. I was at the trial.
Tell me the facts he fabricated.
You want me to remember them? I can't.
Okay. Did you check to see that the exhibits were not correct in the transcripts?
I did not.
I'm sorry, I can't hear.
I said.
I can't hear Counselor Jubinville.
Oh, I'm not now. Okay. So I said, did you check to see whether or not the exhibits cited by Judge Bornstein and the page numbers were proper?
Why would I, frankly?
Because you're coming here saying that this is all fabrication, that he's made it up.
No, that's not what I said.
What's fabrication mean then?
The language that he has used, the fact that he references in his opinion that kids, and I'm paraphrasing because I don't have it in front of me, but that he references in his opinion that children were questioned over and over and over again, and that they were coerced and all the rest of it. It's just not true. It didn't happen. So that's where it's coming from my own personal experience and knowledge with the cases. And I don't need to read something when I was there.
Well, he wrote this in when was it? 96?
96, 97,
And the trial was 86?
86, 87, 10
10
years.
years later, you remember everything in the trial? Come on, I don't. Terry Kennedy don't. You don't remember every single thing.
I didn't say I remembered every single thing. I said what I'm remembering is that there was no evidence in this case of the things that he referenced in his opinion.
So nothing in his opinion, in your opinion, nothing in this document that he wrote up and had a hearing with on tape, nothing he did in this report is accurate.
Well, that's not what I said.
You said he fabricated the whole thing.
No, I certainly did not.
Okay, what did he fabricate?
I'm not going to go there. I'm just telling you that I read it. As far as I was concerned, it could have been written by Attorney Sultan, and that was my reaction to it.
Yeah, but
And I'm not going to go through his opinion. This is not what I'm here to do, and pick out all the different things. I could.
No, but
I could. We'd be here for another few hours.
You made the statement that he fabricated. You made that statement. He was on the Kool-Aid. But you don't back it up with anything saying like on page 54 when he cites Exhibit 2B-5 and H1-226. I looked that up and he's completely wrong in the transcript. You never did that.
No, I did not.
Okay. Let me ask you. You would agree with me that the way cases today involving allegations of sexual abuse of children are handled much different than they were handled in the 80s.
I would disagree with the much, but they are different.
Well, they do SANE interviews.
They do SANE interviews.
Right away.
And in fact, some of that really was an offshoot of the videotaped interviews that happened in this case. I mean, that's what they were kind of leading to.
If anybody questions the child, they're brought into a room with a trained examiner.
It's
And
not-
everything is on I, tape. I'm sorry, I can't hear you, Mr. Jubenville.
I think you got to turn
You
your
keep
hearing up,
fading.
Mary.
Mary, do you want my hearing aids? You can have them.
Can you hear me now?
I can hear you now, but what happens is your voice drops just like it does in the council chamber, and I can't hear you.
Well, I don't like to.
Voice drop in the.
I don't like to yell at women. I get in trouble. But what I'm saying is today, everything is recorded right off the bat.
No,
So
no,
from
it is,
you
no,
as
it is not. I'm sorry.
Well, I've had a few of these cases. I'll go back, I'll say in the last 10 years, probably had a dozen of them involving kids. From day one, when the allegation was made to a police officer, they were taken to a sane interview, either that day or the next day, but pretty quick after it. And
That is-
everything was recorded so that the prosecutor could see it and the defense attorney could see it. Isn't that what they do today?
Well, let me say this. That is certainly a protocol, but I'm not sure what the point is because yes, that's certainly a better protocol. But if the insinuation or interpretation you're trying to put on that protocol is that somehow before they started using SANE teams, the trained and experienced social workers and police officers that went and spoke to children were incompetent or incapable of getting accurate statements, I couldn't disagree with you more.
Well, you will agree with me that this case has been a troubled case from day one.
No, I would not agree with that
In the
terminology.
sense of the appeals, motions for new trials, going to the SJC, it's unusual to have this much activity in a case. Very rarely does this happen. Would you agree?
I can't think of another case that's been rejected 6 times by the Supreme Judicial Court, if that's what you're asking me.
Well, I can't either. And that's my point. And part of the problem
missed
as
the
I
point
see
then.
it, part of the problem as I see it is a lot of interviewing with the children happened before anybody recorded them.
The recordings in this case were a failure.
No, that's not my question. My question is, there was discussions with the children before they finally went and started recording them.
No, I'm sorry. That makes no
never
sense.
happened.
That makes no sense. Your statement makes no sense.
Okay, that never happened, that these kids were talked to before it was on a video.
There was no videotape that was of any import or use. And of course, the kids were spoken to before they made that effort to put them onto videotape. But the reality is, and if you have read, and I'm sure you have, the Attorney General's report that I provided to you, you would see, in fact, how the disclosures of the 9 children that participated in these cases came to be. That was the testimony at the trial. I don't know what else you want me to say about how it came about.
You think a lot of this, what do I say, this points in this case that were brought out and the arguments on behalf of against it and for it, a lot of that would have been not been done had these kids been interviewed like they do now from day one.
I don't really understand your question.
Okay. Now, you've been in front of juries a lot in your life,
Many times.
and so have I, and Counselor Kennedy, and Counselor Ryan Ellen, and Counselor Ferrera at times. And I know it's our system that we have in this country. But in my view, and I tell my clients that you never, ever put your faith in a jury unless you have to. Because jurors get it wrong. I think the statistics are about 15 to 20% of the time. Would you agree with that?
I certainly can't agree with that.
Okay. You agree that there have been numerous, dozens of cases, if not throughout the country, maybe hundreds, where people were exonerated because of DNA.
I think DNA has become a very useful and
You agree that it's exonerated a lot of people?
I don't know what a lot means, but I will agree that people have been exonerated, thankfully, through the use of DNA testimony or DNA evidence. Yes.
We seem to hear about it every other month. But see, my point is, a DA stood in that courtroom and pointed at a defendant and said he committed this crime. And the jury bought it.
Okay.
And they were wrong. Now,
Okay.
you can't know that as a DA, but they were wrong.
I understand that happens sometimes, especially in cases of identification. In fact, if you went back and looked at all those cases that you're referring to where DNA became a relevant factor, they were identification cases. They were cases where the perpetrator or the defendant was misidentified, was wrongly accused. They got DNA evidence and they determined that that was the wrong person that was identified. Has nothing whatsoever to do with this case.
There's been cases where the police have gotten a confession from people that we now know they were innocent of, right?
Okay, yes.
So there's flaws in our system. Would you agree to some point?
I would certainly agree that there are flaws in the system. Okay.
So personally, I think our jurors should be trained. Like when we jury waive a trial, we have a trained person sitting on the bench.
Well, that raises other questions, because then you risk having biased, trained jurors, and the whole idea behind our system of justice is that you're judged by a jury of your peers, that don't have preconceptions, they're not trained, they're not schooled in any particular thinking. They come in, they're people just like everybody in this courtroom, and they listen to the evidence and they make a decision. That's our system. Maybe there is a better one. I don't know of it. Not a perfect one, I'll give you that.
It's probably never going to change in our lifetimes. Now, the fact that this case had 3 judges that gave new trials, I believe, right?
No. I don't know where the 3 judges come from. I don't know where that is.
Barton, give him a new
Barton,
trial?
the only judges I know of are Barton and Bornstein. I don't know where this 3rd judge came from. I have no idea.
Wasn't there 3 appeals of the government up to the SJC?
The 3rd appeal was a whole different matter. If you want me to explain it, I'm happy to.
There were 2 then.
2.
Judges that gave new trials.
2.
And they were appealed, right?
Yes.
I thought there were 3 Supreme Court decisions on this case.
Yes, if you want me to explain the one that you're referring to, I'm happy to. But it was not.
No, there's 3.
No, it was not 3 in the sense of 3 decisions that overturned any part of the case. That is incorrect. I'll explain the 3rd one if you want to hear what it is.
So one judge allowed a motion for a new trial, right?
I'm sorry?
One judge allowed a motion for a new trial.
Correct.
Another judge allowed a motion for a new trial.
Correct.
Those got appealed and were overturned, right?
Correct.
So that's 2 judges at least that thought something may not be right in this case,
Yes.
right?
Yes.
And you disagree with them.
Well, it's not whether I disagree with them or not. I certainly have to rely on the fact that we have a Supreme Judicial Court in our state that makes the determinations of whether to agree or disagree. It doesn't matter whether I agree or disagree with them.
I agree. Okay, but I'm just pointing out.
Well, we know I
when you
disagree
say
with.
2 juries found him guilty, and there were 2 judges that thought they needed a new trial. And a 3rd judge, Judge Bornstein.
And I would say this, if you want to equate 2 juries and judges that sat there for 3+ months, listened to the evidence in front of them, made determinations about credibility, if you want to equate them to 2 judges that got dropped into the case 10 years later because the original judges retired, go ahead and do that, but that's ridiculous.
I don't think it's ridiculous. I'd much rather have a judge make my decision on my fate.
Wrap up.
Okay.
I'm sure you're glad to hear that.
And not all of the SJC judges concurred, by the way.
Yes, there was a single dissent, I understand.
Yeah. The pardoning, you said the records are sealed.
That is my understanding.
I don't know whether that happens automatically with a pardon or whether the person has to then ask the court to seal it.
All I can say is that my understanding is that along with a pardon comes the sealing of the records and the
I've
removal
never
from
read that
the registry. I
And
mean,
with-
that's something that you can
and
certainly,
also,
you can certainly determine.
a sealed record can be looked at by the courts and by the police.
Not by employers, not by anybody else that might want to do a query check on an individual before they give them a job.
Well, in this particular case, forget the Corey record. All somebody's got to do is type in Gerald Amirault, and every single thing that happened will come up on Facebook or Twitter or Tweeter or whatever else they use. Right?
Yes.
So a record today, even if you seal it, it's available to anybody that wants to look it up. So what we're asked to do here is a pardon. It's going to shave 1 year off of Gerald Amirault's parole. My question to you is, at what point do you say, okay, he's paid the price?
I would answer that question honestly by saying if this were a commutation hearing, I probably would not be here today. I think I tried to explain the reason that I have come, the reason I put in all the effort I needed to put in to be able to be here today is because I believe, given the posture of this case, that a pardon will be misused. We'll be reading about this as the second Salem witch trials in Massachusetts. It'll be used to discredit children in future cases, and that is why I'm here. If this were a normal proceeding for a pardon based on the standards that should be applied to a pardon, I probably wouldn't be here either.
So we should deny it because maybe the press or whoever else are going to make statements about it?
You should deny it because it doesn't follow the correct protocol, because it is being misused by the other side, frankly. And so, yes, that is a part of it. Yeah.
Well, my last comment will be, it hasn't been abused. Governor chose to do what he did. He has every legal right under the Constitution. If you read it, it doesn't say anything about going to a parole board. He has a right to pardon, period. And that's what he did. But thank you for your time. And if I still had my place, you would have been still parking there.
And I'd still appreciate it.
Thank you. First of all, this isn't a meeting about Judge Bornstein. And so let me just wind it up because enough's enough, okay? What happened was.
I can't hear.
You're lucky.
All right. I don't know whether this is working. Is it working?
Now it's working. Thank you.
All right.
It's working now.
All right, then I'll take Counselor Ferreira's. All right, let me summarize this in enough's enough about Judge Bornstein, because it's not about him. It's supposed to be about a hearing about Cheryl and Gerald, but they're absent. So this is a true backroom politics. No DA was told about this, no affected families, no parole board, no sex advisory board. And the governor should respect the parole board who rejected it. So why is it going so long? The governor was given this 2015. And it was a friend, Barbara Anderson, and she was dying. And she said, as my last wish, would you pardon my friend Gerald? He waited a few weeks before his term is over. How about that? Okay? This is the most secret. And how secret can it be? We don't even have him here. But I want to just enough's enough about Judge Bornstein, and I respect him. The witnesses before Judge Bornstein had absolutely nothing to do with the cases. He never heard from any parent, any child, any police detective, any social worker, or any of the actual trial attorneys, prosecutors, or defense. And what he based it on was great deal of reliance he put on were the interviews on videotape of the children. So enough said. So I'm just saying that I respect you, Attorney Haddoum, because you're here for the children. And this is going to be history. Because if he gets the pardon, all children, and it's happening every day, they're being abused, who's going to speak for them? You know? Who's going to be left to speak for the children? So I respect you for that. Now, I want to go back and my good counsel colleague, Ferrara, had mentioned about Scott Hashbarger. He was my Middlesex County District Attorney and Attorney General, know him very well. And he said, and I won't go over what you said to be redundant, but he said it's imperative, in my view, that the council consider the full picture of the issues in this case to hear from and understand the traumatic impact on the victims and survivors and their parents, and grapple with how such a decision will reverberate beyond the individuals involved, as it most certainly will in a case of such notoriety. I believe justice, as best we can determine in our system, was done. And so he believes that we should reject this pardon. Now, I want to speak for Tom Riley. He was also my district attorney, lives down the street. And I want to correct, sometimes they misquote in the media, and I want to correct it. And he has said recently, he was the first assistant district attorney under District Attorney Scott Hashbarger throughout the investigations and trial of these cases. And he wants to make 3 points to share to clarify. 1, they are not innocent. 2, they were not wrongly convicted. And 3, the juries believed the children. Enough said. So I'm sorry that you're put through this. This isn't a court trial that we're, that we should be doing this. And for Judge Boardstein, I don't think you should have been the center of attraction here. I'm sorry for that. But I do want to say that, one of the counsel says I should recuse myself. The rule does not apply unless you are related, and I'm not related. But I'm here for her. She's 41 now, and for all those children. And I hope the ones that did survive through it all are living good lives. But those will never know how many died. We do know that many of them are drug addicted. So this has affected, we don't know how many children. So I can't thank you enough. I really, because again, you're talking for the children. Is there anything that, that you would like to say in summation of this case and how much time you took into it? How many decades have you been involved in this one case?
As you know, I've been involved for many decades after the trials, mostly as a spokesperson, honestly, because I was called upon to respond to the basically same story that you heard here today. So for a period of time, I spoke locally. I was on national television programs, on radio programs, because I felt it was important for the other side of this case to be explored and known. But I kind of retired from that at least 15 or 20 years ago. I did not think I'd be back here today. But you've already heard why I am.
All right. Well, I thank you for that. It's very disturbing to me. It seems like in recent years we hear more of sexual abuse, murders of our children. And they just found a boy 4 years old, from 1957, in a box. Did you see that?
I'm
And yeah.
having trouble hearing you. I'm sorry.
Oh, I'm sorry. I said it was just on TV and it was on the Globe. I read they just found a body of a 4-year-old boy that was in a box since 1957. They don't know relatives or anyone, but they buried him. And they said that he had been brutally beaten constantly. They could tell by whatever the evidence they go by, but it's continuing. And if we don't have attorneys like you to represent children, children don't have that ability to make up vile things and lie and say awful things. And one child told their parent, and that's how it went. And so, again, I thank you so much, and I'm sorry that you had to be, under such I don't know, you don't have to defend yourself at all. You did a wonderful job, and a lot of people appreciate you being here because, as you said, no one knows this case more than you.
Thank you, Clark.
Thank you.
Thank you, Counselor Devaney.
He's a big boy. He can take it. Counselor Iannella.
Thank you. Good to see you, Attorney Hudon.
Good to see you, Counselor Iannella.
I know there's a few more witnesses, but in a nutshell, the way I look at this case is, yeah, obviously you know the facts probably better than anyone here. I get it. I don't think Judge, I don't think he meant any ill will towards you.
Never tasted the stuff.
Yeah. You know, the Amiraults, it was really impressive, compelling testimony from the wife and from the daughter. But at the end of the day, for me, these people were convicted by 2 juries, not the same jury. And there's 12 people deliberated in each one. That's 24 people. 24 people.
I actually think the full panels
All
got to
16?
deliberate. I believe so.
That's 32. And 6 appeals to the SJC. But how many of those justices dissented, do you know?
As far as I know, there was either no dissent or one
So
dissent.
let's think about that. We don't, obviously people change, it could have been the same justices.
Well, it was different in some of the different panels.
Okay, 2. But my point is, the jury, the Superior Court judges, the justices of the SJC, overwhelmingly, if you add up that number, my good friend Jubenville is, well, two judges, whatever, but overwhelmingly, the juries, the judges, the justices thought the Amiraults were guilty. And that's how I have to look at the case. And my concern is, if this was a commutation, yeah, they've served a long time in prison, appears to be good inmates while in prison. They've contributed to society when they've got out. I'd have no problem voting for a commutation, but it's not. The thing that gets me is the Mass Sex Offender Registry. If it's a commutation, that's still there. If it's a pardon, it goes away. And that's a little troubling to me. A pardon, in my opinion, it wipes out everything. And what actually happens, in my opinion, I'm not sure I agree with either you or Jubenville. In my opinion, you get the pardon, you then go in front of a judge. In reality, this is what happens, I think. Go in front of the judge, you show that you just got a pardon, and then they're going to seal that record at that point. Okay, then the sealed record goes to the Department of Probation and the record is expunged. That's my understanding. I know everyone has a different viewpoint. That's my understanding. You apply for a job, Corey check, all that, it's not going to show up. It's not going to show up. That's the troubling part for me. And I get it. You know the case pretty damn well. I got to tell you, I was impressed with the presentation and the facts. Other than beating up Ornstein a little, I'd give you, you did a good job on behalf of, your point of view.
Thank you, Counselor.
I'm done. No further questions.
Yeah, it's hard to get this in front of my mouth. So thank you for all the documentation you provided me. And I understand that, how many years ago was this case? Like
You tried like 30 years ago.
More. I think it was 86 and 87.
It's hard, you're a little older. Hard to remember.
A little grayer too.
Hard to remember it all.
It's hard to remember some of it, but it's not hard to remember a lot of it. So it depends.
So, Eileen, I can't hear you.
Oh, all right, here you go. Can you hear me, Mary? Mary?
Yes, ma'am. Yes,
All
I
right.
can.
All
Thank
right,
you.
Good, good, good. The tapes of the kids after they came forward and made these allegations, who requested to have those tapes made?
I can't actually answer the question. I was not involved in the investigation. I was assigned the case at a later point in time, not much later.
So then this isn't a trick. I'm just trying to get the answer.
I think it was I believe
The DA's
that it was
office?
I believe it was a collaborative decision made by the DA's office and the police.
And the police.
That's what I believe.
Okay. And so in the goal was to, get it documented on tape,
Correct.
the allegations.
Correct.
And then, but then you decided that the tapes weren't, I mean, you told me you just got to throw them out, that they weren't even useful.
That's correct. When I got into the case, which was shortly thereafter, it then became my responsibility to basically examine all of the evidence that we had, because I was going to be the one that had to present this in front of a jury. And so I needed to know how I was going to put my case together, what the strengths were, what the weaknesses
Right.
were, all the rest of it. And in the course of preparing and or examining and familiarizing myself with the facts, obviously I watched the tapes.
And they weren't beneficial to your case.
They were A, not beneficial, and B, irrelevant, because they
Well,
all
they
came.
can't. I'm sorry to interrupt you, but this is the part that I'm having trouble getting my mind around. The prosecution asked for the tapes, and now the tapes aren't what they wanted them to be, so now they're irrelevant. And I'm trying to follow that logic. And I'm not trying to be tricky. I'm a lineal thinker, and so it doesn't make sense to me. The sense to me is the tapes they're little kids. They were 3, 4, 5-year-old children, right? I mean, they're babies.
Well, they were more like 4, 5, 6, 7-year-old children, but yes.
When the tapes were made.
Yeah, I believe so.
And so the tapes were made years after the allegations?
The case went to trial.
Because some of I'm sorry to interrupt you. I don't mean to be rude, but some of these people, they're now adults, were only 3 years old at the time. I mean, I've listen, I've talked to you a lot. I've checked these. I've checked dates. I love math. I've been trying to do the statistics of, the number, the percentages of everything of, what these allegations mean from the beginning to end, 25% of the children in that daycare were allegedly abused. That's a huge number. So I'm trying to follow the logic, because that's how my brain works, and I'm not finding a lineal path here.
I guess having a little bit of a hard time exactly understanding what you're not following. So let me just go back for a minute. In order to present indictments in the case, in order to charge these people with crimes, the prosecution had to collect evidence and information that could be presented to a grand jury. And in fact, if I'm not mistaken, the grand jury issued indictments for 19 children. The tapes were created in the middle of that process, before the indictments happened, after the kids had made their disclosures. And part of it was, and let me just back up for a minute. One of the implementations that I instituted in the child abuse unit when we created it was essentially to terminate with a cold stop what I considered to be a fairly barbaric way of indicting people in these cases. And so before we changed, before we basically by fiat changed the protocol and then had to wait and see if the Supreme Judicial Court accepted it, in order to get an indictment, let's just say it's a 4-year-old child or a 5-year-old child, but a child who's competent enough to talk about what happened
Sure.
and understands truth or falsehood, that child had to go into the grand jury with no parents, with no support people, with nobody except the prosecutor, who may or may not have been able to take the time to establish a relationship with the child, and speak in front of a room of 25 adults and describe things that happened to them that they were often threatened to not describe. And that was the process. So I believe that what was being attempted here was an effort to, let's try to get what the children has said 3 months ago on tape. And then let's use that tape in the grand jury.
In lieu of in-person testimony.
Correct. Let's
Okay,
use
that
the
makes
tape.
sense. I'm
So
just trying to.
That's was part of the motivation. In
Right.
other words, let's create something that might be used to relieve the children from having to talk about it again.
And since the prosecution, I don't know if it was you personally or Scott Hart, I don't know who it was, but when the prosecution decided that the tapes really didn't serve that purpose, then did the kids have to testify in person?
So in the grand jury?
Yeah.
No, I think what they ended up deciding to do, because we just really did not want these kids to have to go through this process. It's barbaric as far as I'm concerned. So I believe that they ended up using testimony from the interviewers
So the children never, I'm sorry, this is new information for me. The children never testified before the grand jury. The interviewer, so adults did, the interviewers did.
getting the indictments, correct.
To get the indictments.
Correct. And that's not unusual.
Okay, no, I believe you that it's
Yeah.
common. I just personally
Yeah,
find
it's
that
not- it's not-
fascinating.
it's not
And
a-
is that how it's still done today?
Well, the answer is yes, although
Okay.
it's a little bit different today. I mean, one of the part of what the child abuse unit was able to accomplish, which really emanated from this case, I have to say, before Fellsacre, if an allegation of child abuse came through the system, the police would go out and conduct an interview.
Yeah.
The social workers would go out and conduct an interview. The Office for Children would go out and conduct an interview. Then the prosecutor might have to conduct an interview to prepare the child for trial. And so the reality was that, and there was the grand jury proceeding. So the reality was that a child had to participate this many times, and it was just really, I continue to use the word barbaric. It was just really unfair to the children. So one of the new protocols that we implemented in the child abuse unit was we created an interview space. Well, let me back up for a second. Part of what started with Fellsacre was the effort was made by the investigators to collaborate.
Right.
So in other words, they on their own
I'm
got
sorry,
together.
for the sake of time,
Yeah.
I don't need to know that because
Okay.
that's not relevant in where.
I'm-
I mean, I appreciate what you're telling me because it's interesting and educational.
Okay.
And if we weren't like
Yeah,
going
I'm
on,
happy to.
yeah, that's all right. We
Sure.
could talk about that later. So, but it's fascinating. It's for me as a layperson, I find that fascinating. And I've had to, I wasn't 5, but I was 19 and had to testify in a case. And I know how much preparation goes into getting your witnesses ready and prepared for when you get up there and you get cross-examined by the police, what you got to do and how you got to stick to your story and everything. Did you find any part of the kids, did you find their allegations all, I mean, I guess I don't want to put words in your mouths or in the mouths of the prosecution, but you clearly found all of the allegations credible.
Yes.
All of the allegations.
Yes.
So you believe that children were tied up naked to trees
Oh,
in
I'm
front
sorry,
of the
you're
store?
talking about, did I believe every single thing that was spoken by a child? No.
So how do you, I guess this is the part that's hard for me to discern. Because some of these babies, and they were babies, and I'll be really clear, some of these children may have been sexually abused. Whether it happened there or someplace else, I'm not sure. And I think there's a lot of gray area in all of this, in my opinion. But that's neither here nor there today. But some of the allegations that these children made are absolutely fantastical. Fantastic. They're fantastic, truly fantastic. And so, how did you discern between dogs and squirrels being torn apart and we're being tied naked there were robots chasing us with, there were clowns. It's fantastic. And so, yeah, please explain that to me. How do you discern between what part is real and what part is fantasy, or is it all fantasy?
So,
And where does it, how do we know? How do we know?
so it's not as difficult to discern, frankly. I break it into 3 categories.
Mm-hmm.
They're the things that the children described that were basically garden variety, run of the mill, child abuse, child pornography.
Right.
There were things that the children described that were puzzling, and we didn't know exactly how to interpret it. For example, when some child might have talked about a animal being killed, we didn't know if that might have been a stuffed animal. We didn't know. We just didn't know. And then there were some things that the kids said that we knew was the product of just their imagination or whatever else you want to talk about. So we knew that the statements fit into one of those 3 categories. And the point of it is, because everything you have just said, every single thing you've just said was explored at the trials. And the point is, if you look at it the way you're looking at it, which is I'm looking at these couple of bizarre allegations, then you might be sitting there saying, well, how do you know what's real and what's not real? But when you put it all together, when you look at the big picture, when you look at children that made disclosures about graphically sexual things that were strange to come out of a child's mouth, that came from children that were in different families, they weren't in the school together, they were interviewed by different investigators. And when those, for example, and I'm just giving you one example.
Sure.
When that information comes back, that goes into the, credible garden variety child abuse.
So, okay. So, some of the sexual abuse allegations are indeed bizarre. And so I guess when a kid says there was a foot-long knife put in the anus, that's not true.
Of course, and that was discussed, and it was discussed in the following way, and it's kind of interesting that you mentioned that, because I think one of the other counselors talked about the sticks and the
magic wands, all of that business.
And when the kids talked about those things, when I learned about it, I was puzzled. I was puzzled. I did not understand it, and I think I speak to this in my statement. I just didn't make sense to me that kids were talking about magic wands and sticks and silverware put in their bums. And that was when, just to do it quickly, that was when I sought some assistance from the United States Postal Service, because back in those days, child pornography, it was on paper.
Correct.
It traveled through the mail. And it was the postal inspectors that prosecuted those cases. And I asked one of the postal inspectors, can you please bring me some child pornography? I've never seen it. And he brought it to me, and I looked through it, and it was a pile of it. But what stunned me was when I saw pictures of young children, 5 years old, 6 years old, whatever, naked with sticks and pencils and wands and spoons and forks stuck in their bums. It was a watershed moment for me.
I can imagine it was disturbing.
Well, it was what made me understand that sometimes what sounds bizarre is actually literally true.
Okay. In the thing about the cameras, because I've read pretty much everything I've had, but of course I don't have everything because, like you said, there are 30 boxes of files. But there are two descriptions of cameras. One was clearly a Polaroid, but the other is clearly not.
No, I think as far as we could
I mean, it's described by more than one child.
No, as far as we could
Right.
discern, it was descriptive of the way video cameras worked in those days. You had a camera, you had wires, it went into a console, a cassette. That was how videotapes worked back.
Yeah,
in
that
those
wasn't
days.
how I interpreted it, but that's interesting to know.
Yeah, no, that's how that's how it was presented.
Yeah.
Mark said.
Okay. Okay. That's all. Thank
Okay.
you.
Thank you, Counselor.
You know what my hangup in this case is? We've talked about it. The SJC decision on the confrontation clause.
We have talked about it.
And you agree with me that the SJC found that there was a constitutional violation with respect to the confrontation clause.
Yes.
And you agree with me that they basically gave no remedy related to that violation in the interest of finality and the failure of defense counsel to raise it at the trial level. That's what they did, right?
I would characterize it differently, but yes.
Okay, essentially that's what they did, right?
Again, I would characterize it in a different way.
Now, I have a big problem with that. I remember when the case came out and I read it. I was appalled by it at the time, that finality would trump Constitution. I reread it a couple of weeks ago when this pardon came in, and I think I was even more appalled by it. I completely disagreed with the lack of a remedy, that finality in and of itself was the basis to just frankly blow off the Constitution. That's how I look at it.
Yep.
You can look at it differently.
Well, we talked about it.
Yeah, I look at
And
Judge
you- and
Bornstein
you know I do look at it.
differently than you do too.
Yeah.
You know, but I find that really troubling in this case. And that is not about guilt or innocence. That is not about whether these actions actually happen. That is about a constitutional violation to the confrontation clause. And I've been trying cases now for 39 years. I'm a big believer in the Constitution. I'm a big believer in the rights that come with that. I'm very troubled by that decision. And frankly, every time I bring a new motion of a new trial in a case, and I bring them periodically, that's the Commonwealth's answer. Finality of judgment. You hear it over and over and over and over and over again. I think it's a terrible decision. I think it was wrongly decided. You think Judge Bornstein's decision was wrongly decided? I think that was wrongly decided. When they find such a serious violation of their constitutional rights and say, but in the interest of, public's interest of finality, we're not going to do anything.
I don't think that's what they said.
Then we can disagree to disagree.
Well, no, I think what they said was it was not the kind of error that would have made any difference in the case from their view. They did say that in the opinion. You can read it. And they also referenced the fact that it may well have been an intentional strategic decision made by the defense attorneys. The judge raised that question in front of them and they declined.
Decision as well.
Right. So yes, I mean, I think it's not as exactly as you presented. That's what I'm saying.
But the ultimate finding by the court was there was a violation of their constitutional right under the confrontation clause. We agree with that, right?
We agree with that. Yeah.
Okay. So what do you do about that?
Well, if it had been a serious violation, they would have upheld the decision. There are degrees, and maybe that's where we disagree with.
Constitutional rights is serious.
Okay, so maybe that's where we disagree. You're seeing it black and white, and I'm seeing it as gray.
And that's where we disagree.
Okay,
And that
understand.
is and has been my hang up with this case for a long time.
But here's
But that's not about guilt or innocence.
No, I
We
understand,
care
but
about
here's the important point, okay, that just seems to be missed. I get that you were unhappy with the decision. I get that it has come back to bite you a few times, but in the Commonwealth of Massachusetts, the justices of the Supreme Judicial Court are the ones that make these decisions. And not only did they make it once, they made it at least twice. The last two decisions, at least the last two, if not the last three, the question of confrontation was raised, discussed by the justices in both of those instances, the justices who are charged with enforcing and interpreting the Constitution, and they said it did not merit over.
No, I know they did.
So
I disagree with it.
Okay, all right.
It's
well,
that simple.
Okay.
But you would agree with me that if that trial were taking place today, certainly wouldn't have placed the children.
That's where I don't agree with you, because if I were a defense attorney in this case and I had to strategize how I wanted the courtroom set up, knowing that the court was amenable to making the courtroom a little more child-friendly, you better believe I would not be setting it up so that my client has to be looking at the child and not knowing what kind of reaction I might get from that child. And the other thing is it is important to know that the children did testify in the presence of the defendant.
No, I know
They-
that.
They had to look at him, they had to identify him.
No, I know that.
So the reasons that we have the confrontation clause in order to prevent people from being convicted of crimes by unnamed people behind curtains, that was satisfied. And that's what it was all about.
Well,
And
that's not what the SJC said.
well, and one last point, and the United States Court, the United States Supreme Court, which interprets the similar confrontation clause, does not interpret it the way that Massachusetts does.
Because they're interpreting under the Massachusetts Constitution that has different.
No, I understand, but I'm just pointing out that confrontation clause doesn't universally mean that you have to be looking eye to eye into a person. And
Well,
the-
it certainly does in Massachusetts.
In
It
Massachusetts,
talks about
I
eyeball to eyeball.
understand, yes.
That's the law.
Yep, no, I'm not disagreeing with that, of course.
And when those kids were testifying, you would agree with me, for most of their testimony, it was not eyeball to eyeball.
I would agree, and I would also say that if I were trying it today, to go back to your question,
No, I
I
get
very well might have done exactly what their attorneys did in an intentional, conscious way.
Okay, I'm all set. We're gonna go to the witnesses, and I'm gonna call my friend Janet Fine to testify. I believe she's here.
Thank you, Counselor Kennedy.
Thank you. I'm sorry, you have a follow-up? Just a minute, please.
Yeah, I just wanted to say one thing as a mother of 4 children and a grandmother. I had said earlier in my remarks that the fantasies that they presented about, being tied to a tree, we understand that was fantasy and you don't take that up. But you had 9 children that really were sexually molested and had all of those things, up their rectum and all of that. And we have the clinical proof. That's what this is all about. It's the clinical proof, not that, children make up stories. It's a clinical proof. And I know personally it happened.
Thank you, Counselor.
Thank you. Janet, come on. Wherever you'd like to sit. You're welcome to go anywhere you want.
Oops.
I've done what you've told me for the last 40 years, so go ahead.
Yeah, sure.
Terry, what do you want?
You can stay there.
I'll turn my mic off.
Huh? You can stay, you can leave, you can do it. Yeah, go sit next to Judge Boyce. Like that. Just be careful of his elbows.
Okay. Afternoon, almost evening. I'm mindful of the time, and I do know that there are other very important witnesses that still need to be heard, who are very directly impacted by these cases and by this hearing. Can I be heard? Microphone's okay?
Mary, can you hear her?
Yeah.
Yes, I can hear her, but I can't hear you, Terry.
I'm not saying anything, Mary, that's important.
So you've just heard a myriad of real facts about this case, and I'll explain who I am in a moment, and the issues raised by Attorney Hardoon and a lot of the questions that you've raised for him. So I don't intend to go over all of that, but there were a few things certainly that I wanted to be able to highlight. And if I'm going to be subject to cross-examination, I might need to recruit Attorney Hardoon to represent me. So,
Do you have the retainer?
So it is, you'll hear shortly from some of the people, like I said, who were central to the entire case and who are really the primary reason that I've elected to come before you today. I've been working in the field of victim advocacy for nearly 40 years. 30 of which were in various direct service and leadership capacities for the Commonwealth. I had the privileges of serving as a victim witness advocate in the Middlesex DA's office between the years of 1983 and 1992. I served alongside Counselor Kennedy for some of that time. I also served as the Deputy Chief of the Victim Witness Service Bureau of the Middlesex DA's office, and then the Chief of the Victim Witness Assistance Program in the Suffolk County DA's office. In each of these offices, I helped to create and direct their children's advocacy centers that serve children and families. And then thereafter, I served as the Executive Director of the Massachusetts Office for Victim Assistance, or MOVA, for more than a decade. And at the same time and since, I continue to provide consultation, training, and technical assistance throughout the country and abroad to victim service agencies, children's advocacy centers, multidisciplinary teams, and allied professionals responding to reports of child abuse. I helped to develop the national accreditation standards for children's advocacy centers and have served as a national accreditation site reviewer for many years. I bring all of that experience and expertise to bear when I speak now to the issue of a pardon that you're being asked to consider and vote on. Among the literally thousands of victim survivors and family members whom I have assisted and supported throughout the years were the children and families involved in the Felsacre Daycare sexual abuse investigation and prosecutions. I was part of a multidisciplinary team of professionals back then, the precursor to the same teams that you were referring to, Honorable Jubinville, and a team of professionals who spent many hours determining the best approach for coordinating and planning for the investigative interviews of children and parents and other aspects of the investigation that informed the prosecutorial decisions. In fact, the principles that guided the investigative process for this case paved the way for all that has become trauma-informed best practice in child abuse investigations and prosecutions today, including the use of multidisciplinary team investigations to avoid duplicative interviews by various professionals over a protracted period of time. The issue about later research has come up. So has there been research that further guided relevant professional practice since the 1980s? Yes, of course. We hope and expect that our respective professional fields of practice will continue to evolve over time, and that's no different for anybody doing this highly consequential work with children. The advancements over time, however, in no way, and I underscore that, in no way change the actual facts about the children's initial graphic disclosures of sexual abuse to parents or other loved ones prior to any official intervention or interviews by DCF or DSS at the time, or the police. And you will hear more about that directly from victim survivors and from their parents. I do not, again, intend to repeat what you heard from Attorney Hardoon about the factual errors and misinformation that seem to be consistently and publicly put forth by the Amiralts. Until today, there seemed to be no effort made to seek out all of the available information, and so importantly, to hear from the survivors and parents to ensure that an ultimate decision was fully informed, thoughtful, fair, and just. So know that I am enormously grateful to the Council for affording all of them and us this opportunity today. So I'd like to address a few points, given my role from the very outset of this case, that are relevant and that have been raised here, surrounding the integrity of the investigation and that I believe, have really been misrepresented. And it relates to the police meeting that was described. I echo what Counselor Ferreira shared about the actual facts of that police meeting that were articulated by Detective John Rivers, or retired Detective John Rivers. That at that I was at that meeting. So I was probably the only, other than the parents, the only other person here that was physically at that meeting and helped to plan for that meeting. So it was very palpable. The anger and concern that most parents had at that meeting was really about what are we going to do with our kids tomorrow, working parents, et cetera. And they were also angry about the fact that none of the officials that were there to kind of lead and facilitate the meeting and speak to the parents were providing or sharing any details of the sexual abuse allegations that had come forth. So those leading the investigation cautioned all parents to not interview their children, and they were instructed if they had any concerns based on their children's behaviors or disclosures that they may have made that caused them concern, to reach out and report them, and they were given the proper channels by which they could make those reports. One thing that I will highlight, without getting back into the opinion by Judge Bornstein, was there was a piece that was written in the opinion that said, law enforcement officials made the critical mistake of delegating the delicate and important task of interviewing to parents. Parents were in essence deputized and told to question their children. This is purely and simply fiction. That did not happen at this meeting. I was there, I recall it vividly, and it was exactly the opposite that happened at that meeting. And one of the core DSS investigators that was part of those teams that conducted the investigative interviews still works for DCF today, nearly 40 years later. And in a recent conversation I had with her, she remains unwavering in her vivid recollection of the quality of the interviews and the investigative process and the guilt of the petitioners. So we also heard about the 19 children that then became 9 children that testified at trial. And I wanted to just comment briefly about the significant role that I played at that point in time, which was to help prepare all of the witnesses for trial, to understand the court process and to be familiar with the court setting. That was particularly true for the children and parents and other family members who were to testify. Given the high level of fear that I can tell you existed for the children, knowing that the defendant was going to be in the courtroom, we discussed the court rules and the role of court officers, all in an effort to alleviate their worries so they would feel safe and be able to offer credible testimony. During trial preparation, they were deliberately not asked to repeat their disclosures. Rather, knowing that developmentally, they would not be able to grasp the concepts of direct and cross-examination, it was simply explained to them who would ask them questions, and their job was just simply to tell the truth. In all my years directly working with child victims and their families and supervising other advocates, this remains one of the most compelling and clear cases of child sexual abuse. I unequivocally believe that the guilty verdicts were fair and just and right, and the survivors and the families deserve to have that clearly affirmed. And I can tell you that affirmations that were made here today have gone a long way with the families that are here and those that are also watching remotely. To offer the opportunity for the petitioner to remove an ankle bracelet, especially since I understand, as we've been talking about, he wraps up in the coming year, is one thing. However, to vote to pardon would be an enormous miscarriage of justice for the victim survivors and their families, most importantly, and beyond, and I'll get to that in a moment. Let me conclude with a focus about this additional immense concern that I think is worthy of your serious deliberation. You all have these children's advocacy centers in your respective districts that do exceptional work for children and families when concerns of abuse arise. And there's a statewide network of these programs that is second to none. And yet child abuse continues to be significantly underreported, and children continue to suffer abuse and exposure to violence in silence. Most of the cases involving children that are interviewed and receive services at a children's advocacy center will never be prosecuted. In fact, typically, it is a small fraction of the total. Enormous barriers remain for children to disclose abuse due to threats, fear of not being believed, among others. And I imagine several of you, from your vast experience in the legal world, know that rarely is there a smoking gun evidence in child abuse cases. Delayed disclosures are common, and they result in no clear medical evidence or the like. This case had compelling disclosures, documented post-traumatic stress, competent and credible direct and corroborating testimony, more than most in my extensive experience. So allow me to tell you in no uncertain terms, given my decades of work in this arena, what enormously harmful messages a pardon will send and what a chilling effect it will have on all that has been done by so many dedicated professionals to ease the way for children to report abuse and to get the highest quality of care they deserve to pursue safety, healing, and justice. It will reinforce the belief that children are not to be believed. It will make mandated reporters even more hesitant to file 51As with DCF. It will further diminish the public's trust in law enforcement. It will further discourage any victim from participating in the criminal justice system. It will undermine the credibility of specialized medical and mental health professionals who contribute to a holistic system of care for victims and survivors. It will set the clock back and compromise our efforts to address and prevent child abuse. We would all be immensely short-sighted to think that the results of a pardon, given the facts of this case, wouldn't reverberate that widely and deeply. So many of my colleagues confirm that this is by no means mere rhetoric. A pardon is patently inappropriate here. There may be an attempt to try to reframe what a pardon actually means, that it is only an attempt to give the petitioners a fresh new chapter in their lives. But that is not what a pardon means, in my understanding. And that is not how it has been and will continue to be portrayed to the public. The petitioner's mantra has only been that they are innocent, wrongfully convicted, and a pardon would, for all time, seal that as the wrongful conclusion of this case. I believe that you and the governor perhaps have the one or the other, or all of you, have the power to consider an alternative for these petitioners if the primary goal is to end the current restrictions placed on Gerald Amirault. I ask you to grasp the gravity of this decision and its immediate and far-reaching implications. For all of these children and families, indeed all children in this Commonwealth, I urge you to look to your conscience and use the courage of your convictions to find a different, more appropriate path forward. In doing so, you can prevent all of the immense and presumably unintended negative consequences a pardon decision will undoubtedly create. I cannot urge you enough to deny this pardon request.
Thank you. Councilor DiPaolo, any questions?
I have no questions.
Councilor Ferrero. I did enjoy listening to you. You're extremely highly credentialed. And for you to say that this is one of the most compelling cases that you've dealt with in your 40 years is extremely important to me. Would you agree that, I know you didn't get into detail, but that there were children of different ages, different geographical locations who never talked to each other, their parents never talked to each other, and they had strikingly similar descriptions of what happened even before Tukey was arrested?
Absolutely. And in fact, one I was reminded of was a child who had been out of the school, had not been involved in all sort of the hubbub that related to the initial allegation and the closure of the school and the arrest, et cetera, disclosed to an elementary school teacher about the abuse that had happened at Fells Acre. It was uncanny how many similar disclosures there were from people who were completely unrelated to one another.
Someone talked about them identifying the magic room or the secret room. Can you tell us about that? Will that occur?
You mean physically identifying?
Children physically bringing investigators there.
Yeah, so the school had been closed. There was an legal opportunity to reopen the school and bring children back individually. And some kids were really frightened to go, and there were support people, like a state police detective that went with one of the children to be able to just provide some sense of security. And going into the school, they were asked about, having made disclosures about magic room and secret room, they were asked if they could show where those spaces were, or if they could show just around the school. And there were consistent disclosures of what room in the school they remembered being the magic room or the secret room.
Based on your 40 years of training, your education, your experience, is there any doubt in your mind that these offenses did in fact take place?
No doubt whatsoever in my mind.
No, that was an excellent presentation. Very good speaker.
Thank you.
Councilor Devaney?
I want to thank you for your work. What you say is hard. It must be tough to go home at night after you read these things and you're at these meetings and everything. No one's talking about here about the physical and what happened with the doctors in the hospital, that there's evidence. It isn't what children say, it's the evidence on these children's bodies of what they did, I think it's sad that we didn't have the pictures that, that they took. And all of those children, and you correct me if I'm wrong, they each talked about a camera and a red button. Remember that? A red button. They can't make that up.
Picture come out the front.
That's right.
Yeah.
And the picture came out in the front and they had to take the clothes off. One said no, but he took them off. All of that and the different things that they did, they were so sick I can't even talk about. But unfortunately, the police didn't get in there in time to get those pictures, so they destroyed them before they were arrested. So, you've seen so much. And you're so definite about this happening. I know because it's my friend. And I'm just saying that, I don't know how we can ensure to make sure that this doesn't happen anywhere else. You know what I mean? And I think, and you've said it, and Attorney Hardun has said it, and I feel if this pardon is allowed, it's just going to take all credibility away from children and that children make up things. Yeah, they had fantasies about being, animals being killed up tied to the tree. You ignore that kind of testimony. That's fantasy. But the other things are real. And in my friend's child coming home with the different clothes, other people said the same thing. How could they make that up? They didn't even know the other child or the parent. The children were coming home with different clothes and everything else. And they would say they were hurt. They didn't know how to identify it. And I would be very graphic because I had 4 children. Children at that age, 3 and 4 years old, they don't know the word penis, and they said it and everything else. The other thing is the police did not wear uniforms, did they?
No.
That's the thing that that has been presented, that they think they came in uniforms and the children were scared. So tell us about how that was presented with the police.
Yeah, I mean, there was great care given to how those interviews would be conducted. Police were in plain clothes. They let the DSS workers typically kind of take the primary lead, but they were present so that they could hear what the children had to say for their own benefit. and they didn't have to duplicate the interviews. So, and they were in a comfortable setting. They weren't in a police department or in even the DSS office. They were in a comfortable, child-friendly setting.
Was there any way that you could follow up on these children after the court session and Tukey went to prison? Was there any way that you could follow up on the children to see how they were doing with the parents?
Well, I unfortunately have had many opportunities to reconnect with this most inspiring, courageous, resilient group of people. So yes, I've had opportunities over the years to hear both those who have continued to have struggles given childhood trauma, and others who have maybe had that and been able to find some personal resilience, and others still working on that resilience.
Thank you so much. Now, why did it take 3 weeks for the warrant? Why?
That is not, I'm stepping out of my lane
Oh,
for that
okay,
one.
okay. You know, that had a lot to do with not getting the pictures and the pornography, and that's what it is. But, you know, they didn't question the children. The children just volunteered it. And even the uncle hearing, you know, the cousin telling the other cousin what Tukey did, you know, that wasn't, they weren't integrated. They were children, and they just volunteered that something was happening. And they said, I don't want to go there. And it wasn't because, as the other attorney said, Sultan, that children cry when they go to school. This was children individually who like to go, and all of a sudden they were crying and screaming. And those parents have a lot of guilt feelings, unwarranted, you know, because they forced them to go and they didn't know. But again, we can't listen to the testimony of people that work there because they didn't see it. Because those children were kept separate, and they were kept back, and they were taken from NAP. So I thank you for your work. It's not an easy job. Thank you so much.
Thank you.
Thank you very much. Just one quick question. You probably don't know the answer, but I'll ask it anyway. You worked at one point at the Middlesex County DA's office, correct? Yes. A lot of times when we have a commutation or a pardon, we hear from the DA from that county. Even though I know it's been Harshbarger, I think it was way back when, but oftentimes we hear from the current DA. I don't know, I haven't heard from the DA. Do you have any personal knowledge of whether the district attorney is supporting this this pardon?
I personally don't have not had.
I haven't heard anything from the current DA, nor have I heard anything from the Attorney General. Oftentimes we do. So they're obviously taking no position on this.
Yeah,
pardon.
that I don't know.
Thank you very much, sir.
No questions, thank you.
Counselor DePaul, you had one follow-up question?
Thank you very much, Mr. Chair. I just have a two-part question. The first is, it sounds like you've worked with some of the victims in this case.
All of the victims.
And still have ongoing. So to your knowledge, I heard today that the victims in this case heard about this pardon on the news. To your knowledge, is that accurate?
That is absolutely accurate, and it was really unconscionable.
I agree.
Somebody asked the question about victim rights. I started in my career back when the victims' rights law had just been passed, and we were part of the team of people, victim advocates, working to implement that law or to, you know, make it known to everybody. Basic to that law is the right to be notified, the right to have a voice, the right to be informed, the right to be present, to be heard. So for something as grave as this hearing, this step, to have people this at any time, but this many years later, hear about it either through the grapevine or on the TV news was really unconscionable.
I agree with that assessment, and I won't belabor a point I made earlier, but when I read the Constitution that tells me that if the offense is a felony regarding a potential pardon, if the offense is a felony, the general court shall have the power to prescribe the terms and conditions upon which a pardon may be granted. So this isn't my area of law, but to me, it sounds like if the legislature made a law about the process, which it did regarding the parole board, then that's what the Constitution's asking for. And as I pointed out earlier, that was a mechanism to avoid notifying the victims.
Mhm.
A cynical person might take that
Cynical.
perspective, right?
Mhm.
Fortunately, I don't suffer from cynicism. My follow-up question is I've worked with children who are dealing with trauma. What's the impact on a victim to read about this in the news, in your professional opinion?
Well, I think part of the whole experience of victimization is to have had your sense of power and agency and control taken away. So to have that happen is, I think most would describe it as a re-victimization and certainly an enormous trigger for that lack of control.
I would imagine all along the way with the appeals and the 6 SJC decisions, it's the same. Thank you. Thank you,
Please,
Mr.
yeah.
Thank you. Thank you.
I don't have any questions for you, Janet.
Okay.
It was good to see you again.
So I did have, and I had asked you about this, I was asked to read.
Excuse me.
Oh, I'm sorry.
Oh, I'm sorry, Mary.
That's okay.
It's been a long day. I
fault,
missed
buddy.
you.
I forgive you, Terry. I just want to say thank you for coming here today. And I think that you shed a lot of light on the facts surrounding this case and not speculation, conjecture, or really a smokescreen that tried to be presented here today. So thank you.
Thank you.
You had a letter you wanted to read?
Yeah, I have a few short statements on behalf of a couple of the child victim survivors and a couple of mothers. For health and other reasons, they were unable to be here in person. And they have submitted their statements in writing, but they did want to exercise their right to be heard, to have their words heard in addition to being read. So, and I also just wanted to note before I go ahead and share those with you, I also wanted to note that you also received prior statements from parents who were longstanding staunch advocates for their children for many years throughout the many chapters of this case, so to speak, who have passed away. And if they were here, they would no doubt be standing before you to deliver their own remarks. And so those that you received in writing reflect the power of their experiences, past statements they have made, and I think serve as a part of their enduring legacy.
They're part of the record, and as you can see, everybody has read through a lot of material here. That's very obvious.
All right. I will be succinct, short, but I'm reading their words. So this is from a Fells Acre victim, survivor, now adult survivor. Good afternoon, ladies and gentlemen of the Governor's Council. This is the first time since the trials that I've wanted to have my voice heard. But please understand that my silence in no way indicates I was not impacted greatly by the events that occurred at Fells Acres. It impacted me greatly for many years. Every time I watched the Amiraults and their supporters on the news proclaiming their innocence, it affected me all over again. But during these times, I was trying to work through it, and coming forward was not something I was comfortable with. I am speaking to you today not as a victim, but as a 42-year-old woman that has been in the human services child welfare field for almost 20 years. Part of my core belief system in my work is that people can change. I believe that criminals can rehabilitate and addicts can recover. I believe in giving second chances to those that do. Part of truly reforming and changing is admitting and working through the past mistakes in an effort to avoid repeating this behavior. As each member of the council knows, this is not the case with the Amiraults. They have continued to deny any and all allegations against them, which makes me fearful of him reoffending. I'm not fearful for myself. I can protect myself now. I'm not speaking for myself. I am speaking for all of the innocent children that deserve to grow up being unharmed. My point of view may not be shared by many, but I consider myself lucky. Gerald served many years in jail and many on parole. He was held accountable for his actions and brought to justice, and we did that. We brought him to justice. Many victims of abuse do not get that comfort. Gerald has never been found innocent, despite many attempts over many years of him trying to prove he was. My understanding is that if this pardon is approved, his record will be sealed. In my understanding of record sealing, this is based on someone rehabilitating. Rehabilitation has not happened here. Innocence was not proven here, and he has done nothing to better himself Instead, he has put all of his time and energy into proclaiming his innocence, a notion that has been rejected time and time again. I am asking the council to recognize that Gerald Amirault is undeserving of your pardon today, and I am hoping you vote accordingly. And then another victim, adult survivor, who wanted you to hear her words. Ever since I was sexually abused by Gerald Amirault, I have been in mental health counseling. I have had nightmares about the abuse and having to go to the magic room and waking up in hot sweats. I had to do EMDR, which is a therapeutic modality, to try and help with it, and it did work. I have since been on depression medication and anxiety medication. I do not agree at all with this pardon. What he and his sister and mother did is a heinous crime, and I feel he should remain on parole for the rest of his time as he was sentenced and stand convicted. I don't know how someone could say he is innocent and live with that guilt. He has ruined or caused suffering for the children and families involved. I myself can honestly say that the abuse has caused me pain and suffering all my life. So no, I do not agree with this pardon and ask you to please not grant it. This is from a mother of a victim, adult survivor. To the esteemed members of the Governor's Council, I was caught off guard with the recent announcement from Governor Baker. I knew of no new evidence indicating innocence. The Amiraults were found guilty in 2 separate jury trials. Their appeals were denied by the appellate court and the Massachusetts Supreme Court, and yet I find myself writing once again almost 40 years later. I cannot reopen all the wounds I and my family have suffered by sharing the litany of trauma-related issues we have endured over the years. In short, my daughter lived in fear of retaliation from the threats made against her and me. She had related medical, sleep, and other emotional issues that stemmed from the abuse. She had the courage to testify in court despite her real fears and feelings of shame, especially since she had to do so in the presence of the defendants. It is unconscionable that any of us would need to revisit all of this at this point. There is no question in my mind that the Amiraults were and remain guilty of the abuse they inflicted. So I simply urge you to please stop the issuing of a pardon that is within your power. And then finally, Governor's Council members, I regret that I can't be present to speak directly to you on behalf, this is from Mother, behalf of him and my entire family due to health restrictions. I have always found it in me to muster the emotional and physical strength it took to support and guide my child through the investigation and prosecutions of this case, and to deal as best as I could with the immense pain it all caused. Who would have imagined that after 35 years, I'd be faced with having to open the serious wounds of what the Amiraults did to my beloved innocent young son and our family? We were shocked and stunned, to say the least, that we learned of this pardon request on the TV news and came to find out that no one who has provided us notice for all the many court and parole hearings, appeals, commutation requests, etc., knew anything either. I thought as victims we had rights here in this state, and yet we and all that this would cause appeared to be completely ignored. Mostly what I want to convey to you, as best as I can in a short amount of time, is all that we have had to endure as a result of this abuse over so many years, from my son's childhood and throughout his adolescence. The details of the abuse that my son disclosed before any official interview by DSS and the police were through his own words, and that manifested in his severe trauma symptoms, his shocking sexualized behaviors directed at me or that I directly witnessed, and his intense fears due to the threats made to him that his parents would stop loving him and that they would be killed. This all started before his 6th birthday. At bedtime, I would read a book, tuck him in and kiss him goodnight. He would grab my face and try to French kiss me. I would tell him that that is not how children kiss their mommies and daddies. He told me that Cheryl told him that French kissing means you love someone. If your parents don't do this with you, then they don't love you. He would ask his sister to come into the bathroom to help him pee, which he told us was what they did at the daycare while the camera on the tripod was on them. He would cry every morning, pleading with me not to take him to daycare, a place that should have been filled with fun and laughter and friends. He would put on 2 to 3 pairs of underwear when he got dressed in the morning because he thought when Cheryl Vire took off his clothes, the underwear would protect him. He said that didn't work. The only way a 5-year-old child thought he could protect himself, this was supposed to be his parents' job, not his. He didn't want to go to his grandmother's house because she was old like Vi, and he said she will hurt him. I would take him to her house. We never knew this. The detectives took us by the general area and my son picked out the house. He also knew there was a garage there where he talked about Vi taking the kids and videotaping them. I asked him about the gash on his head that day. He said Tookie hit him with something because he was going to tell his mother, me, his protector, that they were hurting him and the other kids. He made my son stay outside, just sitting there in the hot sun. The Amiraults continued to build a wall separating our child from us. This did not just happen overnight. They groomed their victims. Once the school closed, the allegations were no longer allegations. When the truth finally came out from my son, the pieces of the puzzle started to fall into place, and the truth reared its ugly head from my child, and as we eventually came to find out, from other children from the daycare. I asked him why he never told us. He said, "You would die. They would kill Mom and Dad." After my son disclosed to us, his dad died tragically. He blamed himself for his father's death because he told what the Amiraults did to him. Instead of my child going out to play after school, I was taking him into Children's Hospital to see a therapist weekly for years and years and years to come. Not the childhood I dreamed of for my child. He should have been out playing with his friends and having fun. Instead, he was by my side, afraid that I might be the next one to die. The pain watching your child going through this is at times unbearable. Can you imagine being in this child's shoes and looking back on his childhood memories? Building childhood memories for his own children, his are nightmares. While the Amiraults and their attorneys would have you believe that my child's disclosures and behaviors were due to interviews that came well after all that I just described is purely and simply 100% false. To say that we as parents or trained and skilled investigators put such vile details in their minds and that they maintain such details over years is ludicrous and outrageous. I am one of many parents who had to endure the pain of their children's nightmares, being frightened, untrusting of everything, and deprogramming him not to be a pedophile himself, which was a fear. And while it is overwhelmingly painful to deal with this all yet again, I cannot stand by without ensuring you that you have the benefit of the realities of this situation. We have heard the same arguments by the Amiraults and their attorneys over decades. There is nothing new to examine or explore here. This case has been appealed and reviewed so many times I can't even count, and all have resulted in their convictions standing as they should. Seeking to remove his ankle bracelet is one thing, but an out-and-out pardon is both horrifying and unspeakable. Please don't allow our children to be victimized again by an absolutely wrong decision to pardon. Thank you for listening.
Thank you.
Next, we're going to call some of the survivors and parents.
She can't be coming.
Barbara, and I apologize if I mispronounce your name, Stanke? How do you say your last name?
Stand.
Like
you stand.
Stanke, okay.
I can't hear him. What is your son?
Can
Barbara
you just
Stansky, one of the parents.
Tell us who you are and in relation to this case, and then we'll give you a statement.
Hi, my name is Barbara Stanke, and my child was my son was a victim at Fells Acres.
I'm going to ask you to speak up a little bit and into the microphone because we can't hear you.
My name is Barbara Stanke, and my son was a victim at Fells Acres. He began there when he was 2 years old. The first thing I'm going to read is my victim statement when the trial was over, if that's okay.
Yes, no, you do whatever you want, and take as much time as you need.
To state all the effects that these crimes has had on my son and myself would take too long and too many agonizing memories. During my testimony, many symptoms were brought out, such as nightmares, sexual behavior, and regression. Yet there is no way that anyone listening to those few statements could possibly comprehend the frustration and heartache that would tear me apart every time a scream in the night would occur, or I would find my son masturbating so intensely that I feared he would injure himself. And no one could know of the endless nights of crying myself to sleep, thinking of my son telling me what had happened to him, with the fear that he was bad and that I would not love him anymore. My son's innocence, self-esteem, and inborn trust has been taken away from him, and that hurts the most. We have been in therapy weekly for almost 2 years, and that will continue. Therapy, hopefully, will help him to trust and someday feel that he is a good boy and the same as other children. But all the therapy he could receive will never return his innocence and all the joy of being a child that holds. Though the symptoms may fade, the scars of these crimes will be with him and us our entire lives. Having just read that, I feel like I just wrote it today because nothing's changed. The pain is still the same. And I think of how the Amiraults have affected my son's life and mine still today. To hear the governor was considering a pardon was a cold, hard slap in the face and a direct insult to our character by calling my son and myself liars. My son has talked about this throughout his life, what's happened to him and how it's affected his life and his relationships with women and with his son. He has never had any true happiness or success in his life, despite the years of therapy that he's had.
Excuse me, something's happened to your microphone. I think, are you, something
Hold
happened to
on
your
a second.
microphone.
Just, is the green light on? She just speaks very softly, Mary.
Okay, thanks.
Right down. You know that? They told me they got stupid stuff, you know. Spoken to my, I told him that. Told that he put his TV in his mouth. Oh, that's so ridiculous. And Cheryl came in. He almost had a break. So I said, oh, you know, it's silly. Oh, yeah, yeah. And being a young girl, I was my sexual abuse.
are not a little girl. And I'm not gonna get blown off with Amirault. They killed me. He cannot be pardoned. Children are still living this sentence. Never had a happy day in his life. Struggling. Funeral gets a time. I don't know how to get myself.
Thank you very much.
Thank you very much. Questions? Thank you.
Thank you.
Next.
Brenda Hurley McCarthy.
What college do we have to expose their names to?
Wait for that. He's not even.
My name is Brenda Hurley McCarthy. My daughter was a victim of sexual abuse at the hands of the Amiraults. Already written to this council explaining my opposition, having Gerald and Cheryl, we stand by all that was said in that email. And I've had memory and read that as well.
Oh, very, but you're welcome.
I want to thank the Governor's Council for holding, allowing me to speak. Would like to first state how appalled that I am that Governor Baker made the news announcement to recommend the pardon of Cheryl and Gerald Amirault without prior notice to the victims' families, parole board, sex offender registry, or the victim witness advocate office. Hearing on the news should not have been how the victims and families found out about this. These headlines and the search for answers of what was true consumed me through Thanksgiving holiday. I and my family were really victimized and having to relive the trauma. This case, the memories, all this has brought back. And the anger.
It's my connection.
I am angry
What's yours?
that after 38 years, this case doesn't end. I'm angry that governor would even think had known that sexually abused my daughter. I'm angry, very disturbed and disappointed with this happening around politics. It's unbelievable. Now I would like to expand on my previous letter and speak of the trauma that my daughter and our entire family went through beginning in 1984. For the next 18 years, there was hardly a year or a month that went by without emotion, hearing, appeal, etc. Many years I as a parent carried the guilt. Many years my daughter struggled with the
Yeah, actually.
After Gerald was paroled in 2004, I, and I'm sure many others thought, finally, that we not have to have this in our face, day in, day out, throughout, and or never end. We were. I remember sitting at Gerald's parole court hearing, and he stated that he had a drug problem prior to his incarceration. Yet it was the first time he admitted this publicly or associated this with this case. I said to myself, it may take another 20 years for him to admit that he
Let him sit there after the next witness.
My daughter was always a happy child,
Next witness, let me switch.
but that soon changed after her time. The narrative the defense and Governor Baker want you to focus on is that this investigation took place without the benefit of scientific studies. This is just another smoke. My child made myself. Disclosures that no 4-year-old would have in their vocabulary. Prior to these disclosures, she exhibited behaviors that were concerning and was referred to a child psychologist. Truth has already been told by brave children who came forward first to their family members, doctors or therapists. While the defense and the Amaroults want to maintain their innocence, every argument they bring forward today has already been raised and addressed countless. Nothing more being brought up. Baker stated the investigation and prosecution of the Amaroults took place without the benefit of scientific studies. You've all been talking about that, so I'm going to skip down. He's left with grave doubt regarding evidentiary. I remember clearly that the focus of the investigation and how it's being is one of extreme caution for reliability of the in Hutchinson Superior Court, Appeals Court, and State Supreme Court. I will add that I was not at the police department meeting. The trauma that my daughter, our family, and myself endured reared its ugly head many times throughout these past 38 years. As I stated in my previous letter to council, my daughter was examined by competent, knowledgeable medical professionals at Children's Hospital Boston. She had labial adhesions, mental scarring, that are not usually present non-sexually abused. Daughter was also having that. Started using her tongue, family, and other behaviors that I learned. Brought these behaviors first to the attention of her pediatrician, who referred us to a child for any knowledge of sexual abuse of the hands. She continued to have difficulties throughout her adolescence. My daughter was admitted to a psychiatric hospital at the age of 7. The suicidal idea developed. During her preteen and teenage years, she began to use alcohol and then drugs. Continued this behavior. Had therapy on and off throughout her childhood. From this childhood. Due to the trauma she endured and continues to endure, she was unable to care for her and lost custody of those 3. I have adopted all 3. Youngest one, he was less than 3. And his siblings, 2.5 and 5. My grandchildren have lost so much of love. They lost a mother who couldn't get past her trauma to their wisdom.
It's too long.
3 generations that have had to live with this trauma. Single. In October of 1999, Cheryl's lawyers filed a motion to revise and revoke her sentence to time she had already served. ADA Rooney agreed to this with conditions. At the press conference afterwards, it was reported by Attorney Sultan that one of those conditions was that Cheryl cease all further attempts to clear her name via the legal process. So how is she allowed to get pardoned? Isn't that part of the legal process?
Why did she agree to this condition? I would venture to say she knew this was the end of the legal case and nothing would change, as all legal remedies had been exhausted. This condition was placed so that the children and their families could finally put this nightmare of never-ending court media attention to an end. Have some measure of closure and attempt to heal without the constant resistance from absence. Myself have had hardships dealing with what was done to my child, and it wasn't easy. Thank myself for putting her in those acres for many years. I've dealt with trust issues my entire life due to what happened to my daughter. And I was powerless to protect her. All throughout my children and then my grandchildren's life, it's difficult to have them out of my sight. My other children and grandchildren, I was and still am very overprotective. As much as we have tried to heal and find closure, it really isn't something that it does help that the scrutiny of this case has not been front and center. As former DA Riley stated, I stand behind the decisions made at the time by the prosecutor's bill. Why can we be trying this case now? The pardon Amirault was by no means the investigation and trial. Someone had shot a pellet gun. It was determined through my bay window. I can still remember family members of the Amiraults standing across the street, staring at us. Right in line. Taking my kids to soccer, softball, baseball, wherever, being stared down by their family members. Yeah. I believe I understand them better. Certainly more than the Amiraults or their supporters have done. I never lowered myself to their supporters' behaviors. I was able to move on for the most part with help and support and moving out of Massachusetts so as not to be confronted daily. Compassion is one thing, pardoning them is a whole different. They were convicted in a court of law because many judges who were involved in this case upheld those convictions. Them promise to not take away the justice that was dealt 38 years ago from the only victims of this case. Families this happened to. It has been stated by the governor's office that the families' victims have not spoken out, have not attended hearings, etc. False. I, along with many other family members and victims, have spoken out repeatedly, well as attended all court proceedings with that with Governor Swift. Spoke out to the media many years ago to have our side of the story. We believe our children did the work. There is nothing in this case that wrong with Cheryl M. The court proceedings, all the way to the state Supreme Court, address each and every single concern. September letter, as you well know, the parole board urged Governor Baker there was clemency petition, and a month earlier, Tosi paid in a letter that the court system was the appropriate avenue for the big case. Governor Baker issued the pardon recommendations against the advice of his advisory board of pardon. This council grants a pardon to the Amiraults who are going against the parole board. Why do we have checks and balances such as appeals courts, Supreme Courts, and parole boards if you're not going to listen or abide by them? Mr. Kennedy, you stated it's not about whether they committed the crimes. A lot of people feel they were unjustly convicted. A lot of having pardon has more to do with where they are in that station in life. This station in life was that they have a conviction that should stand because I'm 100% certain did not lie. Not brainwashed. Not grilled, told what to say. They were justly convicted, are guilty no matter what they want. If this is more about their station than I think guilt or innocence, I do not believe wanting to spontaneously visit grandchildren or travel is a reason for a cop. They have always spoken out in the media of their innocence. Each and every time they or their lawyers have alluded that parents brainwash their children or coerce by overzealous investigators or prosecutors.
Excuse me, we've asked that we keep the statements down to 5 minutes each. You've gone almost 25 minutes. Yeah, yeah. So I'm gonna ask you, we see that, and I'm just gonna ask you to wrap up if you could, please, so other folks could go.
They should continue to live with the guilty verdict they receive. Happy lives taken from them forever is exactly the point. My child and many others involved in this case still can't get passports done. Fears, nightmares, and struggles faced daily due to sexual abuse at the hands of. Can you tell me when my daughter, myself, or my family will get our pardon? And my daughter will be able to erase what happened to her and the ensuing pain and suffering she has had for her. I beg you to deny these pardons. My hope is that you.
Thank you. It was.
Excuse me,
I
Counsel?
I am gonna, got it.
Counselor,
Well, just, can everybody just hold on for a minute? We're having problems with the audio, okay? I'm gonna ask you to switch seats because that one works and that one is not. Okay. I understand Councilor Devaney has a question for you.
okay, thank you.
Go ahead.
I just want to thank you. Thanks. Your daughter is so lucky to have a mother, to be able to adopt your children. Doesn't happen all the time. And God knows how many of those children that they didn't have a grandmother like you.
Thank
So I
you.
want to tell you, I've been involved in this for decades. I was prepared when it came before Governor Swift to vote no. But this is a travesty that you weren't told, no one was told. And you know what this is all about that makes it more egregious? The
Yeah.
reason that the governor approved this pardon is because of his friend Barbara Anderson.
Yeah.
That's all. Doesn't have any concern about all the children whose lives are ruined and their families were ruined. Barbara Anderson, and he promised her. 2015, he did her eulogy at her funeral, the whole thing. So he didn't investigate. He didn't look to see, talk to you people. Imagine finding out in the news. I publicly apologize. This is not how I started out. I started out with Governor Salucci, find me and honest me. This would never have happened. And as I said, I have pleaded with the council. This should be unanimous no. And I'm praying it will be no. And I would keep you and your daughter in my prayers.
Thank you.
Thank you. Thank you for your testimony. I am going to call on Jennifer Bennett. We have 3 more witnesses, and I am going to ask them to try to please adhere to the 5 minutes that we asked. We've had a very long hearing, as you can see, very long day. Jennifer Bennett here? No, you got to switch seats. It's complicated, Janet. We can't do that. We have to switch seats.
Oh, it's all these.
Somebody comes to you.
She's a sponsor.
Go ahead.
Hi, my name is Jennifer Bennett. I'm a victim of Gerald Amirault. He is without a doubt the person that raped and molested me. I was just an innocent 4-year-old little girl. He robbed me of my childhood.
and as I come to find out, others too. I am now 44 years old, a mother of 3. The students of Fells Acres Daycare School has disclosed abuse and always will be victims. But most importantly, I do believe, even with the struggles I've had, and I know others had, that we are survivors. With all the trauma caused by Gerald, I've been in and out of counseling for the vast majority of my life. On top of counseling, from the time I was a child and as I got older, I was willing and able to testify in court and make my voice heard. Other times, after the court cases were over, I cannot wrap my head around the fact now, more than 35 years after his convictions, Governor Baker wants to give a pardon, which fails to make it like the golden ticket for freedom, especially without any victims being notified or asked for our input or getting the full picture. I'm grateful to the counselors for having this opportunity. As I understand it, Tookie and his family want a pardon because he continues to proclaim that he is an innocent man. He'll enable him to walk away with a clean record, like nothing happened. Please do remember the fact Gerald and his sister Cheryl were convicted after 2 trial runs by 2 judges, along with 2 sets of jurors, all which came back with a guilty verdict. I will never forget what he did until the day I die. I continue to have nightmares, panic attacks, and avoid places that trigger all of those traumatic memories. My pain is one you cannot see. It lives in my head with all the things he has done to me. I live with the life sentence as a result. I honestly sit here and think, how in the world did this get to all of you? What's driving this now when he is almost finished with his sentence anyways? I also understand he is currently free to travel out of state to visit his grandchildren. So what is this all about? This man has been denied all of his appeals and requests for clemency up until now, and for good reason. I know how hard it is to disclose abuse. If this is done, I wholeheartedly believe this will make any and all victims feel as if they cannot trust the justice system and be afraid to stand up to people like the Amiraults, who perpetrate abuse and cause a lot of pain and trauma. I ask you, how would you feel if this was your kid up here? Would you still let the man walk away? I strongly urge you to deny this pardon.
Thank you for your testimony. I call on Harriet Delano.
Counselor,
I'm sorry.
I just want to say, it took such courage for you to come today. And I'm sitting here and I'm thinking, you and others have victims have got a life sentence And now they're asking for a pardon. The injustice of it all and how this was kept all secret. I'm so sorry.
I just want to say thank you for your testimony. This is Counselor Hurley. I appreciate your courage. Thank you.
It's amazing she could do that.
Honorable members of the Governor's Council, thank you for the privilege of standing before you and allowing me to speak my truth. My name is Harriet Delano, and my daughter is a survivor of the Fells Acres daycare case that was tried in 1986 and 1987. She is now 42 years old and has been living outside the United States for most of her adult life. I was highly disturbed to hear about the governor's recommended pardon through the NBC.com news article that was passed along to me by a family member. My daughter and I were not officially notified of this news until we received a letter on November 28th from the Sex Offender Registry Board, where we were both asked to contact them for an update on the offender's classification status as a sex offender. To gather more insight prior to contacting my daughter, I called SORB and was told that there would be a Governor's Council hearing scheduled and that they would forward the information via email. In the meantime, a victim witness advocate who was present at both trials reached out to offer us assistance. The process of the Governor's Council was explained, and if we chose to, we could have a voice and be heard. On December 2nd, I called my daughter and sadly informed her of the difficult news. I passed along the information that I had received and apprised her that I would be attending the hearing. She asked for time to reflect upon whether she would reach out directly with questions of her own or whether she would make a statement. A few days passed by and my daughter decided that she would keep the past in the rearview mirror. She stated that after all these years, she saw no need to go back. No need to revisit the past and the painful memories. It would serve no helpful purpose. She has moved on and made a future for herself with her family and career. She has chosen to live her best life on her terms, as she should. I understand Governor Baker made a promise to the late Barbara Anderson and would keep her dying wish. It is the responsibility and duty of the elected governor to serve the people of the Commonwealth, not to grant favors to those with political ties. There were two separate trials involving the Amiraults, and in both cases, they were all found guilty in a court of law by the people of the Commonwealth. It's easy for them to lie and maintain their innocence because the alternative, the truth, would be to admit their guilt to the heinous acts that have been committed against innocent children. The truth of what they had done came from my daughter's graphic disclosure before any formal investigative interview took place. The truth remains the same. I'm a mother of a child who was sexually abused. I have been sentenced to a lifetime of grief that I have somehow failed my daughter, while the Amiraults robbed my child of her childhood. Where's my pardon? I know that this must come from me, and I thank God every day that my daughter has risen above it all and is living her life, her way. And that there lies my redemption. I'm very proud of my daughter. In closing, I honorably ask the members of the Governor's Council not to approve the pardon and dutifully act in the best interests of the people of the Commonwealth. Thank you and good evening.
Thank you, ma'am, for your testimony.
Thank you.
Hello, can you hear me?
Yeah.
Good. I've left messages for all of you. Some of you I've spoken to. I'm Mrs. Robinson. a Fells Acres parent. And I'm here to, what I want to, for future, for kids, walk in my shoes before you choose. And let us all try to do this. Be a voice of hope for children who get into these kind of situations, okay? From the past, present, and future. That's where I'm at. So now, here, this is the before us trusting. Signs of abuse. First I want to say something very important. My daughter was born in June 1981. When was this case? What year?
85.
So how old was she?
4.
Too young to be bribed or us to brainwash her. Little kids don't hold on to strong stuff unless they've experienced it. That's what I want to say to all of you. She was really, really young. And I also want to say in my defense, I was the mother of 4, and the other 3 were older than her, obviously. And they were very protective of her. All of us were. She was the baby. She was special. So now when all this came out, for us, it was disbelief. Like, no. I checked out a few places to have kids, you know, to send your kids, and I chose them. All right, so now today, no, Governor Baker, there was no notice. The notice was on TV. It's a very, very, it's very, very disrespectful that we didn't get a notice from Governor Baker. And accept lies and no notice. And later on down the road, a voice, like I said, for the kids. Now for us, would I have a message for Governor Baker? We believed in you all these 8 years. It's disappointing if you approve total dismissal of the case. You are beating our kids up again because they were beat up the first time. Calling them liars. My baby was considered, look up your records, I don't know, they gave her the label of the star because she was the youngest one. And yes, we were shown the courtroom in Cambridge. You all know, no matter how years you've been in this, courtrooms are very, right? Very scary. We were shown around the courtroom. She was shown where she was going to sit. Then she was shown, we walked up the couple of steps, you know, where witnesses sit, and shown where the judge was going to sit. And just to, we like making people smile and laugh. She had to go to the bathroom. And the smile of the day was there were hearts on the toilet paper. So I guess the judge, she had good humor or something. Okay, so back to if this all happens, because nobody seems to know what the word pardon means. You have us totally confused with a pardon. Okay. Mr. Jubenville, yes, everyone should be free. But, yes, take the bracelet off, whatever, so we can go see grandkids, yes. But there should not be a total wipeout of a record. There should always be something there. Always, always, always. There should be something there. So, pardon? I've been waiting all day to everybody else talking. So you're calling our toddlers liars. And why do the victims have the shame and embarrassment? Okay? So my daughter, she's too embarrassed to be here. She saw this on the news. She was afraid to tell me. And she said, Ma, you know what I saw? I said, okay, hard to believe. No notification. Anyway, before counseling or any of that, she showed signs. And her sister says that she came to her room, and I'm going to only mention about a fork and soap.
Yep.
But we went to Children's Hospital and there was signs of abuse. That's what Children's Hospital said. So yes, without a doubt, their innocence is taken away. All right? And you take away the kid's innocence, nothing to do with the truth you're saying. Victims feel guilty and shame. So I think, does lie detectors still work? Do lie detectors still work?
They didn't do it though.
I'm all for it. Show me a lie detector test. So anyway, nothing to do with the truth, and the victims feel, so that's my message. Walk in my shoes before you choose, and be a voice, because this is happening to kids every day. And I made my child strong. In her early years, she suffered from migraines, but I made her strong, and we went out and we give back. We go to nursing homes.
Yeah.
We give hope and inspiration. Okay, and she has small classes that she paints with little kids who are poor. All right,
Counsel-
thank you for your time. I don't know about the
Mrs. Robinson, through you, Counselor, I just want to thank you and the others who came. This was a very hard thing for you to relive this, all of you. And it means a lot. It'll mean a lot to the people out there. With
Yes.
your testimony, all of you came.
Yes, to
Then
give those.
there will be justice.
To give
I
those
promise you, there'll be
who
justice.
speak up, all those kids, yes.
Thank you.
I hope we gave you. I know, but we didn't get our time. Beat me up, beat me up. You beat the kids, now you're gonna